thing that was getting ready to happen is that they found, I'm sure that they found some reason why he ought to be thrown into the mix. And in essence, what this guy was doing, he's trying to defend himself from getting killed. He didn't initiate nothing. But this bill saying that if you ever ride or you start something like that, then all y'all gonna be thrown into this pot to deal with this. That's not right. That's not right at all. That's not right at all. And so I'm saying that yeah, you're right that it needs to be done that way. And yes, you are right what you said about the bill. Yes, the senator walked up to me and told me about the bill and said, "You got some comments." Comments, it's something 9 months, and I got 9 minutes, and I got to make a comment, and decide whether this ought to be legitimate. No, if people look strange at us sometime when we on the floor. That's the first impression we've seen of stuff. I ain't talking about a comment that I'm doing this, but the first is to sit down and let's go through each step by step. That's all that I'm saying. That'd be the first impression. So for us, what is it? It's committee of the whole because we are not on certain committees and things are thrown out there after the fact that they have been put together, and analyzed. And that's the third thing I want to say. I'm gonna be through, Mr. Chairman. That's why you have to have diversity. You got to have us and other people sitting at the table with you to be able to share these other angles and things that you got to put into the mix. It's like making a cake. You don't have no lemon flavoring, your cake ain't gonna taste worth nothing. You got to have it all in there. And so, yes, and I know this ain't the platform, but I'm gonna say it like this. You heard what I just said about the need for diversity. I mean, we down here now, we got folks in the house don't want us to even be at the table. It's bills. Yeah, I'm just saying this, so that's what concerns me, even here, that we're not taking any of that under consideration. None of that whatsoever. We just gonna wipe out the whole situation, just like we were saying about the inmates. So I just got a concern about that,
Understand.
Mr. Chairman.
Thank you, Senator. You had to bring up that you were the chairman of this committee, which means that I'm gonna pale in comparison. I wished you wouldn't have done that. So big shoes to fill. So we're on the amendment. You've offered the amendment. I'll second that amendment.
I have one question I want to ask.
Yes, sir, go right ahead.
Did you consult DOC and or the governor's office since the governor had an executive order out there on good time?
So after the executive order, I gave the governor's office this bill for their review the day that I filed it. I have had my door open for DOC. I have had 3 or 4 very, very in-depth discussions with DOC in my office, and my door has been open for discussion.
And what did they say, if you can share that?
So the last thing I had a meeting with the commissioner, Mr. Williams and Dion, and the only thing that they brought to my attention was that there might be an issue with reporting because their current software wouldn't potentially allow everything to be reported in the form that we were asking them. And I made that agreement with them that I would listen to anything they said about reporting, and we're still working through some of that stuff. But reporting was the only thing that they brought up to me.
So did they tell you
So I will tell you.
I'm just asking, did they say they just support and adopt this bill?
I
Did
don't
they
want
tell you
to
that?
put words in their mouth.
No, I was
They did not
asking
say
you.
that. No.
Okay.
No, they
that's
did
all.
not say they supported it. Let me be very clear.
Okay.
And I got some language in an email very late Friday afternoon that had some more suggestions. And I will tell you, it came from somebody that I'm not familiar with, but I assume they're related to DOC, related to numbers. But the only thing that I talked to them in person about in my office was reporting.
All right. Now we're on the amendment. You've offered it. I've seconded it. Let's take a vote on that. Holly, if you call roll.
Senator Albritton, Senator Bell,
Aye.
Senator Cornley, Senator Coleman Madison, Senator Elliott, Senator Figures,
I'll be consistent with the no.
Senator Gavan, Senator Orr, Senator Singleton,
No.
Senator Smitherman,
No.
Senator Stutz,
Aye.
Senator Weaver,
Aye.
Senator Barfoot.
All right.
Okay, 9, 3, and 1.
All right, amendment is adopted. I think Senator Bell, you had a question or comment about the bill itself now as amended.
I guess I look at this bill a little bit different. Um, if you get a 10-year sentence, judge goes into court, gives you a 10-year sentence. The person sentenced knows what they're getting roughly if good time is figured. I've represented multiple people, been on both sides of the aisle. And so you know you're going to do 3.5 years if you get a 10-year sentence. But if you go down there, act right, do the things you're supposed to do, that's when you're going to get out. But if you go down there and try to escape, you're peddling drugs, you're assaulting officers, you're assaulting other inmates, what are you going to do if you continue getting your good time? What are you going to do when you get out? You're going to continue the same behavior that you did in prison when you get out. There's no consequences to being bad in prison. And therefore, then my family or other families are in jeopardy of being hurt or being harmed. It's more of a safety issue from the people that are going to continue being bad, whether they're locked up or out in the public. And that's why I support the bill is they're going to continue getting in trouble when they get out. And the longer we can keep them behind bars, the safer our families are.
Thank you. Good comments. Appreciate your comments. Senator Albritton.
Thank you, Mr. Chair. Senator Weaver, I'm going to vote for your bill. All right. I'm of the philosophy that yes, bad people need to be behind bars. Our first duty is protecting the public. But there are lots of concerns here that I have, and it's concerning money, and it's concerning the practicality of where we're going to put them. We haven't built a prison in 50 years in Alabama. We have closed several. The number of available space of beds, if you will, is declining. We don't have room for people. In most of our prisons, we have the dormitories, which has 100 minimum, 150 sometimes in one area in a dormitory. Hence, we have the issues that's going on. Yes, we need to lock them up. But when we don't have locks, we don't have cells, we don't have doors, we don't have guards, where will they wind up being? Where are they going to be? Where do we keep them? How do we protect the public in that way, in that fashion? I have an amendment I've given to you earlier on. I support the bill, but I would like for this effective date to be delayed. Not delayed till we get new prisons built. I don't know exactly how long that's going to take, and that will be 2 or 3 years. But at least until we find a means to where we can have some additional space. Space I'm determining to be beds. So what my amendment does, and I'll read this for the body for just a moment. The pertinent part is that let's see, when the Department of Corrections certifies bed space is available. And it continues in that by the Commissioner of the Department of Corrections to the Governor, Speaker of the House and Representatives and Pro Tem, that it has the necessary bed space available to implement this act. When we have the room, we can take it. Now, Mr. Bennett Wright is here, and if the chair would like, I'm sure he'd be able to come forward and give some expert information as to how this may or shall affect the prisons and the spaces that we have, if that's amenable.
I have the utmost respect for Mr. Wright, and through this process, I've been engaged with him, had multiple discussions with him, and I know Senator Weaver has as well. And he certainly has the intellect and ability and expertise in this. And so I don't have a problem if you want to ask him to come up and answer any questions that you may have. I'm certainly satisfied with the bill in its amended format as it is. If you'd like to have him come up and discuss your amendment, that would be okay.
I would
suggest-
mind, there's just forbearance to find out if this is actually a valid amendment or not, whether it would have an effect.
Well, I don't have a problem with that. My issue is, and of course, I think this is a committee that we need to have open dialogue and discussion about. With the time constraints, though, there are 5 other bills. Senator Orr's got some folks here from out of town. I'll leave that to your discretion, understanding that, we've got several other bills on here that we need to discuss.
Senator Orr's mad at me already.
Let's
Mr. Bennett,
do
would you mind coming forward? Time constraints.
Yes, sir.
Will this Senator Weaver's bill, will that affect overcrowding or affect prisoner retention in prisons?
I'll give you the short answer. It's complicated, but it very well could. To really the extent that it would exacerbate prison crowding would rely on multiple assumptions. Those assumptions would rely on what is the judicial reaction to the change in the law with good time and paroling practices.
Would my amendment help alleviate some of those propensities?
It would definitely allow additional time for study and review to see what the potential ramifications of that would be in terms of, we talking about a bed space extra of 10 or an extra bed space of 1,500? It could run the gamut.
It could. That's why I've kept it simply to an additional bed space.
Yes, sir.
If I could, before I recognize you, Senator Figures, let me just make a comment or,
After him.
okay. Let me, the philosophy now is that good time is given on the front end and an inmate can lose that. So for an example, under current law, a 10-year sentence, an inmate could lose that good time and could spend up to 10 years on that sentence, for instance, correct?
That is correct.
And so this would not necessarily mean the implementation of the amended bill that she has, that Senator Weaver has. It would not mean that for sure that inmates stay in there longer than they currently could be in custody now for. Is that a correct statement?
It would definitely require people spend additional time in prison.
Requires.
It would.
Well,
Yeah.
it would require, tell me if I'm wrong or right, it would require the potential that they spend additional time. But the population now could lose good time now and not receive that good time, and on a 10-year sentence could be locked up under today's law for up to 10 years if they lost good time and didn't receive it. Is that an accurate statement?
That's an accurate statement. Their parole dates would actually be pushed further back. So their first bite at the apple at the parole hearing would be pushed further back. So their minimum time to serve would increase.
But it's also true that under today's standards, right or wrong, in which I may wind up agreeing with Senator Smitherman about, that those inmates are not getting paroled out now by and large. Is that a correct statement?
That is correct.
Okay. And secondly, just want to point out something. Good time only applies to inmates of 15 years or less.
Yes. So the easiest way to think about it is the converse. People that do not receive good time are inmates sentenced to death, life without parole, Class A felonies, any sentence in excess of 15 years, splits, a death involving a deadly weapon or instrument, and child sex offense.
And the inmate
complicated.
population that is eligible for good time at this point is about 10%. Is that?
And climbing, it's about 26 to 2,700 of the 21,000 that are currently incarcerated.
And your statement about the potential changes from the judicial side of the equation, which I support, split sentences, it allows judges to have more control or allows judges to make sure they know what the inmates are doing. If that model switched from the judicial side, then those split sentences would not be eligible now, nor they're not eligible now for good time, nor would they be eligible in the future. And so this
Correct.
bill would not adversely affect any of that population. Is that correct?
That is correct.
Okay, thank you. Senator Figures, you had a question or comment?
Yes. Senator Albritton, I'm glad you brought that up. You know, we were in a meeting, I think last week or week before last, with mental health, dealing with Mobile and Baldwin counties. And they were asking for capital money. And when Senator Albritton asked, well, he asked about training, which led into my question about staffing. Did this include that too? Because you can't build a building with beds unless you have the staff to take care of the people who are going to come there. So you're raising the same question here, basically, that even if we had the additional beds in the rooms, they're going to be staying there longer. It's already been noted that we're having a problem trying to hire people into the system anyway. So, and that is why I said too, let's take our time to make sure what we're doing and that we take the time to see exactly what the consequences are going to be and ramifications are going to be down the line so that you don't get in there and then you can't really be effective with what you're actually trying to do.
And
Thank-
Senator, if I may, I'm not trying to carry this over. I'm not
I didn't
trying
say
to
you were.
delay.
I
All I'm
just
trying to
mentioned the
do-
money.
Yes, ma'am. All I'm trying to do is delay the effect of this bill for some time frame until DOC can find some additional space in which to cover the potential here. And as already been discussed, we're not talking about a whole lot of people necessarily. The small percentages is there. So I'm asking for a little bit of delay. And at that point, I would move to adopt my amendment and ask for a vote.
You've offered that amendment. Senator Weaver, you want to speak on that? I would say that in the essence of times, we're still in the first bill and we're 45 minutes into it. So
Wow.
So I would, I just got this amendment as I was coming in the door. I haven't had time to look at it. I would like to discuss it more with you before we.
I would love to
adopt it.
discuss it.
Senator, would you
Offline,
would you-
between here and now. And I
would you consider delaying a vote on your amendment to have some opportunity to discuss with Senator Weaver?
Mr. Chair, I'll follow the lead of the chair as always, but I would like to get a vote to find out where I am on this.
Okay. So you've got to offered your amendment. Is there a second on Senator Albritton's amendment?
I would ask that we table that amendment.
Okay. There's a first and a second. We've got a motion to table the amendment. Let's take a vote on the motion to table and then we'll come back on the amendment should that fail. So we're on the motion to table.
Senator Albritton,
Motion's table, no.
Senator Bell.
Aye.
Senator Cornley. Senator Coleman Madison. Senator Elliott. Senator Figures.
No.
Senator Gavan. Senator Orr. Senator Singleton.
No.
Senator Smitherman.
No.
Senator Stutz.
Aye.
Senator Weaver.
Aye.
Senator Barfoot.
Aye.
8 and 5.
All right. Motion table is.
I thank the chair for his consideration. I'm sorry I've made other people other than Senator Orr mad at me.
Thank you. So we're back on the bill. As amended by Senator Weaver, you've offered that. I've seconded that without any discussion, any more discussion. Let's take a vote on that bill.
Senator Albritton. Senator Bell.
Aye.
Senator Cornley. Senator Coleman Madison. Senator Elliott. Senator Figures.
No. Sorry, I was drinking coffee.
Senator Gavan. Senator Orr. Senator Singleton.
No.
Senator Smitherman.
No.
Senator Stutz.
Aye.
Senator Weaver.
Aye.
Senator Barfoot. 9 and 4.
All right, the bill is given a favorable report. Let's move on. Second bill on the agenda, we're going to come back to that's SB 39. Let's go ahead and Senator Orr, you have some folks here that have come from out of town. So let's address your SB 55.
Okay, Mr. Chairman, thank you. And I do have two amendments I'll pass around very quickly. I'd like to call to the microphone so he's ready. Mr. James Tucker from ADAP. That's the Alabama, forget the what it stands for, but you can help us, James.
Yes, sir, I
And
can.
then it's in Tuscaloosa. I know that much.
That's right.
And this bill briefly is has been passed in 18 other states. So this is not a bill of first impression as far as our sister states. It provides an area where if you've got highly competent individuals and they're named as the adult in the bill, but they do have some mental, they do have some mental challenges. It allows a mid-grade between going ahead and proceeding with a conservatorship or guardianship for their assets or for their person, You don't go that far, but it allows them some autonomy. Questions been asked about powers of attorney. Why can't they just execute a power of attorney? Well, I think Mr. Tucker will tell you there has been a lot of abuse across the state where an individual may execute a power of attorney and then get the attorney, in fact, that it takes a lot of their assets and some problems arise. I'm trying to move it along, Mr. Chairman. I would like Mr. Tucker to add any comments, and then we can talk about the amendment.
Sure. Mr. Tucker.
Thank you, Senators. James Tucker with the Alabama Disabilities Advocacy Program, ADAP at the law school in Tuscaloosa. Basically, this bill would provide one additional alternative mechanism by which to allow individuals who are competent to retain their decision-making power and not have that power be taken away or then potentially abused by a power of attorney, guardianship, conservatorship. As Senator Orr said, it has been passed in 18 states. We think it's a useful alternative to guardianship in the state of Alabama and is a functional tool that should be available to individuals who would choose to exercise what's known as a supported decision-making arrangement.
Thank you so
Motion
much.
to adopt the amendment.
Got
Okay,
motion
so
to adopt. There are two amendments.
There's two. So let's say amendment number one is the one with the form that would be embedded into the bill, and it doesn't have to be this exact form. We wanted to get kind of the highlights and the requirements. Mr. Latham drafted this and is very supportive.
Okay, so we're on amendment number one. You've
So I'll
offered. Got a-
second the motion by Senator Singleton.
All right. Senator Smitherman.
Thank you, Mr. Chairman. Who is going to make the determination whether this person has the capability to enter into this mid-range agreement? Because to determine the conservatorship and the guardianship, you have to go to court. You
Senator,
have
I
to
think
sit
it's a,
there.
yes,
Let
sir.
me finish my
Yes, sir.
question. if you don't mind. And in that court, competent witnesses, medical records, depositions from doctors, along with a variety of other pieces of evidence are presented to the court. At that time, the court makes a determination whether this person is a non-compos menace or whether or not they can understand fully their decisions. Things are brought in like whether or not medical show that they're at the beginning phase of Alzheimer's, whether or not the fact that you may in a situation, if you allowed them to go forward, whether or not the conditions that they were in were going to be deteriorating kind of conditions, which we don't have a cure for, that's going to lead them to a point that they can't do that. Who makes that determination, number one, in this bill about this level, and what kind of safeguards are in place in this bill? I'm not talking about what's out there because that applies to the conservatorship and guardianship. In this particular bill, what is it there that's going to address those issues I just mentioned?
Yes, Senator, a couple of thoughts. First of all, the mechanism provided in this bill is like a power of attorney in that it is an instrument entered into outside of court, if you will, like a private contract. However, it is different from a power of attorney in that it does not give rights to another person to make decisions about the integrity and decision maker of the adult entering into the supported decision-making agreement. It's different from a guardianship and conservatorship, as you indicate, in that it does not require a court order. However, there is a protection in this bill such that if there is a concern regarding the execution or implementation of the supported decision-making agreement, then the probate court may review the propriety and execution of the supported decision-making agreement. So as described at the top of the discussion, it provides an alternative to guardianship like power of attorney, but it's not nearly as intrusive as a guardianship or conservatorship. So the bottom line is that it preserves decision-making integrity to adults who are competent.
Thank you for that. And for that question as well, because I had that similar question, and I'm supporting the bill and the amendment. If we could, let's get back on the amendment. There was a first and a second. I mean, a first.
Mr. Chairman,
Yes, sir.
I had a follow-up.
Oh, I'm
what you
sorry.
were just
Go ahead.
saying. May I? ask
Yes,
a
sir. Go right ahead.
Thank you. If this is a contract, because you've mentioned contract several times, and if the person who enters the contract deteriorates and become mentally, how in the world you're going to get out of the contract if there has been no determination by the courts of whether they were competent or not to make that contract? I mean, because the person who makes the contract, if they they deteriorate and paranoid schizophrenia, and want to, understand what I'm coming from. And
Yes, sir, I do.
they don't believe they supposed to take the medicine. You know that.
Yes, sir, I do.
Yeah, okay. So here's somebody who is when they taking the medicine, they competent enough to talk about it and do this and everything else, but now they don't take it. How is this contract gonna be void without that determination? I mean, you understand what I'm getting at? Now, I just tell you, I honestly see in this, I know there are some people that don't want people, or they don't want to have to get to the point that they can't control what they have. But I also see this setting it up for some of the most serious abuse under contract law that somebody's got a right to do A, B, C, or D. In fact, I've seen one case that has a similarity to this where the person was kind of competent, and then all of a sudden they wasn't, and then they came in and took all these folk money. Okay, see, under the name that they signed this and knowing what they are doing, here's the contract. So I can see the room for a considerable amount of abuse. And I think the Alabama Law Institute is working on something related to this as we speak now. And I think that will be more of a thorough follow through on this particular issue than all the abuses, unintended, of course, that this opens. And I'm through when I say this, Mr. Chairman. I keep saying this. It's just like on the last bill. We get all worked up about some emotional thing, and we don't see all these other things that's going to happen to everybody else that's in this once they move to that. There's nothing in here that deals with that, and so I have concerns about that aspect of it. Thank you, Mr. Chairman.
Thank you, Senator Smitherman. We're back on the amendment, first and a second on the First Amendment. Let's call a roll on that.
Senator Albritton, Senator Bell,
Aye.
Senator Carnley, Senator Coleman Madison, Senator Elliott, Senator Figures,
Aye.
Senator Gavan, Senator Orr, Senator Singleton,
I guess I made the motion.
Senator Smitherman,
Aye, on the amendment.
Senator Stutz, Senator Weaver, Senator Barfoot.
Aye.
12.
The amendment passes. Senator Coleman Madison, do you have a quick comment?
Yes, sir, I did. I want to thank Senator Smitherman because he basically took it to where I was going. And I'm one of the biggest proponents of an advocate for people with disabilities, having done that in my professional life. And the question that I want to have, I'm a co-sponsor on this bill, but I want to know, is there a review? Again, I'm trying to get to where Senator Smitherman is going. At some point in time, is there an annual review, or a person goes in to determine whether they are competent? Because, I believe that people with disabilities who can make that decision, I believe in nothing about us without us. But if it's set up where there's no review to determine, and I had a brother-in-law that was like that. And again, you're right. When he's on this medicine, he's doing fine. He could talk to you like PhD, but you let him get off. So is there a point in here where there is some type of review to determine whether that person is still in that state of mind where they can make their own decisions?
Senator, there's not a mechanism for a judicial determination. The decision-making agreement mechanism would operate more like a power of attorney than like a court-ordered guardianship or conservatorship. With regard to the questions that both you and the senator have asked, I would note that in the event of the deterioration of capacity of an individual, even if that individual had entered into a supported decision-making agreement, they still would be subject, for example, to a guardianship or a conservatorship, or in the cases that you have described, in the case of a serious mental illness and deterioration, they potentially would be subject to an involuntary civil commitment. So all of the protections that exist in our state law for individuals who might be at risk of deterioration remain in full force and effect. This simply provides one state law recognized tool by which to protect decision-making authority, which you're referring to.
Thank you, Ms. Tucker. Did you have a follow-up
I
question,
just
comment?
want to know, did you say how many other states use the same model?
Approximately 18.
I like to know
The House Judiciary Committee will come to order. Madam Clerk, please call the roll.
Chair Breen. Present. Representatives Edwards. Carter.
Present.
Hope. Here. Arbit.
Here.
Stevendorf. Here. Hoskins. Cerniglu.
Here.
Fink.
Here.
Wenzel.
Here.
Wozniak.
Here.
Outman. Johnson.
Here.
Madam Chair, you have 11 members present. You do have a quorum.
Thank you. I will now take a motion from Representative Hope to approve and adopt the minutes from the previous meeting. Thank you, Representative Hope. Those are now approved. And we are going straight to House Bill 4021 by Representative Vanderwall. We previously heard testimony on this. I have one card supporting the bill, not wishing to speak, from Tyler Woodenbush from the DNR. And I will take a motion from Representative Arbit to report House Bill 4021 with a recommendation. Madam Clerk, please call the roll.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Stevendorf. Hoskins. Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 12 yeas, 0 nays, 0 pass. House Bill 4021 is reported with recommendation.
Thank you. I'm sure you were all here for that particular bill, but given that the committee needs to go at ease now. Folks, thank you all for being here. I'm going to apologize for the late start as we now come back to order. And we are today going to be taking up secure storage bills, which includes House Bills 4139 through 4141 and House Bill 4144, as well as the Senate Safe Storage Package, which includes Senate Bills 79 through 82. I'll just be very honest here. The reason for the delay is that we have had a lot of substitutes to accommodate changes from various stakeholders that we believe are necessary. We have taken in a lot of input from an incredible amount of people. In fact, I'm not sure who we haven't heard from, because honestly, I think I saw my kids, third grade class all weighed in, them and their parents and every single teacher. Everyone is weighed in on these packages. We are doing our best to craft the best policy possible. Because of this has caused delays. We have one person who is helping us write these bills, and this guy is doing an incredible job. So we don't want to rush this through without being deliberative and thoughtful on this entire process. So that is why we are only picking up one package today where we have the substitutes ready. And I want to start by saying to everybody, nobody wants to lose somebody to gun violence. And I want us all to, again, start with that very basic assumption that we are all here for that reason, to try to save lives, to try to mitigate violence. We may not agree on the path to do that, but the goal is the same. And right now, what we have happening in our country, in our state, what has happened at Michigan State, what has happened at Oxford and Columbine and Parkland and Sandy Hook, what happens in homes every day due to domestic violence. We recently lost a 14-year-old in northern Michigan to suicide. These are all things that we can take different measures to in order to try to stop them. So again, I ask that everybody be respectful of each other, understand that there are gun violence victims in this room, and we have respectful dialogue. And with that, we are going to start with some testimony from Representatives Braybeck and McDonald, and I would ask that they come forward to discuss their bills on secure storage.
Thank you, Chair Breen, members of the committee. We are honored to be here this morning to be able to talk about this package. Safe storage has been a personal priority of mine since I joined the legislature in 2021. And I want to thank my colleagues, Representative McDonald, Whitsett, and Price, for all of their work that they've done so that to get the bill to where it is right now. All four of us, as well as the majority of our caucus who co-sponsored the bills, have strong confidence in this legislation and in the evidence showing that this kind of policy actually saves lives. And it's so important for all of us to remember. Our goal with this legislation is to save lives. And as legislators, that is where our focus should be when we're discussing these kinds of policies. With that being said, let's talk about what is in this bill. So the first bill, 4144, would require firearms to be locked and safely stored away where there is any reason to believe that it could be accessed by a child or when there is a minor in the home. This legislation would apply to firearms that are left unattended on the premises under the firearm owner's control, like one's house, for example. It would also apply to firearms left unattended at someone else's home, if that fire owner reasonably should know that it could be accessed by a minor. So what does it mean for a firearm to be locked and stored safely? There are three things. One, it has to be stored unloaded. Secondly, in a box or container, and that it's locked with a proper locking device. And that locking device ultimately prevents the firearm from discharging. To encourage and help to ease the process of Michigan's firearm owners obtaining storage and locking devices, Rep. Whitsett and Rep. Price's bills would exempt firearm safety devices from sales and use tax through 2024. And then I would also add that many of our counties throughout the state, I know that Washington does it, I believe the city of Detroit does it, offer free trigger locks for guns as well. So there are ways, if residents show up, I know again in Washington County, if a resident comes to the sheriff's office, they will be able to get a free locking device. And then Rep. McDonald's bill updates the sentencing guidelines. Again, this is widely supported, common sense legislation that will save lives. Many responsible gun owners already lock and store away their guns when they're not in use. And this bill package ensures that every Michigan gun owner will be held to that same standard. As we look back, as the chair mentioned, some of the devastating school shootings, we look back at Oxford and think about what we as legislators potentially could have done differently to prevent this from occurring. And safe storage immediately comes to mind. Children should not be able to easily access their parents' firearms unattended. And I think most Michiganders, actually, we know that most Michiganders agree that that's not an unreasonable sentiment to have. Oxford families in particular have been calling for our legislature to enact safe storage laws since that shooting happened in 2021. And as legislators, it would behoove us, and we must listen to the families of those who are harmed by gun violence and act now. Not only could safe storage prevent potential mass shootings in our future, these laws are also instrumental in preventing suicide in our children and teens. As many of you know, suicide accounts for over 50% of all gun-related deaths in our country. And that rate at which children commit suicide by firearm is going up year after year after year. But it's not the children aren't the ones who own those firearms. They're owned by adults in their households, and we must start holding them accountable. Regardless of circumstances, children should not be able to easily access a loaded firearm anywhere, but especially in their home. And children should not be able to hurt and potentially kill themselves or others because a loaded firearm was left available to them. This safe storage bill package helps to prevent these tragic and avoidable events by requiring guns to be locked and stored away from children and teens. It's just that straightforward. Madam Chair, thank you for your time today, and thank you to the committee. We're happy to take any questions.
Representative Fink.
Thank you, Madam Chair, and thanks for being here, Representative Brabeck, to speak to your bill. My question would be about the circumstances that might vary for different people in different places. Just as a for instance, in one of the counties that I represent, there are no sheriff's deputies on the road at night. The sheriff's department doesn't have sufficient staffing to have deputies on the road at night. So if you're in a rural area, the first police agency that you would expect to see in response to an emergency call would be the state police. And I don't know exactly what the response times are, but even with the sheriff's department around, it's not extremely quick. I mean, it's long distances, sparsely populated parts of the state. And my counties are actually in the top half of counties by population. So I imagine that this problem is actually exacerbated if you go farther north. In discussing this set of bills with an acquaintance of mine who also lives in a rural part of the state and who had, I don't know if abusive is exactly the right term, but let's say a tense relationship that involves some threats with a former boyfriend or partner. She expressed to me that her concern was that as a single mother, when she was faced with threats from her former boyfriend, and she knew that the police could not get there as quickly as he could, that something like this legislation might present a problem for her if the first thing that she hears is, him trying to get into her house. And so my question really comes down to, do you think that this is an area where different circumstances might suggest different practices make sense rather than one size fits all for the whole state?
So one of the things that I think is challenging with any of the laws that we create is that, of course, there are going to be different circumstances that might call for different things. One of the things that I believe we have to focus on is what is going to do the most good for the most folks. And that is this package of bills. There, like I said, we could come up with outliers in every case in all the laws that we work on. But this will do the most good for the most. There has been some discussion about immunity provisions within this bill. Are you able to speak to that? Okay. Sure. And Bill from MAJ is here too. We actually talked about him coming up. I don't know if he's in the hallway. If we could check. Thank you so much, Tanya. So what we have done is addressed the issues around our small businesses and those smaller gun owner stores so that are not liable. Come on up, Mr. Flory, if you don't mind. We're talking about the immunity piece. Yeah. I said, Bill and I were just talking about this. And so it would prevent that from happening as well as our federally licensed dealers as well. But Bill can say more.
Bill Flory, I'm with the Michigan Association for Justice. The language that's in the current act, as I think Senator Ruth Johnson pointed out when they were going over it there, is like, she questioned why you have immunity in this section, because it doesn't make a lot of sense going with the safe storage and then having a bunch of things saying that the manufacturers aren't liable when this doesn't really have anything to do with the manufacturers. This is all about the people who are selling or providing access. So it's not this isn't really a bill about manufacturing guns. This is a bill about what is a safe storage and what is going to be required to keep things safe. So we're leaving in the stuff that says federally licensed dealer, taking out the stuff that has a prohibits local units of government from bringing any claims, and the thing that says that it doesn't create any liability for damages for misuse. So that's.
So if I understand this correctly, for our federally licensed dealers, our mom and pop shops, or whether it's Dickens
even
Sporting
individuals,
Goods
because
or
you
any
can have-
individual,
There are several levels of licensed dealers.
as long as they are compliant with the rest of the laws, and let's assume that universal background checks does get implemented, as long as they do what is required by law, they'll be A-okay?
Yes. Yeah. This basically specifically says they're not liable for any damages for use or misuse as long as they have complied. So if you do the safe storage stuff and you provide the person with the information, if they don't follow it, that isn't on you, because that wouldn't make a lot of sense.
Okay, so our folks that have been in business for years and years, as long as they comply with the law, they are not liable, as they should not be, if the gun falls into the hands of a bad actor.
And that's actually the current law.
So, and as far as manufacturer liability, what is the current status of that in federal and state law?
Federal law bars any lawsuits against manufacturers.
Okay.
Yeah, so that won't really change. This just avoids having a Michigan law in case the federal law changes.
So if I'm understanding these bills correctly, we are simply asking people who own firearms to ensure that their personal responsibilities accompany their personal rights, and to ensure that we don't have the tragedies that we have seen, as Prosecutor Worthy has pointed out, where children have found firearms on their beds, behind televisions, in a variety of places, and children have unintentionally caused themselves or their family members harm.
Yeah, but those failures wouldn't attach to the dealer. They would be on the person that failed to do that. The dealer's responsibility in this is to make sure they have the information about it and they have a lock and so forth.
Okay. Does anybody have any? Representative Hope?
Thank you, Madam Chair. Thank you for being here this afternoon or morning, whatever it is. I lost all concept of time. One of the questions I get regarding this particular safe storage package is how would it be enforced? So there are some pretty obvious examples that might come to mind, but maybe less obviously, like if someone's minor child, accidentally or intentionally harms or kills himself, would that person be prosecuted? Would the person be prosecuted if there's a theft from a home and it's determined that, well, that person didn't have their gun
Sure.
securely stored? Can you talk a little bit about that?
Sure. So I would take a crack at it, but we have attorneys here who, and I'm not an attorney. So I would, Tanya, do you mind coming up? We have Tanya from Brady, because I anticipated that there are going to be some questions that were really specific.
Good morning, everybody. Can you hear me? Yeah. I'm Tanya Shart. I'm Senior Counsel and Director of State and Federal Policy at Brady. Thank you all so much for having me today. I think that's a really tragic example. And I think the first thing to consider when you're talking about safe storage laws is the goal here is not to punish or prosecute people. The goal here really is to effectuate behavioral change. It's imperative that we start treating safely storing a firearm the same way that we treat putting on a seatbelt, keeping your child away from dangerous medications or house cleaning products. We need to really ensure that it is the norm to safely store your firearm. So that's the priority. That's the goal here. That's the intention. There are going to be cases where people will be prosecuted, and certainly instances where a child has harmed themselves. It's devastating. And I think we're going to have to rely on prosecutional, like their preference. And I think they're going to have to think thoughtfully about whether or not they prosecute those cases. But it's important to establish the standards and for the standards to carry with it a penalty so that people understand that these are really important, these are really important ways to maintain and safely secure a firearm.
Thank you. Representative Wozniak.
Thank you, Madam Chair. Thank you, Rep. Maybe for your counsel.
Sure.
My understanding reading this is that two requirements of the gun owner is one, to store the firearm in a lockbox or container, or keep the firearm unloaded and locked, with a locking device. And it doesn't really say anything about a box, but then the duty goes further if there's a minor in the house to make sure that it goes into a lockbox. So is that the way is that correct?
Yeah, the way I read it is if you know or have reasonable cause to believe that there will be a minor in the area and you're not possessing the firearm yourself, that it has to be contained either in a locked box or it needs to be locked with a trigger lock or something else and unloaded.
Okay. Trigger lock is sufficient if there's no minor in the house?
Yes.
Thank you.
You're welcome.
Representative Edwards.
Thank you, Madam Chair. I just had a really quick question. So I do agree with the safe storage of firearms package, but I understand that the locks are $8 to $700. Can you restate where individuals can get the free trigger locks?
Sure. The ones that I know about are, in Washtenaw County, residents can get them. I was talking to one of our colleagues who gets to represent Detroit, and he said that he thought that was the same there. I also actually have a question in, and I'm happy to follow up. I have a question into our sheriff's department in Washtenaw County to see where else this happens in the state. And I was talking with him last night about that. And so he is going to be getting back to me about that so that we can get that information out to residents so they know that. But the cost is variable, and there are places where our residents can get those for free.
Thank you, because I know that's one of the concerns. If we can't afford it, what
That's
are
right.
the other
What do you do?
options? Right.
Mhm.
Thank you.
Absolutely.
There have been some questions raised about making certain storage devices tax-free. Are you able to talk a little bit about that? Either you or Mr. Flory or the representative from Brady.
So in the bill, they're not, both the trigger, any secure storage device is tax and use free. That's in the package.
Mhm.
So, it's part of the package. I don't know if I'm missing part of
Just
your
to make sure
question.
that we're trying to make these things more affordable
Yes.
and accessible. I know,
Yes.
I believe every police department in my district does offer trigger locks for
Oh, that's
free.
great. Yeah.
So I know for sure I walked into, for example, Northville City Hall,
Mhm.
and they were right there
Yep.
in a basket for people to use. So I personally would encourage people, if they need a trigger lock, to check with their local police department to see if this is something that is available to them for free. Do you have something else to add to that?
No, I think that's a wonderful framework. I think the
Mhm.
purpose here is to incentivize people to create new norms around safe storage. So whatever we can do to normalize safely storing a firearm, we'd be supportive. I think a tax incentive is a wonderful framework for that.
And there also are discussions in play about doing what we can to incentivize people to take training courses and other safety courses, because we do want people, as they use firearms, to do so in a responsible manner and to know how to best store and use them for whatever purposes they need. So those are discussions that are taking place. Representative Hope, you have a follow-up question? Okay. Representative Fink, you have a follow-up?
Yes, thank you. I wanted to follow up a little bit on this discussion of the liability issue for sellers and manufacturers. I understand that this language as amended in this, or it's, I guess, as remaining in what would remain in the law with this sub, in other words, what is not stricken from that liability section, would only apply to FFLs, right? So in a private sale, a seller would still, a seller between a non-FFL and a buyer, there would still be potential liability for the seller there for the actions of the buyer, right?
There's a private,
I mean, it says if you're a federally licensed firearms dealer,
right?
all right. So if you're not a licensed dealer and you're just a private, I mean,
Yes, and that, that also matches the federal law, the Protection of Lawful Commerce and Arms Act. It only protects federally licensed firearms dealers.
right. And then I guess then my last question on this line would be, you mentioned that if we remove this, then if federal law were to change, then Michigan would also not have there would be no issue with suing a manufacturer because the weapon was dangerous if the federal law were to change. I mean, that's the state of play if we remove this language from Michigan law. So,
yes.
I mean,
yeah, the Michigan law doesn't trump the federal law. The federal law trumps the Michigan law. And if the federal law goes away, then the Michigan law, if it were still here, would fall into place. And we'd end up kind of like we have with the drug immunity, where we're often left out. So
left out of what?
Larger lawsuits, like the opioid one. Individuals don't have any right to bring a case on the opioids.
So I just want to make sure I followed your testimony to say you want this removed so that if federal law is changed, then there would be liability for manufacturers.
Yeah.
All right. Thank you.
Just to clarify, there's nothing about right now that is to repeal that law that I'm aware of.
Oh, I mean, there's a federal bill to repeal the law, but I mean, I don't think it's moving at any time soon. The one thing I'll add is just like when we're talking about potential liability for manufacturers, it's not, oh, a gun is dangerous, I'm going to sue the manufacturer. It would be a failure on their part that you could pursue a claim against them. If we were to repeal PLCAA and we were somehow able to repeal this, there would still have to be an act or a failure to act on behalf of the manufacturer that resulted in harm to somebody.
Yeah. Basic tort law is always, there has to be a duty, a breach of the duty, and causation and injury. So if somebody created a duty on behalf of gun manufacturers to create non-harmful ones, then maybe there might be a claim, but I don't think that's going to happen anytime soon.
Representative Wenzel?
Thank you, Madam Chair, and thank you for being here. So you mentioned earlier that these bills are, as I understand, to impact behavior, right, to promote people. But you said 80% of Michiganders support these bills in safe storage. So isn't it assumed that 80% of Michiganders are already doing this, and the 20% that maybe don't support it, this isn't really going to affect them? Impact them?
At the risk of harming children and children dying, I wouldn't make that assumption. I think it's fair to create a mandate and to ensure that we are actually effectuating this change. Unfortunately, research has shown that while parents believe that children don't know where their guns are, they do. And we've seen this, I was very quickly Googling, I think 2 children died late last year in Michigan because of access to a firearm. So we have an obligation, I think, to protect our children. We do it with so many other items. It makes no sense that we're not doing it with firearms.
Representative Johnson?
Thank you, Madam Chair. With the idea of penalties for theft, can you comment on the sort of the contrast between a severe penalty for stealing a gun? Certainly there's different circumstances where they use the gun or they just possess the gun. When we think of stealing someone's prescription drugs and either committing suicide with it or reselling it or whatever, there's a definite penalty with that. Stealing someone's car, doing damage to somebody else, causing an accident, and certainly stealing a gun would be very serious. Can can you comment on the contrast between the penalty for theft
Sure, and
versus this?
I'm not aware of the exact penalty that's tied to theft of a firearm. I think it would probably depend on the value of the firearm, actually. But I imagine that there is already something in Michigan code that would make it unlawful for somebody, even a minor, to steal a gun. I think that's already built into Michigan code.
Are there any other questions from the committee? Thank you very much.
Thank you, Chair.
We have two people that are present that wish to speak in opposition to the bills. Given the time constraints, I ask that they limit their comments to about 2 minutes and to speak just to the bills that we are taking up today. Mr. Austin Krautz and a Tom Lambert. Are they present? Okay. Sergeants, if they wish to speak and they're in the overflow room, they're welcome. Gentlemen, thank you for being here. I know that you've been here before, and I apologize due to the time constraints, but we have a few minutes. If you could just speak to the secure storage bills.
The problem that I see with this bill is home invasion. My brother-in-law had a home invasion. To have these bills in place when you have a home invasion situation, to say, hey, wait a minute, I got to go get my gun. I got to pull out my trigger thing. I got to load the gun. And if you just stand there, then maybe I can defend myself. None of these bills that have come before this committee on gun control, not gun violence, gun control, will stop anything like the Michigan State disaster, the Oxford disaster, etc. Two things are what are needed. The first thing that's needed is the mental health issues. And the second thing that's needed is the early release of well-known criminals, like in the Michigan State disaster, who are allowed to leave an early release.
Sir, please limit to the.
I am. Just hold on a second.
These bills.
Yes, I am.
I absolutely agree. We need to improve mental health.
Okay, just mental health is part of this. To have us in a situation like myself, where I cannot defend myself for home invasion and other things, to have all of my guns locked up makes no sense whatsoever. I would refer you to John Lott's testimony. Look at it again. None of what you're doing will stop gun violence. Responsible gun owners will take the necessary means to store their weapons, but also we need to have a provision in here that we can have a loaded firearm that is easy to access, particularly in areas of high crime where people can defend themselves. Please consider some type for a change of amendment to some of the bills that you're passing. Thank you very much for the
Sir,
opportunity.
I do have a quick question for you.
Yes.
Are you familiar with some of the devices? And I know these might be more expensive, but we're going to see what we can do to address some of these issues. Safes or guns that have biometric aspects to them so that they are coded, and it would be, from what I understand, a split second for somebody in order to access that weapon if they do need to defend themselves.
Problem with those type of devices is it's limited to one person. Now, I'm here in Lansing. My wife is back in Allegan. And if somebody came in and the biometric of the gun would only work for one person, she's defenseless. Education, and I will say this, education is what is also needed. But the ability to quickly access with all members of the family. And the fallacy of this bill is that children also who are in families that have guns learn how to use those guns and certainly know the combination to the safe. You're not going to stop a child from walking in, dialing the dials on the safe to prevent a suicide. Common sense, folks. We have to have a provision that allows a loaded weapon readily accessible, particularly in high crime areas. Because I'll give you this last example. We had somebody knocking on our door at 12:30 at night. All right. We don't know who it is or what's going on. I took my Glock with me. Perfect stranger. The person's trying to get into the house. The moment he sees I have a weapon, he turns around and leaves. If I can't access that weapon immediately, my wife, my household is in peril. It's a necessity that you have some type of a provision that, particularly in high crime areas, that an individual can quickly have a loaded weapon on hand to defend himself. This bill that you're talking about, if I lock everything up, I can't say to the guy on my door, can you wait a minute till I load my weapon? Oh, by the way, I got to get that trigger thing out, and I got to do the combination as well on my safe. These are things that are realities, folks. These are things that are reality. What we should be doing is attending to the fact that some of these people that we release early
Sir,
are,
sir,
just
thank
excuse
you.
me,
No,
I'm
I'm
getting
asking you
to
to
the
take,
end. Let me just summarize here.
sir,
Get guns that are not,
sir, sir. Thank you. Appreciate your testimony. Mr. Lambert, again, please limit to the safe storage bills. Thank you. And 2 minutes max.
Good morning, Madam Chair, members of the committee. Overall, we hear that the public wants something and that these are an answer to what the public wants. The problem is that that is a gigantic bait and switch. The public generally favors people storing firearms and other objects safely. Okay, yeah, everybody supports that. If you were to ask them specific questions of, do you require this kind of thing, these specific provisions, making sure they have these kind of mandates, those numbers drop down significantly. And one of the biggest things in this bill is you've heard individualized circumstances. I forgot the representative that asked the question about individualized circumstances, but it's exactly right. And the answer was effectively a non-answer that, well, we have to make decisions that aren't perfect. I get that. But there are many laws that already exist today, many bills already on the books or already been introduced that create laws based on individualized circumstances. This legislature, this body, is very, very well practiced at doing exactly that. And so why don't we do it here? Why don't we meet the expectations of the public? Why don't we meet the expectations of people who want to reduce gun violence? Why don't we meet the expectations of members of the firearm community who may agree with liability in an individualized circumstance? We also get a gigantic bait and switch in the notion that there is no existence or any laws in existence today. We've heard testimony from many different prosecutors, both here and in the Senate, that have given very specific examples that they prosecuted over many misdemeanors and serious felonies for examples, again, that they've given. Again, that's existing law. So here today, we have a couple misdemeanors and some felonies based on, look at it, individualized circumstances. We do show that we can, at least in some way, tailor the bill to individualized circumstances. But then why does it create a one-size-fits-all obligation? That doesn't make sense. Why does it create a one-size-fits-all obligation when, again, we already have many existing laws on the books? If you were to ask the public, are you required to store your firearms safely today? I'm sure many of the people that say, well, we need this legislation would say no. And unfortunately, they'd be wrong. You are required. You can be charged, again, with multiple felonies, multiple misdemeanors. It happens already under existing law. That's not to say we need to do nothing. Don't get me wrong. But overreaching, creating one size fits all that doesn't, that's not a good policy for the state. It's not a good policy that's going to weather the test of time. That's important. As for some of the liability stuff that you heard testimony on, unfortunately, it was very, very wrong. I hate to say it, you received a lot of very significant misinformation on the liability provisions that are in this bill. I'd like to sum it up with, you heard existing law that if we remove these provisions in the law, then we permit, or removing the provisions in this bill permit lawsuits against manufacturers based on product defects, things like that, where you heard about the duty that under normal tort law, you have to breach that duty. That's already in the provisions that you're eliminating. So I don't understand why we need to eliminate the provisions that already allow for the thing that they want in order to have the thing that they want. I question the honesty of that testimony based on those facts. And you can look right in the bill. On page, what is it? Page 7, it goes down to line 17 and starts by striking out subsections 8, subsections 9, let's see, subsections 10, all the way through 13. If we go to page 8, roughly in the middle.
Sir, we do have some questions. Representative Devendorf.
Yeah, thank you for being here. I wanted to address this bill in particular, and address some specific things that have been said so far. I personally know that storage works. I was raised in a home with a gun because my dad was a police officer. He was a police officer that hated guns and stored his gun responsibly. And at a certain point, when we were all grown adults sitting around the table at a family gathering, myself and my 3 siblings, all casually shared that at some point, all of us had sought out where that gun was stored and tried to access it and failed. Depression is something that many folks in my family deal with. Any one of those attempts could have ended in a suicide or something catastrophic. My father, after doing his very best to keep us safe that whole time, successfully heard this and started crying. He is the loveliest, most generous person that I know. And he did the right thing. My hope is that we can make storage accessible to everybody, regardless of income. Make it as easy as possible to, yes, protect our kids who should not be able to easily get into our storage boxes and bypass our locks, because it works. And it worked in my family. I know it's working in other families where it's being used.
Thank you,
Forgive me,
Representative.
was there a question?
Sure.
Forgive me, the chair said there was a question.
I thought there was a question, but thank you for sharing that story. I understand that was difficult.
I feel it's important that I answer what seems to be a question from some of our advocates speaking against some storage. I feel the question is looming whether it works or not, and I want to ensure folks that it works.
Representative, thank you for that statement. And that's kind of what I was getting to in the beginning. Saying those people who bring up these concerns are opposed to storage, that's a false dichotomy. I started this very testimony by saying this isn't an opposition to storage. The gun community itself supports people storing firearms responsibly. It's just, what is that responsibly? We understand that can tailor to specific circumstances. And to be clear, if you vote in favor of this bill today, you're voting in favor of minors having access to firearms. Maybe that sounds weird, where all the comments have been minors shouldn't have access to firearms, but there are provisions in this bill that specifically pertain, that allow minors to have access to firearms even without parental consent. Are we paying attention to what we're voting on? Are we reading this stuff? Or are we just going off of the general talking points that don't necessarily apply to this specific language? Again, it is the specific language that we're talking about. It is the attempt to find that common ground that we're talking about. If we ignore that and we just push this stuff through because of talking points, then we end up with bad policy, or most likely bad policy that doesn't stand the test of time.
Okay, sir, we have another question, Representative Johnson.
Thank you, Madam Chair, and thanks for being here. What are your suggestions? I'm a single woman in a house by myself. Rarely have children around, but if they are around, then I use a gun safe and everything gets locked up and I'm not going to have to worry about it. What's your suggestion for a situation for single women, high crime areas, or maybe not even that, but so we can still have a feeling that we can defend ourselves and stay within confines of law?
Representative, thank you for the question, and forgive me for the vague answer, but it depends. It depends on the circumstances of that individual, and that's my whole point. If you have very young children around, they're, let's say, a 2-year-old. I have a 2-year-old at home. That 2-year-old is going to get into a heck of a lot less than like my 9, soon 10-year-old will. So the circumstances of what constitutes safe storage can be very different in those in each individual's again circumstances. So let's say the woman in your scenario has a 2-year-old. She might be able to reasonably keep that firearm away from that 2-year-old, but still have plenty of access to it for her own individual circumstances. And I just recently helped yet another person dealing with domestic violence that fled her home with literally just the clothes on her back because she feared for her life with her children.
Thank you, sir.
So
we
I'd
do-
like,
we
really
do-
like to finish answering that question.
We do have one other question after that. Okay.
I just
May
want
I finish?
I just want to clarify, and I probably didn't ask it correctly. I'm concerned that if everything's locked up and I have no risk of children around, I can't access self-defense.
Ma'am, the law would not apply to you. If you do not have children around, the law does, it's not a concern.
That's not quite correct. It's if you
That
could
is
also-
correct, sir. That is what the law literally says.
Let's go read the law.
We do have one more question from Representative Wozniak.
Thank you, Madam Chair. Mr. Lambert, I find your comments on the individualization really interesting with regard to this bill and compliance. Do you see that there's any way you could prove violation of compliance prior to something happening? This seems like it's all after the fact.
I agree. It is all after the fact. And that I think you heard testimony on this won't necessarily prevent some crimes, and that's fair and honest testimony, and it's good to hear. And we shouldn't hold this bill up to a standard of preventing every single scenario. I want to agree with that testimony. But yes, it does apply after the fact. And let's be clear, the bill starts off in the very beginning. Starts off with Section 9, subsection 1. An individual who stores or leaves a firearm unattended on premises under the individual's control, which would be the example in this case, and who knows or reasonably should know that a minor is, okay, if there's no minor, not the example, or likely to be present on the premises, shall do one of the following. So yes, the bill does apply to premises where minors aren't necessarily present. If you know that the minor is or likely to be present, then this absolutely could apply to you. But to go back to and finish answering the question, again, if you have a 2-year-old, safe storage looks very different than if you have a 17-year-old. We heard stories from the representative over here about if you're older, you are much more intelligent and can do a lot more to try and get into a safe or any sort of lockbox. And ultimately, the issue of storage is a balancing test. On one side, you have storage. On the other side, you need accessibility. And usually, when the more you go one way or the other, you have to give up the other side. The more you store something, the less accessibility you have. Generally, but not always, the more accessibility you have, the less storage you have. Thankfully, technology is making many, many great strides to bridge that gap. That
Sir,
allows
and I do have a question then. From what I understand, the biometric safes and firearms that we've heard about before, they can be coded to more than one individual.
They can.
Okay. And you're aware of studies that show that approximately less than 1% of violent crimes are stopped by the quote unquote good guy with a gun.
It depends on, so we've heard lots of statistics. And then we get lots of bait and switch in those statistics too. I know one of the statistics we've heard in this committee on these bills, so I'm narrowing my testimony to just this bill, is that firearms are the leading cause of death among children.
Correct.
Well, that's when you include 18 and 19-year-olds. And when you start looking at different things like gang violence, I think it was Dr. Lott testified to exactly that here in this committee.
Is that not a life?
But it
lost to
has
gun violence?
very different circumstances and a very different solution. Forgive me for broadening it out just a little bit, but to illustrate my point, if we deal with a mass shooter, let's use Michigan State University, the motivation behind that person is incredibly different than a minor who happens to find a firearm at home and is looking at it and doesn't know what they're looking
So you
at.
would agree violence is multifaceted and requires different solutions in order to mitigate it.
Yes, but when we take all of these causes and we lump them all into one thing, and then we use that one statistic that you're now using it for something where it's no longer an honest use of it. When you have the majority of the statistic pertaining to things like gang violence, and you say, well, we need this
The
for
gang
safe.
violence isn't pertinent to the secure storage bill.
Is exactly right. And that's exactly my point, Madam Chair. If you use a statistic that is driven in significant part by gang violence.
So then you're saying that because gang violence can't be addressed by secure storage, we should not do this bill?
No, Madam Chair, I'm trying to explain to you exactly what I'm saying. I'm saying if we use a statistics that is substantially driven by gang violence to support safe storage.
And what percentage of those deaths by minors do you think is attributable to gang violence? Because that is not the data that we have.
Dr. Lott talked to relatively exactly what those statistics are. I would defer to him as to the exact number. But we do know it is a significant portion, more than half, I believe, if that's correct, especially when you look at the 18 to 19-year-olds that, again, skew the statistic. That's, again, one of those big bait and switches. We tell the public how many times firearms are the leading cause of death among children. Well, if you go ask the public if they believe that statistic pertains to 18 to 19-year-olds, I'm going to guess vast majority of them will tell you no. They're being misled about these statistics.
I'm afraid I'm going to have to respectfully disagree because the data that we have shows that firearms are in fact the leading cause of death for children.
When again,
Again, there are still children that are dying, as Prosecutor Worthy testified, because firearms repeatedly are left out and they are accessible by children. And that is the intent of these bills. Representative
but why don't
Arbit
we
has
look
a
at
question for
statistics
you.
that pertain to those scenarios?
Sir,
Representative Arbit has a
I just
question.
wanted to clarify something with you. You're saying that am I correct in assessing that you are saying that the statistics on gun violence being the leading cause of death among children are inaccurate because 18 and 19-year-olds because they can vote are not considered children?
Numbers don't lie, people do. And that usually comes in the form of people applying titles and names to the numbers that it doesn't necessarily apply to.
So when a mother buries her 18 or 19-year-old child due to gun violence, that is not a child that she is burying in your estimation?
Does not the same standard apply to a 20-year-old and a 21-year-old and 22-year-old
I
and
would believe that it
23-year-old?
does, yes. Do you?
And so let's say the firearms
All
are
right,
the
sir, I'm sorry. I do actually appreciate your well thought out and you testify very well in opposition, and I appreciate your input. We do, however, have to move on to the vote.
Madam Chair, I do have more testimony, and
We've gone way over what I thought we would. I appreciate you being here. I'm happy to have a continued discussion with you offline.
I'd like it to be on the record that this limitation that you applied has been applied exclusively and only to people in opposition of these bills.
Okay, thank you for your testimony. I appreciate it. Have
So
a good day.
I just want to be clear, you recognize that.
Sir, we have to move on to the vote. Thank you. Appreciate you being here. I will now take a motion to adopt sub H1 from Representative McDonnell. Motion by Representative Edwards to adopt sub H1. Madam Clerk, please call the roll.
To adopt the substitute H1 to House Bill 4139.
Thank you, Madam Clerk.
Chair Breen.
Aye.
To to adopt, Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins. Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
Yes.
Wozniak.
No.
Outman.
Pass.
Johnson.
No.
Madam Chair, you have 7 yeas, 2 nays, 3 pass. The substitute is adopted.
Thank you, Madam Clerk. We are now reporting with recommendation as substitute H1, House Bill 4139. I need a motion to do that. Representative Devendorf. Madam Clerk, please call the roll.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins. Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman.
Pass.
Johnson.
No.
Madam Chair, you have 7 yeas, 4 nays, 1 pass. House Bill 4139 is reported with recommendation as substitute H1.
Thank you. I will now take a motion from Representative Hope to adopt sub H2 for House Bill 4140. Madam Clerk, please call the roll.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins. Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
Yes.
Wozniak.
Pass.
Outman.
Pass.
Johnson.
Yes.
Madam Chair, you have 7 yeas, 0 nays, 5 pass. Substitute H2 to House Bill 4140 is adopted.
Thank you, Madam Clerk. I will now take a motion from Representative Carter to report HB 4140 with recommendation as sub H2. From Representative Carter. Madam Clerk, please call the roll.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins. Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
Nope.
Outman.
Pass.
Johnson.
No.
Madam Chair, you have 7 yeas, 4 nays, 1 pass. House Bill 4140 is reported with recommendation as substitute H2.
Thank you. I will now take a motion from Representative Sergaloo to adopt sub H2 for House Bill 4141. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins. Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
Yes.
Wozniak.
Yeah.
Outman.
Pass.
Johnson.
Yes.
Madam Chair, you have 7 yeas, 0 nays, 5 pass. Substitute H2 is adopted.
Thank you. I will now take a motion from Representative Arbit to report House Bill 4141 with recommendation as sub H2. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins. Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman.
No.
Johnson.
No.
Madam Chair, you have 7 yeas, 5 nays, 0 pass. House Bill 4141 is reported with recommendation as substitute H2.
Thank you. I will now take a motion from Representative Edwards to adopt sub H1 for House Bill 4144. Please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins. Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Pass.
Johnson.
Yes.
Madam Chair, you have 7 yeas, 0 nays, 5 pass. The substitute H1 to House Bill 4144 is adopted.
Thank you. I will now take another motion from Representative Edwards to report House Bill 4144 with recommendation as sub H1. Madam Clerk, please call the vote.
Chair Green.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope. Yes. Arbet.
Yes.
Devendorf.
Yes.
Hoskins. Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman.
No.
Johnson.
No.
Madam Chair, you have 7 yeas, 5 nays, 0 pass. House Bill 4144 is reported with recommendation as substitute H1.
Thank you, Madam Clerk. I will now take a motion from Representative Carter to adopt sub H1 for Senate Bill 79 from Senator Bayer. Madam Clerk, please call the vote.
Chair Green.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope. Yes. Arbet.
Yes.
Devendorf.
Yes.
Hoskins. Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
Pass.
Wozniak.
Yes.
Outman.
Pass.
Johnson.
Pass.
Madam Chair, you have 7 yeas, 0 nays, 5 pass. The substitute is adopted.
Thank you, Madam Clerk. I will now take a motion to report Senate Bill 79 as sub H1 with recommendation by Representative Hope. Madam Clerk, please call the vote.
Chair Green.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope. Yes. Arbet.
Yes.
Devendorf.
Yes.
Hoskins. Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman.
No.
Johnson.
No.
Madam Chair, you have 7 yeas, 5 nays, 0 pass. Senate Bill 79 is reported with recommendation as substitute H1.
Thank you. I will now take a motion from Representative Edwards to adopt sub H1 for Senate Bill 80. Madam Clerk, please call the vote.
Chair Green.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope. Yes. Arbet.
Yes.
Devendorf.
Yes.
I didn't hear.
Yes.
Haskins. Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
Yes.
Wozniak.
Pass.
Outman. Johnson.
Yes.
Madam Chair, you have 7 yeas, 0 nays, 5 pass. The substitute is adopted.
Thank you. I will now take a motion to report SB 80 with recommendation as sub H1 from Representative Hope. Madam Clerk, please call the vote.
Chair Green.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope. Yes. Arbet.
Yes.
Devendorf.
Yes.
Hoskins. Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman.
No.
Johnson.
No.
Madam Chair, you have 7 yeas, 5 nays, 0 pass. Senate Bill 80 is reported with recommendation as substitute H1.
Thank you. I will now take a motion from Representative Devendorf to report SB 81 with recommendation. Madam Clerk, please call the vote.
Chair Green.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope. Yes. Arbet.
Yes.
Devendorf.
Yes.
Haskins. Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman.
No.
Johnson.
No.
Madam Chair, you have 7 yeas, 5 nays, 0 pass. Senate Bill 81 is reported with recommendation.
Thank you. And finally, I will take a motion from Representative Edwards to report SB 82 with recommendation. Madam Clerk, please call the vote.
Chair Green.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope. Yes. Arbet.
Yes.
Devendorf.
Yes.
Hoskins. Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman.
No.
Johnson.
No.
Madam Chair, you have 7 yeas, 5 nays, 0 pass. Senate Bill 82 is reported with recommendation.
I will now take a motion from Representative Sergelu to excuse absent members. Thank you. And seeing no additional business before the committee, we stand adjourned.
development of science in the United States. At the time, he was the former head of the U.S. Office of Scientific Research and Development. He also led the first National Research and Development Council and contributed to the Manhattan Project. And he lamented that Fleming, when he discovered penicillin, didn't seek a patent, saying that if he had, we would have had penicillin 10 years earlier than we finally got it. So I say that because I've learned, having emerged from a hospital for the uninsured, that there's an ecosystem of investors. And when you are a startup with really no assets, there are investors who invested in your company, as Senator Romney said, maybe taking a loss, but maybe winning big. They could have invested in anything else, but they invested in you. And they did it because they anticipated a return. Some of them got it, some of them did not. And if they invested in a startup that failed, they lost their money. So I say that because it isn't just so much the company that is established. There may be legitimate beefs, but if we're speaking about a company starting, I've learned that there is an ecosystem and they cannot get money unless that investor can see a return on that which she has put forward. No need to comment. With that, I yield.
Thank you very much. And Mr. Bancel, thank you very much for being with us this morning. We appreciate it.
Thank you, Mr. Chairman.
And now we're going to call our next panel. Our first witness will be Dr. Christopher Morton. Our next witness will be Dr. Umit Sarputari. And our third witness will be Dr. Craig Garthwaite. Let me thank all of our witnesses for being with us and for your patience. We appreciate you being here. Let's begin with Dr. Christopher Morton, who is an associate clinical professor of law at Columbia Law School. Dr. Morton is trained as an organic chemist and lawyer. He is a leading expert on equitable access to medicine. Dr. Morton, thanks for being here.
Chairman Sanders, Ranking Member Cassidy, and distinguished members, thank you for this hearing and for inviting me to testify. mRNA-based COVID vaccines are among the most important inventions of my lifetime. They've saved millions of lives. For 2 years, we, the people of the United States, had free access to these vaccines because our government purchased large quantities at affordable prices and distributed them for free. But that sadly is changing. The US government will leave Americans on our own to foot the bill. Moderna has proposed massive price increases from $20 or $30 a dose to $110 or even $130, though each dose costs less than $3 to make. Moderna's proposed price increases will mean that people who need boosters won't get them. More people will get sick and die. Higher vaccine prices hurt us all. Higher prices mean higher insurance costs, including higher Medicare premiums. Mr. Bancel claims the value of these vaccines justifies Moderna's proposed price increases, but his testimony ignored a key question: who created that value? It was the US government, the American taxpayer, that spent billions. It was government scientists that toiled alongside Moderna's. To quote Moncef Slaoui, former head of Operation Warp Speed and a Moderna board member, the US government, quote, held Moderna by the hand on a daily basis, unquote. Moderna is not the primary inventor of any of the 3 key scientific features of the NIH Moderna vaccine that Moderna itself has identified as critical to its value. We gave Moderna the specific mRNA sequence used in the vaccine. We designed and ran Moderna's early clinical trials. We gave Moderna money and resources to expand its manufacturing. The National Institutes of Health was so integral that it aptly named the vaccine the NIH Moderna vaccine, built on over a decade of pioneering research into coronaviruses at NIH. Yet Moderna has repeatedly exaggerated its own contributions and downplayed or even erased essential government support at almost every stage. For example, Moderna's lawyers intentionally omitted NIH scientists as inventors of a key patent application, the same NIH scientists who sent Moderna the vaccine's precise mRNA sequence. To quote NIH, omitting NIH inventors from the principal patent application deprives NIH of a co-ownership interest, unquote. And Mr. Bancel just confirmed a moment ago that Moderna abandoned that patent application rather than share control with NIH. To be clear, Moderna's scientists and engineers made many contributions of their own, as did many academic scientists. These people and their work deserve credit and celebration too. But Moderna cannot claim the vaccine's value for itself. And the American people, the most important creators of the value of this vaccine, deserve a voice in the debate over the company's prices. To quote Senator Casey, our partnership should not be extinguished just because we think the pandemic is over. To justify price increases, Moderna also points to $4.5 billion in R&D commitments this year. But $4.5 billion is easily doable for this company. In 2021 and 22, Moderna made over $20 billion in profits. The company has been so spectacularly successful that many of its executives and early investors became billionaires, including Mr. Bancel. As I speak right now, Mr. Bancel's net worth is reportedly about $4.7 billion, meaning he might be rich enough to fund Moderna's entire 2023 R&D expenditure out of his own pocket. In 2022, Moderna spent $3.3 billion on stock buybacks to enrich Mr. Bancel and other shareholders. That's as much as the company spent on R&D last year. Moderna's price increases are unjustifiable. If we let them happen, we set a terrible policy precedent. Other companies will double down on Moderna's playbook, extract billions in private profits from public science and public money, leave Americans with higher costs, inaccessible technologies, and poorer health. I urge Moderna, do not raise your prices. Your vaccine is clearly profitable at $20 a dose. And if Moderna insists on higher prices, our leaders should act. I'll make two recommendations now, and I present more in my written testimony. First, Congress and the White House should work together to resume bulk purchases of COVID vaccines, continue to use the buying power of the American people, and provide vaccines free of charge to everyone. Second, NIH and other scientific agencies must cut harder bargains with their industry partners so that we, the people, get access to the next generation of medical products that our money creates and that we need to survive and thrive. Thank you.
Thank you very much. Our next witness is Dr. Amit Sapatwari, who is an assistant professor of medicine at Harvard Medical School. He is an epidemiologist and a lawyer. He is an expert on the role of public investment in driving new medical breakthroughs. Doctor, thanks very much for being with us.
Thank you. Chairman Sanders, Ranking Member Cassidy, and distinguished members of the Senate Help Committee, thank you for the opportunity to testify. I urge you today to strongly condemn and swiftly act to prevent Moderna's attempt to quadruple the price of the NIH Moderna vaccine, which would fill the company's coffers with unmerited public funds and severely threaten public health. The reasons why center on the extraordinary role the federal government played in Moderna's success and the substantial barrier to access that this price increase would have. Building on $337 million in pre-pandemic funding of research directly contributing to key investments in mRNA vaccines, the federal government made a series of unprecedented investments in multiple pharmaceutical companies to develop a vaccine under Operation Warp Speed. Moderna was one of the largest beneficiaries, receiving over $2 billion to support clinical trials of the NIH Moderna vaccine, $1.5 billion in an advanced market purchase for a then unapproved product, and over $50 million to scale up manufacturing. In this respect, the federal government turned traditional therapeutic development on its head. The brunt of the risk, for which we reward pharmaceutical companies the ability to charge monopoly-like pricing, was borne by taxpayers. Moderna's benefits from the federal government didn't end there. NIH scientists co-developed the mRNA sequence encoding the vaccine's immunogen and independently developed the vaccine's spike protein. Moderna was also granted broad immunity against patent infringement for use of other patented technologies, which the company has cited as a defense in ongoing litigation. Through these federal government contributions, Moderna, a company that had never brought a product to market, was able to secure emergency use authorization of the NIH Moderna vaccine, benefiting handsomely from its use. Moderna earned $37 billion in revenue in 2021 and 2022, $20 billion of which was profit. Despite these riches, Moderna has at every turn sought to enrich itself further at the expense of Americans and the global South. In the US, Moderna has already denied the pivotal contributions of the federal government in the development of the NIH Moderna vaccine and broken its pledge not to enforce its patents during the pandemic. In October 2021, as the pandemic raged globally, Moderna was supplying its doses almost exclusively to wealthy nations, more so than any other manufacturer. Moderna's price increase is an escalation in this troubling pattern of behavior and a step too far. It cannot be justified based on the value of the vaccine, which was created on the backs of taxpayers and with essential contributions of NIH scientists. It also cannot be justified on the need for research and development. Moderna had ample funds for this. Flush with money, it maximized short-term profit. In 2022, Moderna spent more on stock buybacks than it did on research and development. Moderna's offer of a patient assistance program is no solution. These programs are often complicated, with applications that take considerable time to complete and frequent changes in eligibility, as well as onerous income documentation requirements. We've received no details of this patient assistance program to date. Given these barriers, it is likely that many Americans will miss booster shots, and this will result in more infections and more deaths, particularly among vulnerable populations. The public will also still bear the full cost of an unconscionable price increase. Now is the time to say enough. The federal government should resume purchasing doses for all Americans, leveraging its purchasing power to obtain a fair price. Such an act would not threaten innovation or the willingness of companies to race for a cure in a subsequent pandemic. Instead, it would demonstrate a dual commitment to allow pharmaceutical companies to profit handsomely for their efforts under reduced risk and to ensure reasonable access to Americans in a time of crisis. Thank you.
Thank you very much. Our next panelist was invited by Senator Cassidy, who's now voting, but I'm happy to introduce him. Dr. Craig R. Garthwaite is the Herman R. Smith Research Professor in Hospital and Health Services at Northwestern University. He is an applied economist whose research examines the business of healthcare. Dr. Garthwaite, thanks a lot for being with us.
Thank you, Chairman Sanders, Ranking Member Cassidy, and members of the committee for inviting me to testify today. Today's hearing is about Moderna's decision to raise prices for its COVID vaccine and some members of the committee's desire to push back on that increase. While potentially well-intentioned, the government's attempts to stop this price increase could impact drug development well beyond both Moderna and the COVID-19 pandemic. When the government provided what is undisputably a large amount of funding to Moderna, it did so without regulatory conditions on future pricing. It's inappropriate to now attempt to relitigate that question after Moderna accepted the funding. To put it quite simply, the correct time for government officials to discuss price restrictions with Moderna was before they finalized the funding agreement. Facing such potential restrictions on future profits, Moderna could have weighed its options and made the optimal choice for its investors, who we will note already provided $3 billion in private capital at that point. We chose not to walk down that road, likely because we knew it would delay the process of getting the life-saving vaccine we so desired. That was a policy choice and one we should abide by. Moderna, perhaps ultimately naively, trusted the government would honor its commitments and not try to enact ex post modifications to the funding agreements. Notably, Pfizer had a different view, and Pfizer's CEO, I'll also note, was not in attendance today. Trust of that nature, trust in the government, is critical to our overall system for drug development. And for that reason, while we gather today to ostensibly discuss vaccine pricing, we're actually having a far broader conversation about how economic markets can continue to provide new innovations for patients. Such markets are central to discovering novel pharmaceutical products. In those markets, we provide firms making large investments in drug development with a time-limited period where they can profit from these successful innovations. In this way, we trade off some reduction in access today from higher prices for the incentives for firms to invest in future products. These incentives are critical drivers of innovation that provide access to patients who might otherwise be left without any treatments for horrendous medical conditions. Over the past several decades, the world has enjoyed tremendous benefits from this free market system of drug development. Patients with diagnoses that previously amounted to death sentences have been completely cured or now have entirely manageable chronic conditions. Despite this progress, many other patients struggle with serious unmet medical conditions, and many others die every year because treatments simply do not exist for their condition yet. In debates about pharmaceutical pricing, access to medications for these individuals is all too often left unmentioned when we discuss the morality of drug pricing and access. These patients depend on firms being willing to continue to invest in future innovations. After all, few of our existing treatments came to market without meaningful private investment. Firms make such investments when they believe there are clear and identifiable rules that govern how they will earn potential returns from successful innovations and a trustworthy regulatory state to enforce those rules. Historically, the United States government has admirably served in this trustworthy role. But I fear private firms watching these hearings, along with other recent policy actions and statements regarding government price regulations and margin rights, are beginning to doubt the future wisdom of this trust. Understanding the potentially broader ramifications of a loss in trust in government does require acknowledging the incontrovertible fact that new pharmaceutical products are developed in an expensive ecosystem where private firms invest large amounts of fixed and sunk capital with little certainty of a profitable return. While there may be some limited anecdotal evidence of altruistic individuals giving up profits solely to benefit society, these examples are unfortunately exceedingly rare. Hoping such altruistic funding will emerge from the ether is simply not a strategy for drug development. Instead, we must accept the reality that the private firms crucial to drug development can only attract the capital they need if they can generate a risk-adjusted return for their investors that is sufficiently attractive compared to other non-pharmaceutical investments. And most of these investments ultimately fail. Firms can withstand these failures because a small number of large successful investments support a larger number of failed projects. If firms believe that policymakers will ultimately expropriate the gains from investments that are deemed too successful, they will not invest in the first place and will get fewer products. As much as we may not like it, this is true even when it means allowing firms to capture large windfalls from products that generate massive amounts of value for society. And if we choose to ignore this fact in favor of specious arguments and grandstanding about pharmaceutical greed, we will clearly forfeit access to future medical innovations. That said, our goal is not to provide firms with unlimited returns on their investment. We must aim to balance the incentives necessary to attract private capital with the ability of patients to access the resulting medical innovations, and I provide numerous suggestions to that end in my written testimony. Regardless of the choices that we make, it is critical that we understand that if we decrease spending on healthcare, on pharmaceuticals, we will get fewer products. That might be acceptable. We might want less innovation and lower prices, but that is the debate we should have. We should be debating how much innovation are we willing to give up, not falling for promises that we will have lower spending and the same level or more prices. Thank you, Senator Sanders and Senator Cassidy.
Thank you very much. Let me begin by asking Dr. Morton and Dr. Sapatwari their assessment of Mr. Bancal's remarks. Dr. Morton?
Thank you, Senator. There's a lot in Mr. Bancal's remarks. I might start with his claim that the U.S. government has already been repaid somehow by Moderna for its contributions to the NIH Moderna vaccine. I think I heard Mr. Bancal say that we have already received something like $2.9 billion in benefit from the company. He describes this as a discount that was granted to the American public back in 2020 and 2021 when we were purchasing hundreds of millions of doses. This is revisionist history. This is sort of a new telling that Moderna has come up with, I think, since this committee called this hearing. At the time that we cut these deals, these were negotiated prices between a buyer and a seller. Moderna sold its doses for about $20 a dose, similar to what Pfizer sold its doses for, similar to what Moderna sold its own product for overseas. And so to view it as a discount, I think is artificial and very much post hoc.
Thank you. Let me go to Dr. Sapatwari. Microphone.
Thank you. I'd also like to touch upon the issue of the discount. I don't believe it was a discount in return for the government's contribution to drug development. Moderna was a smaller company. It was a company in which, if it invested in, there was more risk. The actual guarantee that Moderna got was a guaranteed purchase, even if the product was unapproved. That differs from other purchases under Operation Warp Speed. So Mr. Bancel has at times attempted to justify the price increase on the grounds of increased costs. It seems to be a little bit improbable that 100-fold increased cost would be there with distribution systems that already exist. But that's not really what irks me so much. What irks me is that at times he justifies it on the basis of cost, at times he justifies it on the basis of value. He can't have his cake and eat it too. I think that what we're seeing here is the privatization of gain and the socialization of risk, which is not a sustainable way to operate.
I want to ask both of you, pick up on a point that Dr. Gothwaite and many others have made. In the world right now and in our country, there are people who are suffering and dying because they cannot afford the high cost of prescription drugs. It's true in the United States. It's certainly true in poor countries around the world. Correct me if I'm wrong, but there are probably millions of people dying of preventable, curable diseases simply because the price of medicine is too high. In your judgment, is there another model out there that addresses the issue of making sure that when a drug is developed, a life-saving drug, its goal is not just to make huge profits for the drug company, but to make it accessible to people all over the world? What am I missing in saying that there's something cruel and immoral of people dying and suffering in America and all over the world who cannot afford medicine, which often costs, as in the case of this vaccine, a few dollars to produce, really cheap? What do you think about the morality? And give me alternatives to saying, hey, I got to make billions. I don't care if you die. Is there another model that will create the drugs? Dr. Gothwaite talked about the need to create new drugs. We all want to do that. Is that the only model to say only way to do it is to make billions and people die? Is there another model out there? Who wants to take a response to that? Dr. Morton?
Sure, I'll start. Senator, that is a truly essential question, I think, in this moment. I will respectfully disagree with my colleague, Professor Garthwaite. I think he said something like, if we decrease spending, we will get fewer products. It suggests a kind of a zero-sum game. I think that's a false trade-off. I think there are genuinely transformative options available. The NIH Moderna vaccine proves this. The NIH Moderna vaccine is not a story of the triumph of the free market. It's a story of the triumph of public science and public-private partnership. We have incredible resources at the NIH and other scientific agencies. We can unleash these. We can do public sector pharmaceutical R&D, development, manufacturing, and we can cut better deals with industry when they come to NIH and other agencies to take some of our great technology to market.
Dr. Sapirwari, what's your thought?
So there definitely are other models, and the rest of the world use them. So one model that I'm thinking about is just to actually gauge the value of the product and base the price off of that. 2/3 of drugs that have been approved, in one past year that we took a look at, were actually rated by health technology assessment committees as offering no greater value than what exists today. So what we need to do is not treat innovation as a blank word. Innovation needs to mean clinically meaningful. And in that case, when something is clinically meaningful, I think we do owe manufacturers a good profit on their development. And I think that in those cases, we need to make sure that insurance is there to make sure that millions of Americans can afford these therapies. I do see it as a moral failure, and I think that we do have an obligation that we are failing the American people.
Dr. Gothwaite, I used your name and you can respond. Do you see any other model, any other choice other than saying you're going to become a billionaire, but people can't afford your product? Is there another model to get this science and innovation to people who need it all over the world?
We could certainly have the NIH increase its funding of drugs. I know right now that the NIH doesn't actually bring drugs to market. They do early stage development. my colleague, Dr. Morton pointed out, the NIH did partner with Moderna, but they did, however much we want to downplay Moderna's role here, there was $3 billion spent on getting a platform up and running for them. So there is a role for the private market to work together. I will note, though, that the NIH currently spends a mere fraction of what the private capital markets apply or supply to drug developers, something in the order of like 1/4 of what the private market has. So you would have to have the government step in, and then the government be able to allocate that capital in a way government has never shown it's able to do. And that's the
But
problem.
if the result was, taking your point, if the result was that we took that product after the companies made their fair share of profits and provided it to the world, to everybody in this country at an affordable rate, don't you think from a social and moral perspective, that would be a huge step forward?
I believe I was pretty clear in my testimony that we could have had that conversation with Moderna before we gave
I'm
them
not
the money.
talking about Moderna.
We can have a conversation with anyone beforehand, Senator, but you want to come back now after you give people money with no restrictions and then relitigate the deal. And that means people won't trust the government anymore.
Okay,
And that matters. And I think it should matter to you.
okay. Senator Cassidy.
Yeah, before I start, Senator Paul asked I submit these documents for the record. I ask unanimous consent that these documents related to myocarditis associated with the COVID-19 vaccine be entered into the record. Okay. Gentlemen, I've now learned in academia, you better have a beard. That's the one thing that seems to unite you all. It's interesting. I'll start with you, Mr. Garthwaite. I actually think that the federal government actually copied best practices from the private sector in the development of the vaccine. I spoke to some people once involved with angel investing in venture capital, et cetera. They find a clinical problem. They find the researcher that's done the best work. They work backwards and fund that researcher, and that researcher on that problem identified as essential, think ALS, which they're currently doing, then develops a product from which the investors make a return. Which is essentially what we did with the COVID vaccine. We got an issue. Who can do the work? We're going to fund you. Then we're going to bring it forward. Is that a fair statement?
Yeah, I think in many ways you could think of it operating like a venture capital or an angel investing firm where we had like a very specific target we needed to hit. And the government could be the venture capitalist for that. As the world gets more complicated, as we think about different pathways for treating diseases and different diseases, I just question whether the government's going to be a good venture capitalist, given all of the other.
I accept that. You don't have to argue that with me,
Okay.
brother.
All right.
Okay.
I was worried for a second, but.
And then not at all. Dr. Morton, Dr. Sarbatari, when I read your testimony, you're trying to build a case that the government has a right to march in or to dictate a price. Did they or did they not collaborate effectively or efficiently or whatever on the development of the science, et cetera? But that really goes beyond, passes, if you will, the point that Dr. Garthwaite makes, and what the CEO of Moderna made. If you're going to negotiate some limitation on how the price when we commercialize, then do it beforehand. Don't come back afterwards and ask to negotiate. Do it beforehand. That's really the crux of the matter. And when I read your testimonies, it seems as if you're building a rationale to circumvent that crux. Dr. Martin, I'll start with you. Any thoughts? And be brief because I got limited time.
Yeah, thanks, Senator. I think it is regrettably true that in 2020, the US government, the Trump administration, did not extract from Moderna a clear contractual obligation to share control with NIH or to set affordable prices. But it is clear from the record that NIH and Moderna were partners. They had an
but
understanding.
that's beside the point.
Well,
That's so sorry, and I don't mean because your testimony is all about that, but that's really beside the point. They did not negotiate before, and so Dr. And I'm limited time. I'm sorry, Dr. Sabtwari. I'm sorry if I'm not getting your name correct. I apologize.
Serpentwari. but yes,
Sabtwari.
Yeah. So thanks for the question, Senator. I agree that we need to do a better job upstream in negotiating contracts that would have avoided difficulty in this case. But I think there was an understood agreement here that in turn for all the late stage de-risking that was done, that Americans would have affordable access to this.
Now
vaccine.
you can't say that it is not affordable if there's going to be no out-of-pocket exposure for someone despite their coverage.
Affordable in two ways, I think, is slightly what I mean. So first of all, we know.
And by the way, I'm sorry to interrupt. That unspoken agreement probably should have been put on paper. I'm not going to argue with that. We need to have affordable drugs, but to come back and say it was unspoken is really a wish. It is not something which you can take to a court. And by the way, we can also argue whether the Trump administration failed. I was there, and feces were hitting the fan, and we were trying to get things done as rapidly as possible. And it's very easy to 2020 retrospectively look at things. But anyway, go back to your point. I'm sorry.
Sure. And so in terms of affordable, we need to look at the patients who are going to fall through the cracks through these patient assistance programs, which happen.
Now you're presuming because it's happened with other PAPs, it's going to happen with this one.
Yes, I am.
But the testimony is that they're already working with advocates for the homeless in order to make sure the homeless who are often drug addled and cannot fill out paperwork can get it completed, that sort of thing. So you're prejudging guilt, if you will.
No, I don't think so. I'm making an educated assessment based on a vast amount of evidence about these programs. I think secondly, when we talk about affordable, we need to think about what public payers are paying for these products, because that will limit, in the case of Medicaid, what it can spend in other places. And in the case of Medicare, that's going to result in higher premiums.
Well, it's two things about that. And by the way, if we want to talk about capping, block granting to states or doing a per capita cap on state Medicaid program, right now they have kind of an unlimited budget. And obviously that's a problem for the fisc. Dr. Gartway, there's been kind of a sense of, is there a new paradigm by which we could bring things to market? And by the way, I hope I got your name correctly too. Can we bring things to market with a new paradigm? But I'm told that prior to the passage of Bayh-Dole, only 5% of basic research was being translated to clinical practice. And Bayh-Dole, which basically said to universities, NIH has funded your research, but the university is going to now own the license to the patent. And you can work with private industry if you wish. And that was catalytic to dramatically increase the translational research of the basic science that NIH was funding. Is that a fair interpretation of history?
Yeah, I mean, I think we have a pretty clear sense that we are now able to commercialize things from what we often refer to as the bench to the bedside. That basic science done sort of at universities, of which a lot of my colleagues who are much smarter than me do, is great, but it's only great when it comes to patient welfare to the extent it turns into a drug you can take. And so Bayh-Dole provides a mechanism by which we can commercialize that science, yes.
And so basically at that point, we waved the white flag and we said to depend upon a federal government basic science researcher, and that's not what she or he is interested in, to commercialize or translate the science is not going to happen.
It's just a capital question, right? All of this is about like who's going to pay for those next steps and who's going to make the choices about what we select to move forward, where there's this difference between what is good science and what could be a good product. Venture capital does a really good job of taking things out of universities and figuring out what we should commercialize going forward.
In which case they get to set a price, which we may or not like, but nonetheless, that's part of the deal.
Yeah, I'd rather they set the price on a drug that exists than have people like my mother-in-law and others who've died of cancer because there's no treatment that exists for them.
With that, I yield.
Okay, let me thank our witnesses. Good discussion. Like to go on further. I got a vote. Senator Cassidy has another engagement. So this is the end of our hearing today, and thank you again. And let me thank Dr. Bancel, Mr. Bancel once more. For any senators who wish to ask additional questions for the record will be due in 10 business days, April 5th by 5 p.m. I ask unanimous consent to enter the record a statement from a stakeholder group about the cost of COVID vaccines, as well as a letter from the NIH about its inventorship of the COVID vaccine and evidence about public funding of Moderna. The committee stands adjourned. We done?
a year in safety. And as a result, over time, derailments are down, hazardous material releases are down, and injuries are down.
So
We
you-
can always get better.
Right, so you
That is
won't answer my
focus.
question about suspending the buyback program?
So their stock buybacks never come at the expense of safety.
Yeah, I take that is that you will continue with your plan on the buyback. My time has expired. The chair recognizes Senator Thune.
Thank you, Mr. Chair. First of all, I want to offer my deepest sympathies to the residents of East Palestine, as well as express my gratitude for the first responders, NTSB investigators, and other officials who arrived and have remained on scene since the derailment. Railroads remain one of the safest ways to transport all types of freight, including hazardous materials. However, the derailment in East Palestine serves as a stern reminder of the importance of this committee's vigilance in ensuring that agencies and railroads faithfully implement and enforce requirements set in place by Congress. The strongly bipartisan FAST Act, which was signed into law in December of 2015, included an expansive hazardous materials title, much of it directly responsive to the tragic derailment at Lac-Mégantic and others like it. This title set forth new, stringent requirements for the operation of high-hazard flammable trains and a schedule for complete replacement and retrofit of all tank cars carrying Class 3 flammable liquids, both meant to reduce the impacts of future derailments. Unfortunately, other rail safety requirements from the FAST Act are still pending on the regulatory agenda, something that this committee needs to work to correct. I hope the discussion today remains focused on solutions directly responsive to what we know about the underlying causes of this derailment and avoids talk of imposing restrictive requirements that decrease the efficiency of rail operations without proven data-driven benefits to safety. Chair Homendy, first of all, I want to thank you and your team for NTSB's leadership during the response and ongoing investigation of this unfortunate accident. In response to a requirement from the Rail Safety Improvement Act of 2008, the FRA finalized the Risk Reduction Program rulemaking in 2020 and subsequently approved the plan submitted by all Class 1 railroads. Could you describe why a safety management system like the Risk Reduction Program is so important to managing risk and improving safety?
It's critically important, and we recommend it in all modes of transportation, that operators are proactively identifying risks and addressing them before tragedies occur. And then as well, having a just safety culture so that employees are emboldened to speak up when safety concerns arise.
Mr. Jeffries, Mr. Shaw, could you describe the implementation of the risk reduction program by railroads, specifically how it complements existing rail safety regulations?
Thank you, Senator. As you mentioned, all 7 Class 1s have RRPs in place that have now been approved by the FRA. And I think the basis of them is that each railroad, because of the unique operating characteristics of that railroad, takes a risk-based approach to addressing potential issues on its railroad. It allows the opportunity to test out ways to address that. And rinse, repeat, and adjust as time goes by versus a more command and control one-size-fits-all. So we're very early in the stage. I think there's an opportunity there to create a flexible system that allows for a much more nimble response to risk. But that story's yet to be told. But I personally think there's opportunity there, and look forward to the railroads moving their programs forward.
Mr. Comstock, Section 7302 of the FAST Act required the Pipeline and Hazardous Materials Safety Administration, or what we refer to as PHMSA, to finalize a rule requiring railroads to provide real-time emergency response information to first responders on trains carrying hazardous materials. Unfortunately, that last requirement has languished since PHMSA issued an advance notice of proposed rulemaking in 2017, despite an updated deadline of December 2022 in the Infrastructure Investment and Jobs Act. So Chief, it seems to me that this type of information would have been extremely helpful to the first responders in East Palestine. Would you agree?
Yes, absolutely.
And Chair, your testimony mentions that NTSB has several open recommendations to PHMSA related to emergency response notification. It seems to me that the agency has simply failed to prioritize this rule. Have they provided NTSB with a better answer as to why this has been delayed?
I don't have their response on why that was delayed, but I'm happy to provide it for the record.
It would be great if you could. It seems to me at least that's a fundamental, one of the issues I think that has come out of this that would have made Mr. Comstocks and hopefully something that could have been used to avoid and mitigate the damage from this terrible derailment. My time has expired.
Can I add one thing?
Yeah, yeah.
Just to emphasize what the chief said, operations level training for firefighters. There are different levels of training. Most firefighters receive awareness level training, which is not appropriate for firefighters. At a minimum, they should have operations level training, which is a standard. And so just for consideration.
Okay, very good. Thank you. Take that to consideration.
Senator Peters.
Thank you, Madam Chair. And I just want to start off by thanking all of our panelists for being here today. I chair the Surface Transportation Subcommittee of this full committee, and I also want to thank Senator Brown and Senator Vance for their leadership on working to improve safety of our rail systems. My first question, though, is for you, Mr. Shaw. And Mr. Shaw, by the way, thank you for your willingness to testify here today. Your presence before two different committees in Congress this month should certainly underline how seriously this body takes not only this incident, but also on how important it is for us to enhance rail safety all across the industry. Over the past few months, Michiganders have seen multiple Class 1 railroad derailments in our state, leading to rail cars hanging off the side of a bridge in the city of Detroit, days-long passenger rail delays, and near miss of hazmat incidents. Michiganders are watching what's happening in East Palestine and are rightly demanding that we do everything in our power to prevent it from happening again. And I'm certainly committed to do that, and I appreciate that you've also stated your commitment to safety in your testimony here today and our conversation that we had earlier as well. Unfortunately, though, I received data yesterday that indicates that Norfolk Southern is not yet living up to that commitment. A document that I received, which I have right here before me, a document I received shows data from Norfolk Southern's own internal servers that there are dozens of rail cars operating on trains, some of which are heading into my state of Michigan, that have gone over 5,000 miles without a Class 1 brake inspection. That's thousands of miles above what the Federal Railroad Administration regulations require. Moreover, the documents show that over 100 cars have gone over 10,000 miles, and in one case, 90,000 miles without a mechanical inspection. And this is the data just from two trains. So I suspect we'll have data from other trains that we look at. So Mr. Shaw, I'd like to know, does Northern Southern have an internal standard as to how many miles before a train needs a full mechanical inspection? And how can you account for why your company appears to be running trains right now that have not been sufficiently inspected?
Senator, thank you for that question. I am not aware of that data. I can assure you that our policies are there to promote safety of our train operations, and we do not allow unsafe rail cars to operate.
Well, I'll be happy to provide what we have here and would appreciate your comments after the hearing. One of the explanations that I've heard for inspection issues that has been at least raised to me by railroad inspectors is that there have been workforce reductions that have reduced the frequency and the quality of those inspections. So does Norfolk Southern plan to hire more inspectors to fill this gap and to make sure that trains are traveling safely?
Senator, I've got a deep appreciation and respect for my craft colleagues. And ever since I became CEO in the middle of last year, we've been on a hiring spree. We hired a near record number of employees last year, and our pipeline of conductor trainees is amongst the highest in our history right now. And several weeks ago, I reached out to the heads of our largest unions and asked them for their assistance in helping Norfolk Southern enhance our safety culture.
Thank you, Mr. Shaw. Chief Comstock, thank you for your leadership and testimony today. In your testimony, you called out the importance of passing legislation that I have to continue funding for the Assistance to Firefighters Grant Program and the Staffing for Adequate Fire and Emergency Response Grant Program to ensure that our local fire departments have the equipment that they need, the training they need, and the personnel to respond to a major hazmat incident. As you know, I have authored that legislation will hopefully become before the Senate as early as next week, the Fire Grants and Safety Act, to increase that funding. Could you please discuss how important it is for this legislation to pass and how these grants, if they were to expire, would be detrimental to small communities like yours and make it really nearly impossible to respond to disasters like what we saw in East Palestine?
You're absolutely correct. From the fire service perspective, I can't think of any grants that are more important than those. For my own department, it's permitted us to get radios, to get SCBA, to put a generator in the station that we can put the doors up when the electricity goes off. Fire departments, particularly small ones, rely on those grants every year. They're critical. And without those grants, we could not do our jobs.
Thank you for your answer. Thank you, Madam Chair.
Thank you, Senator Peters. Senator Capito.
Thank you, Madam Chair. Thank you all for being here today. Mr. Shaw, thank you for coming to our EPW hearing 2 weeks ago. Appreciate that, and appreciate everybody being here today. Mr. Shaw, question I have on the ordering of your cars. It's my understanding that this was a 149 rail car train, that on the 23rd car was carrying plastic pellets, according to the NTSB report, that lit up like a match, and then and it had that overbearing wheel bearing, and I mean the overheating wheel bearing. And then 5 cars away were 4 cars of vinyl chloride. I guess first of all, I would ask if that's correct. And then I know that high hazardous flammable trains have more safety regulations. Why would this not have been characterized as a high hazard flammable train if it had this hazardous materials as part of the 149 car train?
Senator, thank you for your question. I'm not familiar with the entire makeup of the train. I know that a highly hazardous train is defined by a certain number of highly hazardous cars in it or a certain number of cars in a block.
Ms. Hammond,
Thank you, Senator.
Hammondy, sorry.
Thank you.
Maybe you can help me with that question.
Yes, the definition of a high hazard flammable train involves class 3 flammable flammable liquids only, and 20 car loads in a continuous block, which would be a unit train, or 35 car loads of class 3 flammable liquids in a mixed freight train. That was not what was on this train. There were some that were flammable liquids, class 3 defined flammable liquids, but this train was not a high hazard flammable train.
Right, it wasn't a high hazard train, but it had high hazardous materials, obviously very flammable, that just lit up the sky. So
that's right.
Is that something that you would consider that should be looked at as a safety improvement?
Yes, Senator. We think that the thresholds of the 20 and 35 should be eliminated, and we think a broader array of hazmat should be in the definition of high hazard flammable train.
Yeah, it sounds like that would. Let me ask about the tracks. We had a derailment in Cabin Creek a couple years ago where the track, it got cold, and I think then it melted, and anyway, the track it derailed there with some hazardous materials. How are we doing on track safety, and what kind of improvements might be in the future that if we look to this bill that Senator Vance and Brown have put together? Is this something we should look at? I know timber ties are what we're most still using. Is that the best materials to use? Are you looking at that at the NTSB or?
Yes, and track defects remain the second biggest cause of train accidents outside of grade crossing accidents. But human factors is number 1, train defects is number 2.
Rail defects.
I'm sorry, track defects. Sorry about that. Track defects. And there is technology, but we also think that personnel are critical as well, and that technology should supplement, not supplant.
Mr. Jeffries, did you want to address that question?
Yes, thank you. track cause being the second leading cause. On main lines, we did have the lowest number of incidents, rate of incidents in 2022, but we're not at zero. And it's important, Chair Homendy referenced technology that can be deployed. Autonomous track inspection tools can, one, provide a significantly more intense and sensitive type of inspection that's really 360-degree around the rail, through the rail, to identify anomalies before they become risks. And that can be attached to the back or the front of a train for continuous inspection. And that is not dehumanizing the network. That is using technology to supplement in a much more effective way the naked eye inspections that occur today. And so we believe we should be encouraging and enhancing and allowing additional pilot programs to expand that technology to take on and get the second leading cause of derailments even lower.
Let me ask a question about the communications. I'm a bit confused here listening to the testimony. When it showed that things were beginning to overheat, it passed through the 10 miles and 10 miles. Does that information come directly to the engineer at the time? Mr. Whitaker, I believe it's Mr. Whitaker, yeah. And why couldn't we do that in this day and age? We have instantaneous communications. Why is that not happening? Mr. Whitaker, can you clarify that on this particular accident? And yeah, I'd like to hear your thoughts on that.
Thank you for the question. So technically, there's two different types of defect detectors. One is a standard that gives an audible to the train crew over a radio. It will tell you the defect or no defects. They
Would that
add,
be like an automated voice stop, warning, or something like that?
that is correct. It
Okay.
sounds an alarm
Okay,
and it repeats various, depends on the railroad, 2 to 3 times.
okay.
But trending defect detector technology is like a add-on to that style detector. We are not notified of a wheel trending hot on the train. That goes to a location, like a headquarters building, a wayside defect detector help desk. They monitor that car. That is the big issue. They need to convey that information to the train crews because we get a no defect alert. So we're just going down the track.
Right, right. So it seems to me that would be a huge improvement if the instantaneous communication would go directly to the engineers. And the last question I have is, and I have they say never ask a question you don't know the answer to, but I have no idea what the answer to this. Would a different braking system on that train have made any difference? Mr. Shaw, I'll let you answer that one.
Chair Homendy was very clear that the use of ECP brakes would not have changed the result of this derailment.
Does anybody disagree with that on the panel? Yes, Chair.
So I had said it wouldn't have prevented the derailment, which is true. At car number 23, it still would have derailed, the fire would have ensued, and likely you would have still had some action on the vinyl chloride tank cars. In this case, it was a vent and burn. However, it could keep some of the cars on the train on the tracks, but FRA is doing modeling on that. It would probably be a couple of cars.
So we could have some more information on that as the investigation moves
that's right.
forward. Thank you all very much. Thank you. Senator Duckworth.
Thank you, Madam Chair and Ranking Member Cruz, for holding today's hearing. Illinois sits at the center of our nation's freight rail network. All 7 Class 1 railroads run through our state, including Norfolk Southern, as they all converge near Chicago. The Chicago region's freight rail network is enormous. We have 3,865 miles of rail, nearly 1,400 of which is shared by passenger trains. We see 1,300 trains a day moving through the Chicago area, which is one of the most densely populated areas in the country. To say that rail safety is important to our state would be an understatement. Yet, over the past decade, there have been at least 272 hazardous material incidents involving trains in 70 different Illinois communities. Last year, we were tied for the 3rd highest total of hazardous material incidents in the nation. The bottom line is that what happened in East Palestine could have just easily happened in Illinois. And among the causes of rail accidents are blocked rail crossings, especially among trains that are carrying hazardous materials. To address this issue, our state passed a state law in 1999 to try to limit blocked rail crossings. However, the law was unfortunately overturned in 2008 by a state Supreme Court decision due to a federal preemption. Ms. Hamady, the Bipartisan Railway Safety Act would require the U.S. Department of Transportation to issue new regulations to help prevent trains carrying hazardous materials from blocking crossings due to railroad delays. Can you explain how that would improve safety in a freight rail hub like Illinois?
Senator, the NTSB has not weighed in on the blocked crossing issue. We don't have a recommendation on that, so it's not something we've looked at.
You don't have an opinion on what a train with hazardous materials in it blocking a rail crossing?
I think it can
would
be
do?
a safety issue, certainly for first responder access to areas in communities, and having high hazardous materials could be an issue as well.
Thank you. Over my objection, as well as that of Senator Durbin and others among the Illinois congressional delegation, the Surface Transportation Board recently approved a merger of Canadian Pacific and Kansas City Southern. This merger will likely result in more and longer freight trains through the Chicago area, particularly the northwest suburbs. Ms. Hamady, without asking you to comment on the recently approved CP and KCS merger, can you explain the safety risks that could arise if a rail company injected more and longer freight trains, some of which may be carrying hazardous materials, into an already crowded rail corridor like Chicago with such a densely populated area?
Yeah, I will say for the East Palestine train, that one was not a particularly long train in our opinion at the board. The one in Springfield was a very long train. It was a 2.55-mile train. You have workers who have to maybe go back and inspect, stop and inspect an axle. And if you're walking back 2.5 miles, that is a lot
With your equipment.
on the crew with the equipment and potential safety issues, as well as higher gross tonnage on the train, which is a big safety hazard.
Thank you. In 2021, the Federal Railroad Administration recommended penalties for 7,300 regulatory safety violations it found after inspecting railroads, hazardous materials shippers, and rail car lessors. Of those, 3,400 were assessed civil penalties for a total of $12.3 million. This is an average of $3,600 for each assessed violation. That same year, Norfolk Southern's net income was approximately $3 billion. Ms. Hamady, do you believe that the current level of civil penalties is an effective deterrent? And do you think Congress should consider raising them?
The NTSB doesn't have a position on civil penalties. I will say that most civil penalties, unfortunately, are negotiated pretty low. They will be assessed as a civil penalty, and then there is a conference portion where they will settle their penalties on pennies for a dollar.
Do you think pennies for a dollar is effective deterrent for a multi-billion-dollar company like Norfolk Southern?
I do not.
Thank you. I yield back, Madam Chair.
Senator I'm sorry, Senator Schmidt, Senator Schmidt.
Thank you, Madam Chair. You know, East Palestine is a town that outside of East Palestine and folks in Ohio, people across the country probably hadn't heard of before this terrible tragedy. And there's a lot of towns like East Palestine. I know here in Missouri, where I'm from, Garden City, Fulton, Sykeston, Bridgeton, Missouri, where I'm from, a real blue collar neighborhood. These are towns that aren't filled with corporate titans or elites. They're working men and women who go to church on Sunday, try to get home for dinner, take their kids to practice, try to play by the rules. And all of those towns matter. East Palestine matters. And instead of showing up in towns like this, and specifically East Palestine, this administration demonstrated that they didn't matter. Joe Biden still hasn't showed up to East Palestine. He's been to Ukraine, but not East Palestine. Pete Buttigieg, it took 3 weeks for him to show up. And I think so much of this, in addition to the things that can be improved, is a lack of attention from this administration that the people of this town, for whatever reason to them, weren't worthy of an appearance of letting them know that we're going to support them. And so I think that one of the reasons, in addition to obviously the toxic chemical spill, that this has become such a big issue, it's demonstrative and shows that this administration is completely out of touch with what I'll refer to as flyover country, places like Missouri, places like Ohio. It just didn't matter, the Biden administration. And what's worse than all of this, I think, is that this accident was foreseeable, avoidable, preventable. And so, Mr. Shaw, I want to ask you, is it true that Norfolk Southern's accident rate has nearly doubled in the last 10 years? And at least 20 of those derailments since 2015 have involved chemical releases. Is that true?
Senator, thank you for your question. East Palestine does matter. I've been there a number of times, and I've visited with the community leaders. I've been in the homes. People have invited me to their business. I've been in the schools, and I've committed the full support of Norfolk Southern.
I hear you. You've said that, and I have limited time, but my question to you was, has the accident rate doubled in the last decade?
Senator, I am not aware of that. I'll be happy to provide you with that info. I know that from 2021 to 2022, many of our FRAs, most of our FRA safety stats improved. We will continue to get better. We are going to learn from this accident, and that's my commitment. Is I will lead Norfolk Southern and the industry to better safety practices.
Well, I would hope so. And, you know, I think understanding and we're happy to educate you on those statistics that we have at our ready about how the accident rate is doubled, because there's a lot of folks who live close to railroad tracks. I do. And there's a lot of folks wondering what exactly is going to be done to make sure this doesn't happen again, in addition to the things that need to happen to address the concerns at East Palestine. I did want to, with the remaining time that I have, Chair Hamady, as you know, in the aftermath of this incident, many in the media and in this administration were quick to blame the previous administration, President Trump, for not moving forward or rolling back regulations. However, those arguments have been dismissed by including the USA Today and even the Washington Post, noting that none of the regulatory changes made during the Trump administration at this point can be cited as contributing to the incident. Can you clarify to the committee today, I know you've made statements about this, just to clarify, that whether the regulatory rollback that took place under the Trump administration was responsible for this tragic incident?
I am not familiar with all of the regulations and actions taken on those regulations from that administration. What I will say is, with my comments were with respect to electronically controlled pneumatic braking. And there were a lot of comments about how that would have prevented this derailment,
Yeah, I think
which is not accurate.
Right, that was specifically cited by Pete Buttigieg, who, by the way, is not here again. I point out, I have many questions for Pete Buttigieg, and maybe he's taking more personal time. But this is now, we're few months into this Congress with a lot of serious issues involving the Department of Transportation, including this, and he just has refused to appear. And I think that you were very clear publicly saying that rule would not have impacted this at all. Is that correct?
It would not have prevented the derailment.
Correct.
Yes.
Correct. And Madam Chair, I'll yield back the rest of my time, but I do want to mention the obvious, as I just did, that Secretary Buttigieg is not here. He's yet to appear before this committee. And I think it's incredibly disrespectful, not just to this committee, but the American people, that he continues to hide from these disasters that have happened under his watch.
Senator Rosen. Senator Rosen.
Thank Senators Brown and Vance for working together in a bipartisan way to ensure that a tragedy like East Palestine derailment never happens again. And also, we have to think about preventing future accidents, how we can be proactive. So in addition to transporting hazardous waste, we also transport nuclear waste by rail. And the events in East Palestine should be a wake-up call for all Americans that it's time to address how we transport hazardous materials in this country. For Nevadans, the transportation of hazardous waste to our state by rail is something we've been fighting since the 1980s. For over 30 years, we've opposed the Yucca Mountain Nuclear Waste Disposal Project, in part because it would require transporting 9,500 rail casks of hazardous radioactive waste in 2,800 trains and over 2,600 trucks from across the country to Nevada. This is a major transportation safety crisis waiting to happen, putting major metropolitan areas in 44 states, their railways, and millions of Americans at risk. We already have an aging rail system, and consistent shipments of heavy casks of nuclear waste will cause wear and tear on our railroads and could lead to the kind of disaster we saw in Ohio or worse. And so, Chair Homendy, can you talk about some of the dangers of transporting this kind of waste, nuclear waste, could pose to our nation? And even though I, along with all the Nevada delegation, are committed to ensuring that Yucca Mountain never moves forward to become a reality, I still want to ask you if you're prepared to address nuclear waste spills that could happen as a result of shipping waste on aging rail lines through American cities to places like Yucca Mountain.
Well, I will say I do believe that there are some more protective measures for moving spent nuclear fuel. However, there isn't positive train control on, say, that last mile for Nevada. And I will also mention it would be disastrous if something did occur. On our resources, we are pretty strained. The NTSB has 12 rail investigators, and we have 4 pipeline and hazardous material safety investigators. We need to increase our investigator levels, but that requires additional resources, which we've asked Congress, and the president's budget would accomplish our request of $145 million for 2024.
Well, when it comes to safety, we should be investing in that. And I want to carry this a little bit further, because can you talk to us? You said that the positive rail control systems, they're not in Nevada. So we hope that would tell us if that would be beneficial. And can you also tell us, are the trains carrying nuclear waste, do they have their wheel bearings checked regularly? And what kind of regular checks are you doing to be proactive as we may be transporting some of this additional hazardous waste across the country?
They would be checked regularly, but I would have to defer to Mr. Jeffries on the exact requirements for those train inspections.
The federal government has established strict standards for transport of spent nuclear fuel and has determined that the railroads are the safest mechanism for doing so. I know my team would be happy to sit down with you and your team to talk about the specifics of the requirements there. But it is something that we would take with the utmost of seriousness, the responsibility that the government has delegated to our industry to move those cars with the highest level of safety.
Thank you. I look forward to talking about that, because I want to be sure that we're being stringent enough. And I want to move to another topic very important to Nevada. It is reliable freight rail for our tourism economy, because Nevada, we're the nation's leader in tourism and hospitality service. It's a sector that relies heavily on freight rail to bring in goods from out of state partners to support our industry. And the Interstate 15 corridor, which runs from California to Nevada, it is crowded. It makes it difficult for trucks to move efficiently, and it makes reliable freight rail service along the corridor all that more important. So, Mr. Jeffries, how do you think Congress can support more reliable freight system that moves goods quickly, but still promotes safety as its core priority?
Well, thank you for that. We're a service provider at the end of the day, and if we're not providing good, reliable service, then we're not doing our jobs. And I think the pandemic and the associated supply chain challenges really illustrated that. The railroads have been making significant progress on the service front, And as Mr. Shaw mentioned, and I mentioned in my opening, significant hiring efforts continue. We're at our highest level of employees that we've been in over 3 years. And really, it's about taking things to the next step. We've seen the Amazonification of the world. Folks want to know exactly where their things are, exactly when they're going to get there, exactly when the pepperoni is going on the pizza that they've ordered, when that's going to be delivered. And so railroads need to work to provide increased visibility into where their shipments are to their customers, increased predictability, and those efforts are underway. And there's some exciting things on the horizon. Thank you.
Thank you. I yield back, Madam Chair.
Thank you. Senator Fisher.
Thank you, Madam Chairman. The East Palestine train derailment has increased our public awareness of rail safety concerns, especially for trains that are moving through very rural, small communities like those in my home state of Nebraska. This committee takes rail safety very seriously. Modern technologies can enhance railroad safety, especially in how rail cars and tracks are inspected. Mr. Jeffries, can you explain how a two-pronged inspection system using visual and automated track inspections can improve rail safety?
Thank you for that, and thank you for your efforts on rail safety. You're exactly right. A two-pronged approach to track inspections is the appropriate path forward. So as we've discussed, autonomous track inspection tools allow for not only a continuous inspection of track as a train goes over, but at a much higher level of sensitivity, a much higher level of effectiveness, has been found to be 90% more effective in identifying flaws in the track before they become serious risks. And several pilot programs have been in place with some of our railroads at the FRA. Unfortunately, literally had to sue the FRA to expand those pilot programs and recently won in court the ability to do that. It's a shame that it took that level of effort for a proven safety technology, but it is a two-pronged approach. ATI doesn't catch everything, and it doesn't do every job that a human inspector does. So we absolutely still need the human inspection capabilities, and hopefully our inspectors are also spending more time addressing found anomalies than using the naked eye walking the tracks. And again, there's a place for both, and it's a complementary approach that I think will result in a much higher level of safety, which should be the ultimate goal for everybody.
Yeah, you know, that is the ultimate goal. That's what we're trying to get at here. So what's impeding the use of those automated technologies throughout the whole rail network?
Right. Well, we're going to take things step by step as we deploy this technology, for one. But two, we need a regulatory environment. We need a regulator that promotes innovation, promotes technology, promotes pilot programs, identifying new ways of doing things,
So you don't
allows
have
you to
to go
build
to
a
court
data
and sue
set.
them.
So you don't have to go to court. And let's have the opportunity to experiment with things. Some technologies may not work out. Others may prove to have dramatic safety benefits. Let's build the data sets that then we can objectively analyze in partnership with the regulator to advance safety.
Thank you. Mr. Shaw, as you're aware, the current law dictates common carrier obligations that railroads must abide by. Specifically, railroads must transport any freight under reasonable terms, including hazardous materials. Mr. Shaw, can you explain how the common carrier obligation impacts the way that your railroad transports hazardous material in coordination with shippers?
Yes, thank you for that question, Senator. Rail remains one of the safest forms of handling hazardous materials. We do have a common carrier obligation to handle product. We work very closely with our customers, with our fellow railroaders, and with elected officials and with the regulatory body to handle that in the safest manner possible. And I'll note that in 2022, our derailments were the fewest that they've been in the last 2 decades.
What obligation do shippers have, if any, on maintaining their rail cars that transport these hazardous materials?
Senator, as you know, there are many components of the Vance-Brown bill that we fully support. And the rail industry has been advocating and pushing for stronger tank car standards for about the last 8 years, is my understanding, and that is included in the bill.
Thank you very much. I just have a couple short questions here, Mr. Jeffries, for you. When I talk to my constituents in Nebraska, one of the items I hear about frequently is community notification. Folks just want to know what dangerous things could possibly be moving through their towns and cities while still maintaining the security that's needed, that information is controlled in a way, because we all know that there's a lot of people out there that would like to cause mischief. That would be disastrous.
Right.
In the FAST Act, which I helped to author, it added notice requirements that we did it in a way that provided first responders the information they needed. Again, ensuring that the local actors wouldn't have access to that. Those rulemakings haven't been completed, is my understanding. Do freight railroads agree that appropriate community notification is necessary? And what part do they play in ensuring that communities do have that information?
It is absolutely necessary, and we 100% agree with that assessment. And you're right, the rule was supposed to be done, I think, a year after the FAST Act, and so it's 7 years overdue. We didn't wait around. We developed our own mechanism to get information into first responders' hands. But we need help building awareness. We just sent letters out to every firefighter association in each state trying to build awareness. We're shifting towards versus a responder by responder sign up process to a emergency communications center model, because to Senator Vance's point earlier, if you're in a rural area, you don't necessarily have cell service, but there's a requirement that you always have radio service, to my knowledge, with the Emergency Communications Center. So if the Emergency Communications Center has that access, the first responder can quickly get that from there. But we've got more work to do, and look forward to working with Congress for further ways to get that information into those hands who need it.
Thank you. Thank you, Madam Chair.
Senator Lujan.
Thank you, Chair Cantwell, and Ranking Member Cruz for this important hearing, and want to begin by recognizing Senator Brown and Senator Vance for coming together and responding so quickly. Appreciate their staff and the work that they're doing. I also want to thank Ms. Allison for being part of that panel today. I think all too often the impact to a family or to a person are left out. And just want to say thank you for helping the country, those of us here in the Senate, better understand what the family has gone through. And it just reminds me that it shouldn't take a tragedy like this for there to be action. I appreciate everyone coming together now. It's the right thing to do. But why didn't we do it before? There's incidents all across the country where there's derailments. There's been conversations about reductions in workforce. You have less people looking at something, there's going to be a problem. It's not going to be identified until after something horrific happens. We all know the challenges, and one of my frustrations since being here in the Senate and the House is you go through these efforts and we fight for rules and we thank each other and we recognize each other for that work, and then it goes to be implemented. And then all the folks that didn't want the legislation get another crack at this, and then they mess it up over where there's a rulemaking or an implementation, and then there's a bunch of filings, which I'm one of those folks that reads filings, that create a bunch of loopholes. But then there's interviews that come after that and they, oh no, we wanted all this stuff done. I certainly hope there's a lesson here, and on this one, that with all these filings, every word is watched, every statement is watched, and that loopholes are not being advocated for by the groups that have been hired to represent companies or represent interests, only to allow for something like this to happen again. I hope we're mindful to that. Now, a week ago, a train derailed in a small community in Arizona, in Mojave. And just hours before, as you can imagine, that these trains, through small town after small town. It was in New Mexico. And my question here is around first responders as well, because when this happened, the initial reports that went to law enforcement was that there was a concern, a high concern of hazardous materials being carried on that train. It was corn syrup. So while I appreciate information was shared, that doesn't sound to me like first responders are being looked after when they're getting to an incident like this. There needs to be a better way of sharing accurate and timely information. I appreciate the questions of my colleague, Ms. Fisher, as well in this particular area, but I'm hopeful more can be done there. And that's where, Madam Chair, how can the process be improved to ensure that once a derailment happens, the first responders quickly receive the information they need to appropriately respond?
They needed advance notification. I do appreciate what the railroads have done with the Ask Rail app. The problem is when you have a derailment and train cars are bunched up, when you're pulling up a consist from the Ask Rail app, it goes by car in order. If you're looking at a derailment with cars all over the place, again, bunched up, you're not going to know what's in what car. So that's not helpful, but the first responders need
And that,
advance.
let me pause you there. Can that be fixed?
I'll have to get back to you on that.
If that's a problem,
But
before we have an incident, we know it exists today, and if that's broken in the system, let's fix it.
advance notification for the first responder community is key because they need to be prepared. They need to be adequately trained. They need the right gear, and they need to have emergency response planning done in coordination with the railroads so that they can be prepared in case something happens.
I certainly agree with that, but I want to bring attention to the challenge that you identified, and I appreciate you identifying it. But if that system's in place, but there's not communication because cars are close to one another, but you know what's in there, I just hope that that's something that can be fixed because someone knows what's in there. And I'll leave it at that. Mr. Whitaker, first, thank you for your testimony and your work representing Ohio's rail workforce. You stated in your testimony that since 2015, Class 1 railroads have cut over 30% of their workforce. And I mentioned that in my opening. Mr. Whitaker, yes or no, would expanding the workforce have a concrete impact on improving outcomes when it comes to safety?
Thank you for the question. Yes, it would. Adding to the workforce would definitely strengthen inspections. We would be able to reduce fatigue on people as well, the train crews.
Let me center on what you just said on fatigue. Would paid leave help? If people are getting worn out and tired and things of that nature as well, and you want fresh eyes so we don't see mistakes, would that help?
Absolutely. Right now, we have people that go to work sick with the flu, COVID, whatever the case may be, and they're afraid to take time off because if they mark off sick, they get reprimanded.
I appreciate that. I'm sure my time's expired. I certainly appreciate this hearing. There's so many questions I have. I'll submit the rest into the record. But to everyone that's helping the families, thank you for what you're doing. Please no rulemakings. We can all do better at that. And I certainly hope that's something that we can embrace. Thank you.
We proceed to the following items: Senate Bill 76 through 86, Senate Bill 147, and Senate Bills 158 through 160.
Without objection, it is so ordered. The secretary will read.
Mr. President, calendar item 6 is Senate Bill 76, a bill to regulate and license the selling, purchasing, possessing, and carrying of certain firearms, gas ejecting devices, and electromuscular disruption devices. The bill was reported by the Committee on Civil Rights, Judiciary, and Public Safety with a substitute. It is an S2. There are no amendments pending to the adoption of the committee substitute.
The question is on the adoption of the substitute. Is there any discussion? Seeing no discussion, the question is on the adoption. Oh, excuse me. Seeing no discussion, the question is on the adoption of the committee substitute. All those in favor will say aye. Those opposed will say no. The committee substitute is adopted. Are there any further amendments?
There are. Senator Hertel offers a substitute to the bill. It is S3. It's available on Session Web. It's identified as Amendment Number 2. There are no amendments pending to the adoption of the Senator Hertel substitute.
The question is on the adoption of the Hertel substitute. Is there any discussion? Seeing no discussion, the question is on the adoption of the Hertel substitute. All those in favor will say aye. Those opposed will say no. The substitute is adopted. Are there further amendments?
There are no further amendments pending to the bill.
Seeing no further discussion, the bill will advance to the order of third reading of bills.
Mr. Chair, calendar item 7 is Senate Bill 77, a bill to amend the Michigan Penal Code. The bill was reported by the Committee on Civil Rights, Judiciary, and Public Safety without amendment. There are no amendments pending to the bill.
Is there any discussion on the bill? Seeing no discussion, the bill will advance to the order of third reading of bills.
Mr. Chair, calendar item 8 is Senate Bill 78, a bill to amend the Code of Criminal Procedure. The bill was reported by the Committee on Civil Rights, Judiciary, and Public Safety without amendment. There are no amendments pending to the bill.
Is there any discussion on the bill? Seeing no discussion, the bill will advance to the order of third reading of bills.
Mr. Chair, calendar item 9 is Senate Bill 79, a bill to amend an act to regulate and license the selling, purchasing, possessing, and carrying of certain firearms, gas ejecting devices, and electromuscular disruption devices. The bill was reported by the Committee on Civil Rights, Judiciary, and Public Safety with a substitute. It is an S2, and it's available on session web and is identified as Amendment Number 1. There are no amendments pending to the adoption of the committee substitute.
The question is on the adoption of the committee substitute. Is there any discussion? Seeing no discussion, the question is on the adoption of the committee substitute. All those in favor will say aye. All those opposed will say no. The committee substitute is adopted. Are there further amendments?
There are. Senator Bear offers a substitute to the bill. It is an S3. It's available on session web and it's identified as Amendment Number 2. There are no amendments pending to the adoption of the Senator Bear substitute.
The question is on the adoption of the Bayer substitute. Is there any discussion? Seeing no discussion, the question is on the adoption of the Bayer substitute. All those in favor will say aye. All those opposed will say no. The substitute is adopted. Are there further amendments?
There are no further amendments pending to the bill.
Seeing no further discussion, the bill will advance to the order of third reading of bills.
Mr. Chair, calendar item 10 is Senate Bill 80, a bill to amend the Code of Criminal Procedure. The bill was reported by the Committee on Civil Rights, Judiciary, and Public Safety with a substitute S1. It is available on session web and is identified as Amendment Number 1. There are no amendments pending to the adoption of the committee substitute.
The question is the adoption of the committee substitute. Is there any discussion? Seeing no discussion, the question is on the adoption of the committee substitute. All those in favor will say aye. Those opposed will say no. The committee substitute is adopted. Are there further amendments?
There are. Senator McDonald Rivet offers a substitute to the bill. It's an S2. It is available on session web. It's identified as Amendment Number 2. There are no amendments pending.
substitute. No, the question is actually on the amendment. This is an amendment to the floor substitute, right? Sorry.
Mr. Chair, the amendment is not yet available online, and it reads as follow. Senator McMorrow offered the following amendment to Senate Bill number 83S2. 1, amend page 10, line 4 by striking out all of subdivision H and relettering the remaining subdivisions.
The question is on the McMorrow amendment to the McMorrow substitute. Is there any discussion? Seeing no further discussion, the question is on the adoption of the amendment to the substitute. All those in favor will say aye. All those opposed will say no. The amendment is adopted. Are there further amendments?
There are no further amendments pending to the adoption of the Senator McMorrow substitute as amended.
The question then is on the adoption of the substitute as amended. Is there any further discussion on the substitute as amended? Seeing no further discussion, the question is on the adoption of the substitute as amended. All those in favor will say aye. Those opposed will say no. The substitute as amended is adopted. Are there further amendments?
There are no further amendments.
Seeing no further discussion, the bill will advance to the order of third reading of bills.
Mr. Chair, calendar item 14 is Senate Bill 84, a bill to amend an act to regulate and license the selling, purchasing, possessing, and carrying of certain firearms, gas-ejecting devices, and electromuscular disruption devices. The bill is reported by the Committee on Civil Rights, Judiciary, and Public Safety without amendment. There are no amendments pending to the bill.
Is there any discussion on the bill? Seeing no discussion, the bill will advance to the order of third reading of bills.
Mr. Chair, calendar item 15 is Senate Bill 85, a bill to amend the Code of Criminal Procedure. The bill is reported by the Committee on Civil Rights, Judiciary, and Public Safety without amendment. There are no amendments pending to the bill.
Is there any discussion on the bill? Seeing no discussion, the bill will advance to the order of third reading of bills.
Mr. Chair, calendar item 16 is Senate Bill 86, a bill to amend revised Judicature Act of 1961. The bill is reported by the Committee on Civil Rights, Judiciary, and Public Safety without amendment. There are no amendments pending to the bill.
Is there any discussion on the bill? Seeing no discussion, the bill will advance to the order of third reading of bills.
Mr. Chair, calendar item 20 is Senate Bill 147, a bill to amend Elliott Civil Rights Act. The bill was reported by the Committee on Civil Rights and Judiciary and Public Safety with a substitute S1. The rules were suspended to allow for consideration today under general orders. The S1 committee substitute can be found online and is identified as amendment number 1. Senator Johnson offers an amendment to the committee substitute. Oh, I'm sorry. That one does not apply. There are no amendments pending to the adoption of the committee substitute.
Wonderful. The question then is on the adoption of the committee substitute. Is there any discussion? Seeing no further discussion, the question is on the adoption of the committee substitute. All those in favor will say aye. Those opposed will say no. The committee substitute is adopted. Are there further amendments?
There are no further amendments.
Seeing no further discussion, the bill will then advance to the order of third reading of bills.
Senate Bill 158 is a bill to amend General Sales Tax Act. The rules were suspended and the bill was discharged from committee. Senator Huizenga has a substitute to the bill. It's an S1. It's available on session web as identified as amendment number 1. There are no amendments pending to the adoption of the Senator Huizenga substitute.
The question is on the adoption of the Huizenga substitute. Is there any discussion? Seeing no discussion, the question is on the adoption of the Huizenga substitute. All those in favor will say aye. Those opposed will say no. The substitute is adopted. Are there further amendments?
There are no further amendments.
Seeing no further discussion, the bill will advance to the order of third reading of bills.
Mr. Chair, Senate Bill 159 is a bill to amend Use Tax Act. The rules were suspended and the bill was discharged from committee. Senator Heisinger offers a substitute to the bill. It's an S1. It's available on Session Web as identified as Amendment Number 1. There are no amendments pending to this adoption of the Senator Heisinger substitute.
The question is on the adoption of the Heisinger substitute. Is there any discussion? Seeing no discussion, the question is on the adoption of Senator Heisinger's substitute. All those in favor will say aye. All those opposed will say no. The substitute is adopted. Are there further amendments?
There are no further amendments.
Seeing no further discussion, the bill will advance the order of third reading of bills.
Trading the S&P 500, you love the ups. Can you handle the downs? Daily leveraged and inverse ETFs from Direction. Before investing, carefully consider a fund's objectives, risk, charges, and expenses contained in the prospectus at Direction.com. Read carefully.
Oh my gosh, thank you. Appreciate you so much. Okay, so let's see. Are we able to move in a little bit closer? Is it possible? Yeah, maybe a step over to the right and then closer here. Yes, exactly. And then our speakers, if I could have our speakers right next to me and we'll get started. Yeah, right next. Thank you. And then, yes. Okay. All right, perfect. Well, good afternoon, everyone. Thank you so much for being here. Really appreciate everyone joining us today as we reintroduce the American Families United Act. I am so privileged to be able to continue to fight for these amazing American families who just want to be with their loved ones. I mean, fundamentally, this bill is about ensuring that families can be together, that families can fully participate in the American dream, and that the United States government does not continue to stand in their way. I want to first thank my co-lead, Maria Elvira Salazar. This is a bipartisan bill. She is a champion for immigrants. She is a champion for these families. She could not join us today because of a scheduling conflict, but she and I stand shoulder to shoulder in wanting to ensure that these families are able to finally be reunited. This bill should not even have to be a bill. What we are trying to do is fix what is a terrible wrong that was committed in prior legislation. And we are trying to correct a wrong that has devastated far too many children and spouses. I'm going to let our families speak for themselves, but I will tell you, we came close last Congress to getting this on the floor. We were able to get this out of committee and then did everything that we possibly could before the end of last year's Congress to get it to the floor so that we could vote it out of the House. It was a very deeply frustrating process because this is a no-brainer. And the fact that we have to fight so hard tells you just how broken our immigration system is. Reuniting American families should be non-controversial. It should not be an issue for the Congress. But the fact of the matter is, this is a Congress that has been derelict in its responsibility when it comes to reforming outdated and terribly morally wrong immigration laws. We have not had any changes to our immigration system in decades. And instead, the federal government has chosen to address immigration as a border-only issue. That does nothing to help solve our greatest challenges and seek out the opportunities that come with bringing people into our country in a legal way that upholds our values and keeps our families together. So I want you to know I am absolutely 1,000% committed to ensuring that all of these families have a shot at being together. We need to pass this bill, whether it's a standalone bill or whether we can roll it into a larger piece of legislation. My team and I are going to pursue every possible avenue to ensuring that our families are finally reunited. I want to now introduce, we have so many incredible advocates and great champions and leaders of this movement, and you're only going to hear from a handful of them today, but I'm eager for you to hear their stories. I'd like to now turn it over to Kaylee Pliego, who is the treasurer for American Families United. I hope I didn't butcher your last name.
That's okay. No, you did good. Hello. I'm here today to speak actually on behalf of our president who couldn't be here, Ashley. So I'm going to read her words. Forgive me for looking down. Ashley wrote, "Good afternoon." She imagined she'd be here. "I'm honored to stand before you today as the president of American Families United, an organization that fights for the rights of American families across our nation. I would like everyone to take a minute and think, what does family mean to me? To me, to Ashley, family is everything. It's the cornerstone of our society, the bedrock of our communities, and the source of our strength. When we talk about family, though, we're not just talking about blood relatives. We also talk about the people who are there for us, who love us unconditionally, and who we can always count on. The family we choose, which is our spouses. Unfortunately, too many marriages are being torn apart by our broken immigration laws. For almost 30 years, spouses of U.S. citizens who are deemed inadmissible under immigration law have been separated from their loved ones, sometimes for years or even permanently. These people are not criminals. Our spouses are not criminals. They are folks with administrative infractions that carry life sentences. The American Families United Act would provide relief to those families who currently have no path forward, allowing them to reunite with their loved ones and to live, work, and contribute to our society without the fear of deportation. This is not just a matter of bureaucracy. It's a matter of human dignity, compassion, and justice. I would like to take a moment to recognize that the American Families United Act is unique in its bipartisanship. This bill has garnered support from both sides of the aisle, which is a testament to the fact that family is a universal value that transcends political differences. We are grateful for the support of Congresswoman Veronica Escobar, who has been a tireless advocate for this bill and a champion for families across the nation. We would also like to thank Congresswoman Maria Salazar for joining us in the fight and standing up for the rights of U.S. citizens to be with their loved ones. It is heartening to see that our leaders are willing to put aside their differences and work together to make sure that families are not torn apart by our immigration system any longer. What lengths would you go to keep your family together and safe from harm? This is a question that so many of us here today ask ourselves each day. Would you be willing to leave your country, your home, your family of origin, everything you know behind, just to be with your spouse and your children? Would you be willing to leave and live in constant fear of deportation, uncertainty, and isolation? These are choices no American should have to make, but too many are forced to make every day. These are the reasons why we will never give up. We will work tirelessly and speak to every legislator who will listen until we pass the American Families United Act, because the stakes are too high for us. The stakes are too high for our families, and because our families are worth fighting for. So I urge you to stand with us, fight with us, and to get this bill passed so not one more family has to say goodbye. Thank you.
Thank you so much. Thank you so much. Before I introduce our next speaker, something that I want to share with you all about the bill is when an American citizen marries someone without documents, past legislation has placed a permanent bar on the spouse if at any point that spouse entered into the country without documents. A permanent bar. That means even immigration judges have not been allowed the discretion to make their own judgment on a case-by-case basis. What this legislation does is it restores judicial discretion. Basically, it doesn't guarantee that a spouse will have a pathway to citizenship It only restores the discretion to immigration judges so that they can judge each case individually. Because what if, for example, that spouse, when he or she was a child, came through a port of entry and said he or she was an American citizen as a child? Then that individual is barred for life from ever having a pathway, even if married to an American citizen. So in cases like that, or other cases that have been shown to be unjust or unfair, why shouldn't judges have the ability to use their discretion, hear all the facts, and make a decision? That is all that this bill does. And to hear from yet another family member who is impacted, I'd like to introduce Amanda Valencia.
Thank you. My name's Amanda Valencia. I am a U.S. citizen and I'm married to a foreign national. We have 2 children together, Ariana, who is 8, and Emmanuel, who's 4. Due to immigration issues, my husband has been living in Mexico since 2021. We lived in Lansing, Michigan for the last 10 years prior to his visa denial. He had a great job. He was constantly doing community service projects for the city. We went through the whole immigration process and he was denied his visa in Mexico, which means he can't return for 10 years. And no, that doesn't necessarily mean he's a criminal. Recently, he had to actually have brain surgery in Mexico. So we've been dealing with a lot of health issues and now have to pay Mexico health stuff down there. And we actually had to stay down there for 2 months to help him with his recovery. And I had to miss work and my daughter had to miss school, which is why she's not here, because she missed too much. And now I have to pay bills over there instead of here, even though he has a US health insurance. We are already struggling between constantly visiting him and now with this medical issues off of just my income. So we're just asking people to help advocate for our families like mine to be reunited. Thank you.
Thank you so much. I appreciate it, Amanda. And then to close us out, we're going to hear from Jason Rochester.
Hi, everybody. My name is Jason Rochester. This is my son, Ashton.
Hello.
So our family has been separated for over 5 years now. And Ashton has been away from his mom over half of his life. He only gets to see her like once a year when he goes down for the summer. And I try to when he gets to see her for the summer. During all these years, Ashton has had to endure cancer, surgery, chemotherapy, radiation, all without his mom. He has to miss birthdays, Christmas, all other holidays are spent virtual, which is not even a life, really, when it comes to a child. The AFU Act, American Families United Act, when passed, will allow an opportunity for my family and other mixed status families to be reunited. We need support from Congress and Senate to pass the bill. We need support from everyone, not just Congress and Senate, but citizens that stand behind us. I am a proud member of the Teamsters, and I appreciate their support. They're behind me, and I've been very grateful to have them supporting us. And I just ask that everybody get behind us and pass this bill, because it's the only thing that I know that's going to bring Ashton's mommy home. And I don't want him to grow up the rest of his life without having his mom in his life, or having to go to Mexico just to see her and spend another holiday without her, another birthday without her. So please pass this bill, and I appreciate it to the Congresswoman and all the Congress people that are getting behind us. Thank you.
there are countless American families all over the country who have to live apart because of draconian measures in previous immigration bills. Again, this bill, I believe, upholds our values as a nation. There is absolutely nothing good to come from separating families in our nation just because they are mixed status families. And in fact, reuniting these families absolutely upholds our values as a country that recognizes the power and the beauty of a family. So it is my hope that as we chart a path forward, that we can get more Republican colleagues who will come on board and will recognize that what they are doing by signing on to this bill is supporting American families who just want a shot before a judge to plead their case and be reunited. So thank you all so much. Appreciate it. I really would encourage any members of the media to please talk to our families. It's important that our country
You love the ups. Can you handle the downs? Daily 2x leveraged ETFs from Direction. Before investing, carefully consider a fund's objectives, risk, charges, and expenses contained in the prospectus at direction.com. Read carefully.
That are driving mass displacement and fueling instability and a sustained global trend of democratic backsliding. We need to be proactive and use every tool at our disposal to get ahead of these challenges. Your task is daunting, and my message to my colleagues is simple. We can't do more with less. We must increase our investments in our diplomatic and development tools if we want to strengthen our national security. That's why I'm encouraged by the FY24 budget request for the State Department, USAID, and related agencies. It is an ambitious request, but the challenges of our time demand no less. We look forward to discussing the details with you, including your highest priorities, as we consider how best to support the department's critically important people, programs, and operations. Thank you, Mr. Secretary. Senator Graham.
Thank you, Mr. Chairman. I want to also welcome Senator Collins and Senator Murray. They've done a good job of getting the committee back in business. We're going to do markups. We're having hearings. We're going to do markups. We're going to become appropriators again, and that is welcome news to me. As to the budget request, it is ambitious. We got to deal with the House eventually. 11% increase. I don't think the market will bear that, but we'll do the best we can. I consider this account to be national security in another form. Soft power to me is just as important as hard power, and many times even more important. We're dealing with real threats out there. Countering China is one of them. A $13.1 billion mandatory spending request in his budget is not going to fly. We need to appropriate money directly for China, but it will not be in a mandatory spending construct like it's been created. But I want to work with you, Mr. Chairman, and the department of coming up with some funds to counter China throughout the world, particularly in their backyard. Bottom line is we will get it done. We always do. I enjoy working with you. Taiwan, there's nothing in the budget specifically for Taiwan. Senator Menendez and I and many others have tried to create a $2 million allocation for Taiwan's defense needs. And I think we need to actually put money directed for Taiwan's defense needs in this markup when that time comes. But Ms. Secretary, I want to say this to you and yours. You serve in very dangerous places without a lot of military support at times. The military gets a lot of credit and they deserve it, but our men and women in the State Department, they're heroes in their own way, and I appreciate what they do for our country.
Thank you, Ranking Member Graham. It's my understanding the chair and vice chair did not want to make opening statements.
I do have one, but I can wait.
Are you okay with waiting for the secretary? Mr. Secretary, if you would please proceed.
Thank you very, very much. Chairman Coons, Ranking Member Graham, very good to be with you. Chair Murray, Vice Chair Collins, to all the committee members here today. Thank you for this opportunity to speak with you about our proposed FY24 budget for the State Department and USAID. And I think as you've both laid out in different ways, we are meeting at an inflection point. The post-Cold War era is over, and there is an intense competition underway to shape, to determine what comes next. We, the United States, have a positive vision for the future, a world that is free, that is secure, that is open, that is prosperous. And it's our belief that the budget that we put forward will help advance that vision and deliver on issues that actually matter to the American people, particularly by preparing us to effectively meet two broad sets of challenges. The first is the challenge posed by our strategic competitors, the immediate acute threat posed by Russia's autocracy and aggression, most destructively, of course, through its brutal aggression against Ukraine, and the long-term challenge from the People's Republic of China. The second set of challenges is really posed by shared global tests, including the climate crisis, migration, food and energy insecurity, pandemics, all of which directly impact the lives and livelihoods of Americans and people around the world. With this committee's leadership and support, including through the FY23 Omnibus, the United States is in a stronger geopolitical position than we were 2 years ago. Hence, our ability to deal with these challenges, I think, has been enhanced. We have drawn enormous power from investments that we've made in our own economic strength and technological edge at home, including through the Infrastructure and Jobs Act, the CHIPS and Science Act, the Inflation Reduction Act. The unmatched network of alliances and partnerships has never been stronger. In fact, we've been building on it, not only strengthening existing alliances and partnerships, but building new coalitions of countries and other institutions that are fit for purpose. We're expanding our presence in critical regions like the Indo-Pacific. We're leading the unprecedented coalitions to confront aggression and address humanitarian challenges around the world. The 24 budget request for the State Department and USAID meets this moment head on. This budget will sustain our security, economic, energy, and humanitarian support for Ukraine to ensure that President Putin's war remains a strategic failure. It will strengthen our efforts to outcompete the PRC. President Biden is firmly committed to advancing a free and open Indo-Pacific, which is why this proposal asks for an 18% increase in our budget for that region over FY23. The budget contains both discretionary and mandatory proposals, and we're happy to talk about why we proceeded this way, for new innovative investments to outcompete China, including by enhancing our presence in the region and ensuring that what we and our fellow democracies are able to offer, including maritime security, disease surveillance, clean energy infrastructure, digital technology, is more attractive than any alternative. The budget will help us push back on advancing authoritarianism and democratic backsliding by strengthening democracies around the world, including through supporting independent media, countering corruption, defending free and fair elections. And it will allow us to pay our contributions to international organizations because we need to be at the table wherever and whenever new international rules that affect the livelihoods of our people are being debated and being decided. The budget will allow us to continue leading the world to addressing these global challenges, from food and energy insecurity to climate and health crises. And just on that last point, as you all know, we're celebrating now the 20th anniversary of PEPFAR, which I think is one of the greatest achievements in our foreign policy over the last decades. It's helped us save 25 million lives around the world. This budget will help us continue the fight against HIV/AIDS while advancing health security more broadly through a new Bureau of Global Health Security and Diplomacy, which I look forward to working with Congress to establish this year. The budget will advance our efforts to modernize the State Department, including by expanding our training float, updating our technology, carrying out diversity, equity, inclusion, and accessibility initiatives, including to make our overseas missions more accessible. I'm grateful for the progress we've already made together, including Congress's support in updating the Secure Embassy Construction and Counterterrorism Act and Accountability Review Board to give us some of the flexibility that we need to open new missions and better manage the risks that we face. We know there's more to do, and we're looking forward to working with Congress to accelerate these modernization efforts so that the department can better attract, better retain, and support a first-rate workforce as they advance our interests in what is a very complex and fast-moving world. Finally, the budget will further a personal priority for me, and I know for many of you, and that is supporting Enduring Welcome, our whole-of-government effort to resettle our Afghan allies. Keeping our promises to those who served alongside the U.S. remains an unwavering priority. This budget will help us continue to make good on that commitment. When I took on this role, I committed to doing my part to try to restore Congress's place as an equal partner in our foreign policy making. I'm determined to continue to do that and very much appreciate the work that we've been able to do with this committee over the last couple of years and look forward to the work ahead. And with that, I welcome any questions. Thank you.
Thank you, Mr. Secretary, for that brief but a broad review of the challenges we face and the leadership that you've shown at the helm of the State Department. Let me open with a question, if I could, about the workforce. I've had the opportunity to visit State Department employees around the world in lots of difficult and dangerous places. And like I believe all my colleagues, I'm uniformly impressed with their skills and their determination. If we're going to achieve our national security objectives, it's critical to ensure our diplomatic corps is putting the right people with the right tools and the right resources and training in the right places to carry out their work. We worked together, Senator Graham and I, to ensure that last year's bill delivered on that goal, but there is more to be done. What are the most critical workforce and other investments needed to strengthen the department to meet the challenges confronting us today and to have the flexibility to meet emerging challenges in the year ahead?
We very much appreciate that question, Mr. Chairman. And really, it does come down to us, to people, to resources, and in some cases to some authorities. What you'll see in the budget is a proposed hiring increase for another 500 new employees to fill some of the staffing gaps that we have, and that I can go into more detail on. We need more people to address some of these emerging priorities and emergencies. That includes, for example, a couple of hundred new consular positions. I know you're all seized with some of the challenges that Consular Affairs has experienced over the last few years because of COVID. We have been building back in a very significant way, but we need more work there and we need more resources there. So the budget proposes that. We need an additional number of civil and foreign service employees to scale up the Indo-Pacific strategy and to outcompete China, to strengthen our outreach, to fully staff, for example, new missions in the Pacific Islands, something else that we can talk about. We want to make sure that we are building on something that's been a terrific innovation that's been supported by this committee, and that is having additional positions so that we can increase our float, which enables us to pull people out of their day in, day out and allow them to have career-long training so that they can keep their skill set fresh, in fact, get new skills as they go along, for example, by coming here to spend time, by going to an academic institution, et cetera. We're requesting, in addition, new management hires. This is critical because where the rubber meets the road in the department, as in so many other institutions, is particularly our mid-level management. And we have terrific management people in the department, but what you know and what you'll see is that people who don't actually come up through the management silo in the department are nonetheless called upon at different stages in their career to exert management skills. We need more there. We have money there to make sure that we're protecting our missions and our diplomats, and I commend that to you. We have to keep pace with increased security threats and costs, the growing overseas presence, as I said, in the Pacific Islands. We hope to reopen the mission in Libya, something we want to work with you on. That's going to require some funding as well. We have significant funds as well to make sure that we are up to speed on cybersecurity. We have all been challenged across government by this, and we have to make sure that we have the funding to do that. There are a number of authorities as well, Mr. Chairman, that we can get into, and I'm also happy to share with you that would be very helpful. It would be very useful to us to have a new funding account for the Enduring Welcome operation to consolidate up to about $2.5 billion in existing funding for relocating our Afghan partners. There is some personal services contractor authority we need to hire more domestic personal services contractors. We can get to that. Some special immigrant visa adjustments, again, to make sure that we're making good on our commitments to our Afghan allies. And then I would just cite one last thing. There's more to be said, but you touched on this. I think it's very important for us to be able to pay our multilateral commitments. And this is not a gift to these institutions. It's not saying that these institutions are perfect or don't need a lot of work. It is saying that when we're not at the table, then usually someone else is, and probably not in a way that advances our interests and values. And particularly in institutions that are actually having a real impact on, in windowless rooms that people don't see, in shaping a lot of rules and a lot of norms and a lot of standards. For example, the way technology is being used, we need to be there. And part of being there sometimes is paying our dues. The other thing that happens in these institutions, we are the largest actually contributor to the UN system. And yet when we're in arrears, our competitors and adversaries point to that and say, the United States isn't serious about it. So I hope we can do the best possible on that. I very much believe we should be back in UNESCO. Again, not as a gift to UNESCO, but because things that are happening at UNESCO actually matter. We're not there. We're not shaping it. They are working on rules, norms, and standards for artificial intelligence. We want to be there. They are doing the same thing on education curricula around the world. China right now is the single largest contributor to UNESCO. That carries a lot of weight. We're not even at the table. It's important that we get back there. Thank you.
Thank you, Mr. Secretary, both for that answer and for your leadership across those different issues. You mentioned at the conclusion of your introductory statement, Operation Enduring Welcome. I'd just be interested in a brief update on your efforts to review and identify any lessons learned on Afghanistan so far.
Thank you very much. Yes. One of the things that was very important to me was that we conduct an after-action review of the State Department's role and execution of the withdrawal from Afghanistan. And we initiated that review. We brought in very experienced people, including one of our most senior retired diplomats to conduct it. They conducted many interviews, reviewed many documents, and have produced I think, important report that looks at what we did right, what we did wrong, and could do better. And other agencies, as you know, have been doing the same thing. We've now been spending time putting all of this together to make sure that we look at some of the common lessons learned, especially where there's overlaps. And I am committed and determined to make that information available to Congress. And we will do that. We will do that by mid-April. So I can tell you today, you'll have the after-action review. We will share the findings and find the appropriate mechanism to do that within the next 3 weeks.
Great. Thank you, Mr. Secretary. Your opening, you referenced your commitment to including consulting with Congress and including us in the foreign policy making process. And this is a good example of that work. I have long questions I look forward to asking about the Development Finance Corporation, the Global Fragility Act, but I'll just ask one and then turn to my ranking member. We're in the middle of a global food crisis. According to the World Food Program, pre-pandemic, there were 135 million people in more than 50 countries who were facing hunger. That has gone up to 345 million people across more than 80 countries today. It's fueled by conflict, climate change, COVID-19, and as the war in Ukraine grinds on, shocks in terms of prices of food and fertilizer are driving millions to the edge of starvation and increasing instability. What's the department doing to increase contributions from other donors to help tackle this challenge? And what should the international community be doing differently in order to improve the resiliency of communities facing food insecurity for the long term?
Thank you, Mr. Chairman. I've got to say, I very much appreciate the leadership of this committee, particularly you, Senator Graham, on this issue, and others. I'd say quickly two things. First of all, we have to tackle two aspects of this problem. We have emergency situations that demand an emergency response, where people need food now. And back in May, we gathered together countries from around the world at the UN Security Council to focus them, not just us, on the specific things that they can do and we can do to make sure, to the best of our ability, that food is getting to people when they need it. And of course, as you know very well, we've had an almost perfect storm that's built up between climate change, between COVID, and of course conflict, and now exacerbated dramatically by Russia's aggression against Ukraine. Ukraine, breadbasket to the world. That grain was taken off the market by the Russian aggression. I'm very glad that through the work of the United Nations and Turkey, we were able to get the Black Sea corridor going, but that's a fragile thing. It's made a difference, but it's fragile. So there's the emergency assistance. We've significantly increased our own contributions. As you know, we provided about $13.5 billion going back to the Russian aggression over the course of 2022. We've gotten other countries to step up and increase their contributions. World Food Program, Food and Agricultural Organization, the UN Fund. That's one critical piece of it. But again, as I know you know very well, the other piece that's critical, and what I hear, and I know you hear from our colleagues around the world, especially in Africa, is that as focused as they are on emergency assistance, what they really want is investment in their productive capacity. And this is absolutely critical to making sure that they have sustainable agricultural production and that they ultimately can feed their own people and actually feed others. There is tremendous potential in Africa. Let me just cite one thing that we're doing, and we have in the budget a significant fund for this. To me, one of the most exciting things, building on and adding to the Feed the Future program that AID and the State Department run, is something that we have, I think you know, one of the leading agronomists in the world at the State Department, Dr. Carrie Fowler. One of the things that we've learned in recent years is that the two most determinative things to having sustainable food production capacity comes down to two things: soil and seeds. If the soil quality is bad, you can throw as much fertilizer on it as you want. It's not going to work. We now have the ability to map the quality of soil pretty much anywhere, including throughout Africa, determine where it's good, where it's bad, what needs to be done to improve it. And we have a program there. The seeds, if they're not resilient to drought, to climate, to other things, again, doesn't matter. We have the capacity to do that, to provide resilient seeds for nutritious crops. So I think what you'll see in the budget, is the beginnings of an important program to provide for that.
Thank you, Mr. Secretary. That's a topic of interest to both of us. Let me now turn to my ranking member, Senator Grimm.
Yeah, I really want to work with you. I think what you said is absolutely spot on. I talked to Larry Ellison from Oracle. He's created a new school, I think at Oxford or Cambridge, can't remember, about food security. So there are a lot of people interested in making sure people can feed themselves, and, it's soil, seed, and water. You got to have water. So anyway, look forward to working with you on that. Are you familiar with the ICC arrest warrant being that was issued against Putin?
Yes.
Do you think that's sound?
I think we've all seen, Senator, the atrocities and war crimes committed in Ukraine. We believe strongly, as we said.
I think the president said he thought that was a sound approach.
There needs to be accountability.
Yeah.
And the ICC is.
What do they want to arrest him for?
The focus of as I understand it, the focus is on in effect, abduction of children from Ukraine, taking them to Russia, giving them to.
So let's just stop for a second. He's being, there's an arrest warrant for Putin by the ICC for kidnapping children in Ukraine and taking them to Russia. Is that pretty much it, right?
Yep.
If Putin came to the United States for whatever reason, would we turn him over to the ICC?
Well, I can't get ahead of that because obviously I have to look at the laws and rules. As you know, we're not actually a party to the ICC, so I don't want to engage in that hypothetical. But
I would encourage you that if he came here, we should turn him over.
Now, I don't think he has any plans to travel here soon.
Yeah. Well, would you encourage our European allies to turn him over?
I think that anyone who is a party to the court and has obligations should fulfill their obligations.
Okay. Are you aware that the Congress, 100-0, which is pretty rare around here, supported the idea of declaring Russia a state sponsor of terrorism under U.S. law?
Yeah.
I don't know much more we can do to help you in that regard. Do you?
Could I just say on that? And I appreciate it. Look, we have, as you know, multiple designations that focus on Russia's war crimes, atrocities, et cetera. The SST brings with it also, I think, potentially some unintended consequences.
So here's my question.
Yeah.
Are you going to designate Russia a state sponsor of terrorism under U.S. law? Do you intend to do that?
What we've been doing, Senator, as you know, I think, is working with you to look at a new designation that would go to.
But we've sort of failed in that endeavor. And since we started, an arrest warrant has been issued. What more do you have to do to be a state sponsor of terrorism? China, the meeting with China and Putin, would you consider that a marriage of convenience or a strategic alliance?
Perhaps a combination of both. I think you do have a partnership. Remember, as you know, right before the Russian aggression, they met. They talked about a partnership with no limits.
So let's just break that down a bit here with no limits. The world is trying to put a cap on Russian oil, Western world. Is that correct?
That's correct.
I think China just agreed to buy oil as much as Russia can supply. They're undercutting our efforts there. Do you agree with that?
They are, although what we've seen is two things, Senator. With the oil cap, we've tried to accomplish two goals. One, reduce the revenues that Russia is getting from selling energy, but at the same time, keep enough energy on the market so that we don't have a crisis. I think we've largely accomplished that goal. Russian oil revenues are down as a result of this.
But China has made a pledge to buy all the Russian oil they can buy, right? Not at the cap price.
Well, we'll see at what price they actually buy.
Bottom line is, China's working against us. when it comes to Russia. Do you agree?
I think their diplomatic support, their political support, and to some extent material support for Russia certainly goes against our interest in bringing this war to an end in a way that is
You
just.
publicly said that you had reason to believe that China may be considering providing lethal aid to Russia. Is that correct?
That's correct.
If you provide lethal aid to a state sponsor of terrorism, that would be considered material support under U.S. law. Is that correct?
I believe that's correct.
Okay. Don't you think it would be smart to tell China you provide lethal aid to a state sponsor of terrorism? They may be more deterred than if we just remain silent about that.
Senator, I've shared directly with my Chinese counterpart the serious problem that China providing lethal material support to Russia for
Do you
Ukraine
think
will
it's
produce.
working? Do you think they'll provide aid?
As we speak today, we have not seen them cross that line.
So my point is that we made a mistake, I think, by not having pre-invasion sanctions. We should have supplied more weapons to Ukraine before the invasion to deter the war. We're a tipping point here. China is openly embracing Russia. They're undercutting everything the West is trying to do to isolate Russia. They're buying unlimited oil. I think now is the time, Mr. Secretary, to label Russia state sponsor terrorism, because they are. Up the ante if China wants to continue to help Russia. Would you at least consider that as a deterrent possibility?
We want to look at every reasonable deterrent, but again, when it comes to the SST, and we should talk about this further, I think there are better ways to get at the same thing.
Well,
but don't
whatever
have some of
those
the-
ways are, we're over a year into this thing. Let's do something. And I'm just going to tell you, as a friend, I like you. I try to work with you. I'm not going to sit on the sidelines any longer and see Russia not labeled for who they are. They're terrorists. They're wreaking havoc all over Africa. We just got back from Africa. The Wagner Group, Russia committed immense war crimes in Syria. This is just their modus operandi. They just bomb the hell out of people, terrorize people, use rape as a weapon of war. And it's now time to stand up and say, you are a terrorist state under U.S. law. And I think the sooner we do that, the better. Let's go to Mexico right quick, and I'll try to keep within my time, go over a couple of minutes. Are there places in Mexico that the government of Mexico does not have control?
I think you see significant insecurity in parts.
Well,
of
my question is, are they ungoverned? Are there
sure that
places?
there are
Yeah.
individual places, communities.
Are there drug cartels in control of parts of Mexico, not the government of
I
Mexico?
think it's fair to say yes.
Okay. Do you agree with the following statement that fentanyl coming from Mexico is killing Americans by the tens of thousands?
It is, and it's also killing Mexicans.
Yeah. Well,
tens
do
of
you
thousands.
agree it's now time to change our policy because it's not working, or do you think it is working?
I think that, Senator, first of all, you're exactly right about the insecurity in Mexico. As I said, the Mexican people themselves are the number one victims of that insecurity. The Mexican government.
Are
with
more
our support, is
Mexicans
working-
dying of fentanyl poisoning than Americans?
Currently, no, but it's a growing problem.
So how many have died in Mexico from fentanyl?
I don't have the exact numbers. I'm
Well,
sure it's less.
70,000 died last
That's-
year
that's correct.
alone in the United States. Do you believe our policies toward drug cartels and fentanyl coming from Mexico, that those policies are working?
They need to do more. They need to be more effective. Here's one way we can do that. One way we can do that is making sure that we have, for example, the technology on our borders to detect and intercept the fentanyl. 96% of the fentanyl coming to the United States is coming through legal ports of entry. We have the technology that can catch a lot of that. We need to deploy it faster. That's exactly.
How about this idea? Rather than just interdicting at the border, we go to the source and declare Mexican drug cartels foreign terrorist organizations under U.S. law. Would you consider that?
Yes, we certainly consider that.
And that would help us with China, because if you provide material support to a foreign terrorist organization, you could be prosecuted in U.S. courts.
They're also transnational criminal organizations, and that brings with it.
That's what
a
they
number
are
of sanctions.
today. I
Yeah,
wanna
and
up- I
it's
wanna
not
up-
clear to me that again, that we would get additional tools or authorities. It's worth pointing
We
out.
would
I mean,
with China, Mr. Secretary. TCOs cannot, material support doesn't bring you in U.S. courts. FTO, material support for an FTO would capture you in U.S. courts if you're a China company. So please consider that. I would say our policy is not working. I want to introduce a map. This is travel advisory map of the State Department. Tells you where to go and not to go in Mexico. The red is getting redder. And Ms. Secretary, enough with Mexico. Obrador is going to call Xi. Great. I'm not looking for a phone call from Mexico. I'm looking for action on their part. I'm willing to do a planned Colombia type effort with Mexico, but I'm gonna put the Mexican government on notice and your department. When it comes to the poisoning of America, we're going to take different action because what we're doing is
Ladies and gentlemen, it's 1:30 and we're going to get started on the judiciary. This is the House Judiciary Committee. Representative Jim Hill is actually the chair. He's got a couple of bills in another committee that he's handling, and he'll be coming in here just in a little while. I do want to remind everybody to turn their phones down, but I also wanted to thank David Kimberly, who's filling in for Ray Hawthorne in helping us today since Ray's not available. Okay, very good. We've got the agenda in front of us. We're going to take one out of order. Representative Matt Simpson has HB 1, and then he has also HB 76. We're going to take those two first. And we're going to call the roll now.
Hill, Wadsworth.
Here.
England. Here. Almond. Bedsole. Chestnut. Faulkner. Here. McClammy. Here. Pettis. Here. Robbins. Here. Simpson.
Here.
Standridge. Starnes. Here. Stringer. Here. Tillman. Here. We have a
Okay. The first bill on the agenda is HB 1 by Representative Matt Simpson. Would you explain your bill?
Absolutely. Thank you, Mr. Chairman and members of the committee. What this bill will do is add mandatory minimum sentences for those convicted of trafficking fentanyl. And I want to make sure a couple of things are clear. This is single component pure fentanyl that we are discussing. This is not the mixture. The mixture is handed in another section of this similar code, of the same code. If you'll look on page 5 of the bill, specifically lines 122 and 123, there are already punishments in places for mixtures of fentanyl and other drugs and other issues. Mixture of fentanyl and cocaine, mixed fentanyl and heroin, fentanyl and marijuana. There's already a punishment in place for fentanyl mixtures. This is for pure fentanyl. And what this will do, what this bill will do, is if you have between 1 gram and 2 grams, more than 1, but less than 2, it will be a mandatory minimum sentence of 3 calendar years. If you have between 2 and 4 grams, it'll be a mandatory minimum sentence of 10 calendar years. If you have between 4 grams and 8 grams, it'll be a mandatory minimum sentence of 25 calendar years. And if you have more than 8 grams, it's a mandatory life in prison. I have this packet here. It's a sweet and low that you would find at any diner that you guys would go to. This is 1 gram. If this 1 gram was pure fentanyl, it could kill every member of the House of Representatives 5 times over. A lethal dose of fentanyl is 2 milligrams. So when I'm telling you that these people, if you're carrying a gram of fentanyl, you know it's a gram of fentanyl. And that's not a gram that's for personal use. That's not something an addict would have. That's not something a user would have. To have a gram of pure single component fentanyl, that's what a trafficker would have. So that's why that's why this punishment is there. We're not going after the users. We're not going after the addicts. We're going after the traffickers and the people that are bringing it in our community. And with that, Mr. Chairman, I'd ask for a favorable passage.
Do we have any questions? Representative England.
You know, it wouldn't be right if we didn't start off the session with an argument.
Let's do it.
No, actually, no, I want to take advantage of this very limited opportunity that I have to say that we agree.
Y'all have that on camera, right?
Yeah. And, you know, concerning fentanyl and its derivatives, and how dangerous the drug itself is. I think we're all trying to be as careful as possible to make sure that this addresses the specific community that or the specific people that we're trying to get at. And, and I think we can acknowledge that in the past, sometimes we have used sledgehammers on ants and have actually created legislation that has actually gotten users instead of the people that we're targeting. And I think with the way you approached this legislation and how you did it, and also, I mean, it's from where it started to where it is now, I think this is a good bill to accomplish the objective. And also, we also want to focus on treatment, right? I mean, I think that's the point when we're talking about somebody who's addicted to drugs, who needs help, right? But as you pointed out, this isn't that. This isn't those folks. And I know we're also talking about prison space and so forth, and using the resources that we have effectively. But there are some people, especially those who carry this, who are intentionally using it to put in other drugs, that just need to be incarcerated. They need to be removed from the game altogether. And I think this accomplishes that. So it's a good bill, and I support it.
Chairman Hill is not going to know how to respond to that.
I don't either. I feel like I'm having an out-of-body experience right now. But I hope.
Thank you, Representative England. Thank you.
I hope this spirit of camaraderie and goodwill continues on throughout the day.
Representative Faulkner.
I can barely speak with what I've just witnessed by Representative England. And so I would like to move to give this bill a favorable report and have him second it.
Gladly. Second.
We got a motion to give the bill a favorable report. All in favor say aye.
Aye.
All opposed. Bill gets a favorable report. And we're going to take out of order HB 76, and I think it does have an amendment by Representative Simpson.
Yes.
Can you explain that bill, please?
Absolutely. This bill came out of a quadruple homicide in Daphne. What happened was an individual got into an argument with his grandparents. He had lived with them. He went to their home and tried to kick in the door, caused some property damage. The grandparents called the police. He was arrested. The only charge that they could charge him with was criminal mischief because he damaged the property or the door. He was arrested. There's no hold. There's no contact. There's no restraining order. He bonded out immediately, went back to that home, killed his two grandparents and two other individuals that were in the home as well. What came to me that day, I've talked to prosecutors that were involved in the case. I've talked with the law enforcement that were involved in the case. There was nothing that they could do. There was they can't put the hold or no contact or anything without domestic violence. Unfortunately, we live in a situation now in a society where so many grandparents are now the primary caregivers of the children. And there are protections in the domestic violence laws for parents, for step parents, for spouses, child, stepchild, or any person who the defendant has a child in common, a present household member, or who they had a dating relationship. What this bill would do, and the intent of this bill, was to add grandparents to that relationship. Now, there is an amendment that was created from the District Attorneys Association, and on the language of the bill, we wanted to include grandparents into domestic violence as qualifying under domestic violence. The original bill did not have them in place with the domestic violence strangulation, which it should be. We want to have just a uniform domestic violence all through. Also, we're adding step grandparents, and we felt that it was important to add children or grandchildren and step grandchildren, because if the perpetrator in this case was a grandfather or grandmother acting domestic violence on a child, we wanted to have those enhancements as well, that we could pursue that charge under those. So that's the amendment. The bill itself is just literally, it's one word where it adds grandparent to domestic violence. The amendment comes through where it just adds grandparent, step grandparent, grandchild, and step grandchild to make it uniform domestic violence laws throughout the statute.
Do we have any questions on the amendment? If not, all in favor of giving the amendment a favorable? Do we have a motion? Do you have a second? Okay. All in favor of the amendment, say aye.
Aye.
Opposed? Now, do we have any questions on the bill itself with it as amended?
Mr. Chairman, this, what we have in front of us already has the amendment?
The amendment should be included in your packet.
Oh. Thank you.
Do we have a motion to give the bill a favorable report as amended? Secretary Stringer? Okay. Do I have a second? Ms. Robbins, Representative Robbins, all in favor of giving the bill a favorable report as amended, say aye.
Aye.
All opposed? The ayes have it.
Thank you, Mr. Chair and members of the committee.
We have HB 82 by Representative Pringle.
Thank you, Mr. Chairman, ladies and gentlemen of the committee. This is a bill that this committee has passed out at least twice, if not three times. It's identical. For the people that are new to the committee, a friend of mine's son got addicted to oxycodone and after surgery, and his family literally mortgaged their house and sent him to rehab and got him clean. His drug dealer would start hanging out in front of the narcotyne meetings he was going to and trying to get him to take drugs. And it was so bad, he kept calling the kid. He actually changed his phone number. The drug dealer went to his parents' house and knocked on the door and told his mother and said, "Listen, I'm trying to buy this piece of real estate from your son. He showed me about 8 months ago. I've got the money, but I can't get him on the phone." And the mother, thinking it was a real estate deal, gave the drug dealer his new cell phone. And he started calling my friend's child and wore him down and sold him a oxycodone laced with fentanyl, and it killed him. The only thing they could charge that man with was trafficking drugs. And what this bill says is if you sell a controlled substance that causes somebody's death, illegally sell a controlled substance that causes somebody's death, we can charge you with manslaughter. And you've already passed it 3 times, I think, out of this committee. It died in the Senate on the last day at the last minute, so I couldn't get it through last year.
Do we have any questions about the bill? Do I have a motion to give the bill a favorable report? Representative Simpson, do I have a second? Representative Faulkner, all in favor, give the bill a favorable report, say aye. Opposed? The ayes have it. The bill gets a favorable report.
Thank y'all so much.
HB 34, Representative Estes. Oh, 20, I'm sorry. HB 28, Representative England. Representative Ingram, didn't mean to slight you there. I counted 3 and you were
Trying to be nice today, man.
Yeah, you're doing good.
Trying to be,
Would you explain your bill, HB 28?
HB 28 was so as it stands right now, there are basically 3 subset of people that can carry a pistol concealed on school grounds. Someone who's been appointed to do so by the school board, which is generally an SRO, law enforcement, and according to the law, anyone who doesn't have the intent to do bodily harm has a permit and doesn't have the intent to do bodily harm on a school grounds. And what this bill would do would remove the exemption, and the only people that can carry concealed on school grounds are SROs, people who are appointed by a school board, and law enforcement. And that's it.
Do we have questions about the bill? Representative Stringer.
Just had a quick question, like how would this affect someone picking up their kid from a school line or maybe attending a sporting event where they have a weapon in the vehicle?
As far as it's like, so the way school grounds are defined, if you're carrying concealed with a permit, so if you're going through a school line, depending on where it is, as long as you've got the gun and it's not loaded in the trunk, just like it was prior to. If this law goes into effect, that's what you'd have to do.
Thank you.
Do we have Representative Sandridge?
Yeah, let me ask a question about that. Okay. I believe when we passed this, and this specific language was in there, was to address, I think, what Representative Stringer was mentioning. I mean, you have people that come to school that obviously carry their firearms in their vehicles, just as a matter of personal protection. And they have a permit based on that law. And so I think that's what that exception was really intended for, because you already have things in place on school building that would prohibit that anyway, correct?
No. School policy does, but that's for students. So someone carries a pistol or a firearm on school grounds, it's technically not illegal. So before, if you approach someone with an issue with a firearm on school grounds, you can't take the pistol, you can't do anything to subdue them. What you'd have to do is get them trespassed and send them off. A lot of people believe that, mistakenly, that federal law controls on school grounds, but it doesn't. We passed laws that preempt federal law on school grounds. So we have, like I said, when you get a permit, as long as you don't have any intent to do bodily harm, you can carry on campus. And for me, schools need to be treated like courthouses, for example, because you can't have a concealed pistol on courthouse grounds. And it's always never made sense to me that we identify particular locations where we don't want you to be able to carry concealed at all, but where our kids are, it's okay. And also, there are places in the state of Alabama where you can get a pistol permit when you're 18. So that technically means that an 18-year-old or a 19-year-old with a pistol permit can carry concealed on school grounds. So, for whatever reason, to be honest with you, as long as you're not a student at the school. So essentially what I'm trying to do is, since the state of Alabama has recognized that there are certain locations where it's not a good idea to have a concealed firearm, just want to add school to those.
So there's not an exception in the federal law, you're saying, for the school building?
No. And again, that's one of those things that people believe, but it's not exactly true. So with regard to—
That was my belief that it is.
Well, because I'll read it to you. With regard to an issue of a pistol permit, the Gun Free Safety Act allows an individual to possess a firearm when the individual is licensed to do so by the state in which the school zone is located, and the state's firearm permitting requirements require the permit issuing authority to verify that any individual issued a license is qualified by federal law to receive the license. That's our permit. So federal law doesn't control on school grounds because we have preempted them there by passing our own laws.
Okay, but your bill here is for all property of the school, not just the building, right?
School. I think we follow the school zone includes the zone, the grounds of a school, public or private, in the area within 1,000 feet of the school grounds.
So it would basically be the whole campus, right?
Depending on how big it is, yeah.
Okay. Thank you.
Representative Simpson.
Under this bill, and under current law without this bill, if an 18-year-old is on campus with a weapon, somebody on campus, it's tough to prove that they have intent to harm someone until after they've actually harmed someone.
That's when we figure it out after they've done something.
So let's just continue this hypothetical to be 18-year-old on campus, gun either out or holstered, either one, and they're just walking around on campus with a gun. Is there anything an officer can do to that 18-year-old?
Trespass.
No matter how many students are nearby, no matter how many kids are close by, no matter where
As
they
long as that 18-year-old's not a student at the school, trespass them. Which means that in order to neutralize that threat, it's just like you and your private property, for example. Without notice of a trespass beforehand, you have to first identify that person, trespass them, and then tell them to leave. The only time you could arrest that individual for trespass is if they're first trespassed. So then they can come back, and that's when they become arrestable, although I do think you have to do that in the presence of law enforcement anyway. So it makes it very difficult for somebody who's in charge of that property to neutralize a threat because they've got to contact that person multiple times before they could be arrested. So again, and like you said, I think you've identified it perfectly. We oftentimes don't know that a person is a threat or has intent to cause harm until after it's done. So for me, and that's why I introduced legislation, in order to sort of eliminate that problem, limit concealed possession on campuses to just law enforcement and SROs.
Representative Faulkner.
Don't we have a alcohol law that for any school and on school property that you cannot take alcohol on school property?
I'm not aware of that.
Anybody help me out here? I thought you could not take, any alcohol on school property. And maybe it's just a city deal, but the schools I represent, it's my understanding you cannot have alcohol on the premises. And that's, if it seems to me, if we're not going to allow you to carry alcohol on a school property, I don't know why we'd let somebody because you've got a lot of exceptions in here too, that cover things for valid reasons.
Yeah.
But I'm not sure why we wouldn't allow alcohol, but we'll allow a loaded firearm. But perhaps that's a city ordinance, Chris. If you're not familiar with
it,
nobody else is either.
I don't want to speculate, but
yeah.
Representative Bedso.
Yes, sir. Thank you. So Representative England, I think it's fair to say that, I think everyone here, the notion of keeping our kids safe is something, and that's a very real topic in our world today. So it's a tough and complex topic to dig into as far as when we're trying to balance out that element of safety for our children. And also, I think that the Second Amendment rights of our citizens. And so knowing that every school campus is set up a little bit different, I have a couple in my immediate area that just come to mind that something like this would give me a little bit of pause, because so some campuses are set up that once you drive onto that campus, you are exclusively there for the purpose of visiting the school grounds. There is a one-way in and maybe a second exit out, but you are going to that school property. One specific school in my area, and I can think of another, has designed this parkway in which that the citizens of our city are able to use the parkway that traverses through the school property, but it's a means to get from one area to the other. Mm-hmm. So I just think of it in terms of the wording in which that we're dealing with in the bill, and that perhaps there's a citizen innocently driving from point A to point B using the parkway that's open for the citizens that has a concealed weapon. There may be even a permit holder with no intent to stop there in the school grounds, but simply using the parkway. So it does raise a little concern with me, knowing that if I'm traversing through there and I'm not a law enforcement officer and happen to get stopped on a traffic stop, mm-hmm. would I then be in violation of this law simply because I was passing through? And so I think the wording of this and the thought of how we deal with this individually or corporately to all school properties is something that we have to give some thought of. And so that's just my 2 cents on it. And I feel strange giving you advice because you're so good with words, and but I'm thinking of a specific scenario that's literally in my backyard. And so I'm just got a little bit of concern there if I'm just communicating, being honest with you about that.
That's fair. It is. And, ultimately, completely open to discussing if there's a better way to define what we're talking about. But again, just the overall concern is that when we talk about school grounds, obviously it's outside, it's inside, it's somebody who's carrying a pistol concealed. And, you know, in order to neutralize threats on campus, when somebody who can legally possess, it becomes more and more difficult to assess that threat and then neutralize it because you've got more barriers to go through.
Right.
Whereas if somebody is possessing a gun in a courthouse, it doesn't really matter what the mind state is. You immediately see it, you seize it, and they're arrested. So again, and for me, if Alabama as a state recognizes that there are places that we should not have firearms at all, I don't know why schools aren't considered part of that list. So if as this process works, as it normally does, if there's any ideas you have, like you want to kind of massage the definitions a little bit and figure out like, well, because we don't want to say that anybody that doesn't have ill intent can carry a pistol on as long as you got a permit. You know, that could be anybody. And again, from law enforcement, you oftentimes don't find out who the bad guys are until it's too late.
Right.
So, and again, this to me, prohibiting possession, concealed possession, it cuts down the response time law enforcement has, because if you got a pistol concealed, I can go ahead, neutralize that threat and get you off of campus. I don't have to ask you politely.
Yeah.
I don't have to make any assumptions. Just give me the gun and we'll figure this out. And, being that we've got a lot of issues, we locally in my county, we had a 17-year-old with a gun at school. It just makes it easier for us to keep our kids safe if we can limit who possesses them. But at the same time, I do understand that those who are just traveling through
Yes, sir.
may have an issue. So it's definitely worth a conversation for sure.
Thank you.
Representative England, a couple of the concerns that I have deal with the fact that you have all these folks that are in line to pick up their children.
Mhm.
And by them driving through the campus to pick up their children, they're actually committing a Class C felony driving through. That's one of the,
They're not you're not committing a Class C felony. Again, the mere possession, first and foremost, if you're not doing anything you're not supposed to do, obviously we don't have this problem. But at the same time, I have witnessed, and I got school board members and things that have witnessed issues that develop in that as you're dropping your kids off and pick them up, where you got problems with principals, you got problems with teachers, other parents, or whatever, where our kids are around. Again, it's just, maybe it's just me, but I would prefer that we just limit possession on campus to individuals, law enforcement, and those who have been appointed by the school board to have those weapons for protection purposes. Now,
I'll say this, my second concern is in Alabama, we have what you call school indemnity property. We have 16th section property that's owned by the various boards of education. In Walker County, there's 8,000 acres of land that's owned by other boards of education in Walker County. And because of the definition of that's out here, I'm concerned that if you just go on that property, then you potentially could be committing a Class C felony. And for example, around the I-13 interchange, there's about 350 acres that's owned by the Franklin County Board of Education that is inside Walker County. Well, if you walk on that property and somebody goes on that property, say for hunting for some reason, then they could be charged with a felony. That's the concerns I have. I don't think the definition has been narrowed down enough on what's school property at this point. Representative Pettis.
I guess go to my concerns. I'm retired law enforcement. As long as I qualify, I can take a gun anywhere in the United States except in a school in Alabama.
That's not true.
I'm not a law enforcement. I'm retired.
We
I don't
have,
fall under the law enforcement.
specifically, there's a code section, it's in Title 16, that allows for retired officers who are appointed as SROs and also those who are commissioned as law enforcement to carry on school grounds. It doesn't apply to law enforcement in the same way that it applies with somebody that doesn't have or doesn't have the intent at the moment when they're possessing it. So it's different.
But if I go through this, well, the way I read it, it says if you don't have a permit and you have to be a law enforcement or an SRO. I'm not law enforcement anymore. I'm retired. I have to go qualify to be able to carry it anywhere in the country. The state recognized me as carrying it, but I'm not considered a law enforcement officer. I'm retired, but I'm still not law enforcement. If I go up there to deliver a check that I do now, if I have my pistol on, I could be charged with this, the way I read it.
I'm not exactly, I don't think that's exactly accurate, but we can talk about it. I mean, because there's a specific code section that creates exceptions for retired law enforcement and our SROs too. Those that are appointed by the school board for those purposes. But it's a legitimate question and we can figure that out.
Okay.
Representative Faulkner.
Yeah, Representative England, I first want to say that I like what your intent is, and I agree with you that this exception based on intent is I don't think that's good. Because we do, as Representative Simpson said, we don't know intent. And so I don't like that language. I think this needs to be changed. But I would, based on the concerns I'm hearing from the other members, I would like to say let's put this bill in the criminal or civil subcommittee and work on tightening up the language to meet the concerns that have been expressed. Because I think, I certainly think there's a lot of us that like what you're trying to do here, but just want to make sure we don't have unintended consequences that has been referred to. So that would be my request as we put it in, not to die, but we put this into a subcommittee.
Before we get to that, I take that's going to be a motion.
Yes.
Before we get to that point, I'm going to recognize Representative Simpson.
I just wanted to bring to the attention of the chair that Representative Faulkner is the chair of the civil subcommittee, and I think that would be great.
Okay.
This does involve a criminal statute.
Well, we have a motion before us to send the bill to the criminal subcommittee. Do I have a second? Second. All in favor of sending the bill to criminal subcommittee, say aye. All opposed? The bill goes to the criminal subcommittee. Representative Jim Hill, Judge Hill, is entered the room, and
I was sincerely hopeful that y'all would be through by now. Had to take something up in another committee. I'm disappointed. I felt like I'd walk in here and have you adjourn, but apparently not so.
That's correct. And so I turned it over to Chairman Hill.
Okay. What's our next one? House Bill 34, Representative Estes, come on up. Please. That'll help me.
Thank you, Mr. Chairman and committee members. I'll go ahead and warn you, I've never spoken before this committee before, so I'm not near as eloquent as my colleague, Representative England, and how beautifully worded some of his comments typically are. And I don't deal with the Second Amendment on this bill, so maybe that'll simplify things for you as well. It was just drawn to my attention a few months back that I think we have a small loophole in some existing state code that I would like to see us close. I know most of you have had a chance to read the bill, so I'm not going to bore you with going through every nook and cranny of it. Currently, as you know, it is a felony to discharge a firearm either into an occupied or unoccupied school bus or an occupied or unoccupied school building. There are some municipal codes that address this, I've been told it by LSA, but we don't have anything at the state level that addresses the discharging of a firearm on school campus, period. You could discharge a firearm on school campus and it not meet the criteria that I mentioned earlier about an empty building or an empty school bus or a school bus filled with children or a school building filled with children. So that's what this would do, would bring that under that classification to it would be a felony to discharge on campus.
All right, any questions? Yes, sir, Representative Wadsworth, please.
Representative Estes, one of the concerns I have is that it has the same, basically the same definition as that previous bill. Unless I'm missing something, it just says school property. That could be 16 section property.
Yes,
It
sir.
could be school indemnity property, and it could be the school ground where, and I don't think I personally don't think the definition is tightened up enough to know what that would be. And,
Well, I would certainly be open to an amendment to, because I was listening in the previous bill as it was being addressed and thought that you might have the same question. So I'm certainly open and would accept that as a friendly amendment.
at the appropriate time, I'd move to send this to the criminal subcommittee also, for the purpose of, further defining the term school property.
Yes, sir.
All right, hang on. We're going to take a few more questions. Mr. England?
You're talking about shooting on a school property.
Discharging a firearm.
So like pulling the trigger and a shooting on school property. What difference would it make where that came from? I mean, I understand some of the debate about possession, but firing a pistol on school grounds, I'm struggling to figure out, what difference would it make where that came from?
Well,
it's shooting a gun, and I'm not talking about some official event or some sanctioned event on school
because
grounds.
those exemptions are, as you know, built in.
Yeah, they're already there.
Yes.
So what we're essentially implying is, like, if you're 2 feet away from, or if you're 1,500 feet away from a school grounds, right, and you shoot that gun into a car, that's a capital offense. So I'm trying to figure out why you would need a definition in this bill about what constitutes school grounds if you don't have any protected exemption that allows for you to fire that weapon. I'm trying to figure out, because I'm pretty sure if you're firing a weapon on school grounds, you're probably trying to do something. So I'm trying to figure out what difference would it make if it's 1,000 feet or if it's, or if we're defining it, because if you're shooting at somebody or you're shooting it for any reason, it's probably not going to be the best reason if you're near a school.
Let me make sure I understand your question. Are you asking like if you were on the street or property across the street from a school and you discharged a firearm? That's not what I'm talking about. Is actually you're standing on school property and you discharge a firearm. And you know, there's places where children are outside of a school bus or a building. They may be on the playground, and technically that doesn't meet current code that talks about an unoccupied school bus or an occupied school bus, or the same for a building.
Yeah, I don't see where the definition of school zone matters when you're discharging a firearm around kids on school grounds. So, it's probably time I want to make a substitute motion to give the bill a favorable report.
Well, let me clarify, Representative, if I may. Working closely with Representative Wadsworth, as we share a district up in Winston County, and I'm very familiar with the 16th section land that he made reference to, both in my bill and in discussion of your bill. A lot of that is just forested land, and you could technically be standing out there on a piece of property and shooting through 400 acres of property and not hit anything. And there's nobody there for you to potentially hit, as there would be if you're on school grounds. That's what we typically define as school property.
Yeah, but those aren't school grounds for the purposes of the law we're talking about.
Exactly. You're correct.
Yes, those aren't the school. That's not for the purposes of possession or discharge.
I understand. Yes, sir, you're correct. I understand what you're saying. Yes. Sir.
Again, like I said, I'd like to make a substitute motion that this bill be given a favorable report.
Okay, do I hear a second to the substitute motion? Second. Thank you. All right, all in favor of the substitute motion, say aye.
Aye.
Any opposed? Okay. Well, I'm going to take it then, Representative England, that we just gave this bill a favorable report.
Yes, sir. And if you want to make another motion, I can do that.
No, I don't think it's necessary.
Thank you, Chairman. Thank you, Buddy.
Appreciate it.
Yeah, go ahead.
Tell you what, my bill's next, so let me do it. It's House Bill 37.
Chairman Hill, will you explain HB 37?
Yes, sir, I will. Thank you. It goes in a lot of ways hand in hand with things that we've been talking about. It does deal with schools, but not only schools. It deals with any type of real or personal property. But included in there would be churches, mosques, synagogues, religious property, schools, private or public. Two things that this bill does. If you make a threat, and in here, it's called a terrorist threat, in such a manner that it is communicated and it threatens harm, and it does so in an unequivocal manner, such that the building where you are threatening the harm must be vacated. And at that point in time, it is a felony offense, and it is a Class C felony. So that would be one element. The other element of this is a second-degree terrorist threat. A second-degree terrorist threat would be a Class A misdemeanor, meaning that the building would not have to be vacated, but that the threat was real and threatened violence or damage. However, the building, the school, the mosque, whatever, did not have to be vacated. So here's the way I envision these. All right, for example, someone comes to a school while school is in session and says, I have a bomb or I have a gun, and they vacate that school. That triggers the felony response. Someone calls on a Saturday and says, Monday, I'm bringing a gun or a bomb. That would also trigger the same event, but it would become a misdemeanor because there would be no disruption of the school or of the church or of the event. So those are that's the bill. And I would ask that you give it a favor. I'll certainly answer any questions, but I'd ask for a favorable report.
Representative Simpson.
Chairman Hill, let me start by saying this is a much needed bill. I've prosecuted these cases. I've had to comb through this code over and over again to go through this, and this is a much needed bill. I do have two questions on the language, just for my understanding. On page 3, line 65 and line 67, 68, the phrase under the circumstances, subsection C, under the circumstances, the threat and harm is credible and imminent. And on line 67, the statement on its face under the circumstances. What is that language there? I mean, I don't understand the under the circumstances language.
I would say under the circumstances would be, because obviously the circumstances that exist at the point in time of the threat. For example, the school is occupied. The church is occupied. The courtroom is occupied. And the threat is, I'm going to blow it up, or I have a gun and I'm going to start shooting. At that point, in those circumstances would be, and those circumstances were communicated, and at that point in time, it would be unequivocal, and it would be the threat, and it would have a tremendous potential for immediate harm or damage, and consequently, the school or the building would have to be vacated, and that would trigger the felony part of this this bill. And you had another question. If I missed it, let me.
No, it was just concerning the language with that. My concern is it's vague as far as what, if you're trying to prove the elements of the offense, you have to prove under the circumstances. If I could see a defense attorney coming up and saying, well, what circumstances? The circumstances aren't described. They're not put out forward through here. So, I mean, that's my only issue, but your expertise in the courtroom, I will say, if you're satisfied with under the circumstances, then I will be satisfied with under the circumstances.
I am.
Go ahead. Representative Stringer.
Thank you, Mr. Chairman. I wanted to also say I think it's a good bill and a needed bill. Recently, I'd say 2 or 3 days ago, we had a similar situation happen in Mobile at a hospital. But in these situations, they're teaching lockdown procedures instead of evacuations, and they locked the facility down at a potential active shooter. And they were having, the law enforcement community was having a difficult time getting the charge on the person. So I think we need to address that. And I think what you've got here is a good bill.
Well, it would be disruptive.
Yes, sir.
If you lock it down, that's disruptive of what's going on in that particular facility.
Yep.
Any other questions?
Not.
Representative Fogg.
Representative Wadsworth, Chairman Wadsworth, I'd like to move to give the bill a favorable report.
Do we have a second?
Second.
All in favor of giving Bill a favorable report, say aye. All opposed? Bill gets a favorable report.
Thank you, sir. Appreciate it.
Representative Chestnut.
Which one are we on? Okay, HB4, Representative Chestnut, please go ahead.
Yes, may it please your honor. This bill is a bill that deals with, you have to excuse me, Judge Hill. I was hearkening back to the court days, so. Yes, sir. This bill is a bill that seeks to ban microchipping of employees by employers within the state of Alabama. I think it's a pretty straightforward bill. We define microchip and the word voluntary here. So if an employee wants to voluntarily be microchipped, then they can choose to do so. But we're saying that you can't tie conditions of employment to first being microchipped. So if there are no questions, then I'd like to ask for a favorable report.
I've got a question.
I know you and I have talked about an amendment. Do you have it there, Mr. Chestnut?
Oh, yes, sir. Yes, sir.
And I will tell you, let me just explain it if I could, and then you certainly can comment on it. On line 71, page 3, it would allow the Bureau of Pardons and Paroles to install a microchip in an inmate in the event that individual was released early, similar to what we do with a monitoring bracelet. So it would give an exception to the Bureau of Pardons and Paroles. And on page 69, line 69 on page 3, add the word and, A-N. I have no idea what that is. Yeah, I'm gonna be honest, I don't know what the one and would be, so. Yeah, the only amendment I'm gonna make is on 71, page 3, allowing the Bureau of Pardons and Paroles to implant a monitoring device in an inmate if they deem that necessary. I don't even know what it means. I'm trying to figure it out.
So if I'm reading this right, on subsection C, on line 60, what it would do is it would take this section may not be construed to prohibit, and it would just replace line 69, which is like and. So it would be an individual for voluntary elected through there.
So, all right, so back to it, it would, on 69, line 69, section C, would strike the words, this section may not be construed to prohibit. So it would allow an individual to voluntarily elect the implanting in microchip. Okay?
Yeah.
That would be the amendment that I would ask. Yes.
Okay, no problem with that amendment.
Okay.
Yes.
So I would move that we accept that amendment. Are there any questions about the amendment? Seeing none, all in favor to adopt the amendment, please say aye.
Aye.
Okay, thank you. Now, Mr. Chestnut, we are back to your bill as amended, please.
Okay, I think there's a question.
Questions?
Yeah, I'm not going to ask you about companies, but is there any industries that are microchipping employees in Alabama now?
Not that I'm aware of.
Okay.
Wisconsin, yes, but not Alabama.
What industries in Wisconsin?
There's a tech company that's doing it up there.
Okay, thank you.
Yes, sir, Mr. England, please.
A question at the appropriate time. I'd like to move to give the bill a favorable, move the bill as amended to give a favorable report.
Okay, there's a motion as amended.
I did have a question.
Yes, ma'am, please go ahead.
Just one quick question. I see here where it states that, the Board of Department of Corrections can microchip an inmate, and also once they're out for parole. But once they have finished their parole time, would that inmate be, will the microchip be taken out of that inmate once they've done their time and released from all responsibilities?
Yes, I'm sure that once once you complete your time, that's a different situation. You're not awarded, you're not, overseen by the state at that point.
I understand, but is
You've
that
done your
somewhere written for that to happen?
No, because this bill was actually created to deal with employers.
Mhm.
So we didn't, it's not like a necessarily a parole bill.
Okay.
So I can't really answer that question. I mean, Judge Hill, do you have a?
Feel sure that they would be taken out, so just like a monitoring bracelet would be removed at the point in time that the individual was no longer to be monitored. The chip likewise would be done also.
Is there a policy for that? Oh, we don't have a policy for that yet.
To my knowledge, we do not have a policy. However, the parole board would not have any authorization to monitor an individual once that individual was off parole. Yes, sir.
I had a question. I want to piggyback on what Representative McClammy said. So, Prince, I should ask you this earlier, but I know what a microchip is, but what is a other permanent identification marker? So, look, what else is there out there where permanently identifying people?
I mean, that's put there just to kind of be more of a catch-all, like dealing with sort of like biometric data, things of that nature.
Okay, I got
So,
you. Would
like the movies when they're
yeah.
know.
So to get to Representative McClammy's point, I know there's no policy on, I know we had this as an amendment. Would you kind of be amenable to putting something in as like point 2A that the Bureau of Pardons and Paroles must institute a rule on, some time limit on when a microchip must be removed if there is one, if they put a microchip in a parolee, just so that way it would take care of her point and we'd have a policy in place to code.
Okay, well, that wasn't my amendment, so you might need to ask Judge Hill if you want.
I don't mind that at all.
Okay.
I want us to monitor inmates when they're released. If the Board of Pardon and Parole comes up with a methodology by which they implant a chip as opposed to a monitoring bracelet, I want them to be allowed to do that. So no, I certainly don't mind them removing it at the point in time that the individual's off parole, because I don't think there'd be any reason to keep it on.
I guess.
Yeah, I don't believe there would be a legal ground to keep a monitor device on a person who has actually completed his time. I mean, do y'all know of any case where a person has done all of his time and he's somehow subjected to
a suspension of certain liberties after he's completed his time. I mean, usually they're on some form of supervised probation or something like that, which means they haven't completed their time, which is why I think a lot of times defendants will sometimes say, hey, just give me straight time instead of all of these different, probation parameters, because they know that when they finish their time, then they're complete. But no objection if that's worded, in the proper form.
Judge, are you working on us an amendment there? That's what I thought you were doing, so thank you. Yes, sir, please.
Prince, I do have a question. Is this just being proactive, or do you see it being a threat for?
Yes, it's just being proactive and preemptive. Actually, Nevada has already taken this proactive measure. Arkansas has also passed a similar bill. So it's something that, from everything that I'm reading, we're probably about maybe 10 years away from this being a thing. But I just want to make sure we're out front.
So Representative Chestnut, so you're already taking a stance here on microchipping. What's your next step on addressing artificial intelligence, just taking over the world? Is that your next step here or what?
Well, actually, I do read a lot of on that and watch a lot of films, and there are some things that do concern me. If I see something that I will address this body again. So.
We're killing time. I have a question.
Okay, sure.
I just want to bring this up because I saw it. On line 73, you have this listed as a Class D felony. You realize that Class D felonies, there are really no punishments that they can be. They're really just a slap on the wrist at the absolute most for all Class D felonies. And there's no punishment for anybody that violates this statute.
But it's still a felony. I don't think anybody wants a felony on their record.
Just killing until he finishes the thing. Are you proposing that the corporation get the slap on the wrist, the Class D felony? Are you proposing the supervisor? Are you proposing who would be responsible for the Class D felony?
Yes, it would be the person who, the decision maker at the corporation.
Representative Chestnut, some of the members here will remember my reference I'm about to make, but is it true that you have an intent here to accept an amendment to name this act after yourself?
No, it'll be the Judiciary Committee Act.
Yeah, I think since the name's already taken, I think Representative England's right. We've got to add in the Representative Prince Chestnut Microchip Act. I think is what we'll have to do here. So, which has quite a ring to it. So thank you.
David, how much time you think you take?
She had to print it. Mr. Chairman, I make a motion that we move this over to the call of the chair.
That employs a full-time municipal judge by local law enacted by the legislature may elect to apply this section. While that amendment was only designed to target specific offenses, it actually amended the entire code section. So that means that if your city employs a full-time municipal judge, then your city can no longer write citations for anything. So what my bill does, it eliminates that so cities can once again write citations for certain offenses. There is a technical amendment at the appropriate time. I will explain that. Okay, what it does, if you go to replace on lines 73 through 76 on page 3 with the following. It strikes the person is charged with a violation of carrying a pistol without a permit as provided under section 13A11-73. It renumbers it and just says J.V. strikes person, individual is charged with a crime that. And the reason we're taking that out is because we no longer require a permit. So it's not a crime.
Okay, does everybody understand the amendment? And is there a motion to adopt that amendment?
Out of playing nice with each other today, I'll make a motion we adopt that amendment.
Thank you. Is there a second? Second. Okay, there's a motion and a second to adopt the amendment. Any questions on the amendment? All in favor, say aye.
Aye.
Any opposed? Okay, thank you. Now, Representative England, I guess we're back. We're
on the bill as amended.
To you as amended. Yes, sir.
If no further questions.
Make a motion to adopt.
Thank you, ma'am. Is there a second? Second. There's a motion and a second to adopt the bill as amended. Give it a favorable report. Any other questions about it at all? Seeing none, all in favor, please say aye.
Aye.
Any opposed? Okay, thank you.
Thank you.
Thank you. Representative England, you might as well stay up there if you will. And do HB 16.
Thank you, Mr. Chair. Those who know me know that one of my favorite pastimes is talking about pardons and parole. And I think that one thing that we can all agree on is that that process itself needs a little bit of work. I think we can agree on that the process needs some oversight. And what House Bill 16 does is essentially attempts to create that oversight. It creates an 8-member Criminal Justice Policy Development Council that will help create guidelines for the parole board. It will update the inmate classification system, adopt a validated risk and needs assessment for felony offenders, and provide quarterly reports to the legislature beginning in October of 2023. And the bill does not take away the board's independent decision-making authority. The board can continue, as it is doing now, ignoring guidelines. The board can continue, as it's doing now, making arbitrary decisions without considering the circumstances that the applicant has worked towards, put forth. It also can continue ignoring the fact that the Department of Corrections themselves have identified a number of people who are no longer a threat, to the point where they spend their days outside of the facility and only come back at night. Those folks are being routinely denied as well. So what this bill would do will be create that oversight, will create the ability to appeal and review those decisions, so we can begin to massage that process a little bit and make it just a little bit more effective. So with that, I'm willing to answer any questions you may have.
Okay. Any questions? Yes, sir. Go ahead, Mr. Pettis. Okay. We'll do a roll call. Sure. Go ahead, Mr. Robbins.
I have a few questions.
Yes, sir.
Representing England. One, why did you set the number at 8 on the board as opposed to like an odd number? So in case there's a tie.
Oh, it's a great question. And if you want to amend it to offer additional members, take some off, I'm completely open to that. But I mean, there wasn't any general science behind it. It was just those particular individuals that we thought would be important to the process just ended up being 8. So.
Okay.
Yeah.
I mean, because I was just wondering, because whatever happens when you have an odd number, you got 4 and 4 and then you don't get anything. But I didn't know, in looking over, you've got Senate Judy, House Judy, minority party in the Senate, minority party in the House, and LSA. I'm sure Representative Simpson would appreciate this, but have you thought about adding a prosecutor or the DA's Association or the Attorney General's office?
Sure.
Someone from that on the board.
That would be, in my opinion, a friendly amendment. If you wanted to offer that, if you wanted to offer someone, actually Representative Bedsole brought up a point this morning when we were talking about your good time bill about having somebody with experience managing a facility. I mean, I would be open to that as well. It's again, this is not the end all be all. If there's better ideas out there, bring them on.
Okay. And I had one other question, that on page 6, where it talks about the appeal process, and you say within 30 days of the board denying a prisoner parole, blah, 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 may appeal the decision. So is that the statute of limitations, how long a person has, or do we have, should we put into the code some sort of statute or a limitation on how long the party has to appeal this decision?
And honestly, I think we're kind of plowing new ground. So I think we would be, in essence, creating that. So I think the 30 days is just, something to make sure that the process is moving. So, I mean, again, it's one of those things, like if there's a better idea, and if you think we need to create some sort of statute, then I'm more than willing to listen to that as well.
Okay. I was just thinking if I'm that party, if I'm that person that was denied parole, how long would I technically have to appeal the decision? Because at some point, would you have, a year, 2 years, or, relatively, because if you have a decision in a circuit court, there's a time frame on how long you have to appeal that decision. And with this, it just says you may within 30 days. So I kind of wondered if we wanted to set some sort of limit on how long a party has to appeal the decision.
Yeah, I mean, it makes sense. Right now, I think there is no time limit. So I think anything that we're creating would define the process. And I want to remind, it's not just an appeal from a denial. It's an appeal from if you're deviating from,
Right, from the from the guidance or for the recommendation based from the committee, right? So
Right.
if they say do X and then the pardons and paroles does Y, then you get an appeal because they did Y instead of X.
Yeah.
So if you would be okay with it, I mean, I'll leave this up to you. If you said add another member, would you be more open to the DA's association or the AG's office putting an appointee on the
Oh, that
board?
sounds like a trap. Either way, it's fine. Adam, you know, if it's somebody from the AG's office or somebody from the District Attorney's Association or both, I mean, either way, it's fine with me. I'll be open to that amendment.
Okay. I mean, I had one prepared right before we walked in here to add the AGs.
That's fine.
Appointed, but then I was like, I'll let Representative England choose
that's
what he
fine.
wants. So,
That's absolutely okay.
and so if at the proper time, I'd like to introduce an amendment to add an appointee from the Attorney General's office, and I'll give this to Brandy. I'm sorry, I just got it done.
This is the proper time. If we're going to amend this thing, let's do it as we move down. So the amendment is to add another member. That additional member would be appointed by the Attorney General. Is there a motion to do that? I guess, well, you making the motion, aren't you?
I'm making the motion.
Is there a second? Okay, there's a motion and a second. Any discussion on the amendment? All in favor of the amendment, please say aye. Any opposed? Okay, your bill is amended to add one individual appointed by the Attorney General.
Great, thank you. Any other questions?
Yes, sir. Mr. Torrance.
Representative England, this is my baby too. I was spent 25 years with pardons and parole. And I just want to say that it's a hoax that the parole board is not releasing folks. We have mandatory release and they are being released left and right. Now, when the parole board has a packet or considers somebody on parole, that offender is the bottom of the bottom. So with that being said, I truly oppose this council, and I would like to move this forward as to kill this council, because I think it's
Is that in the form of, is that a kill the council motion?
I'd like to make a motion to for this resolution to die.
Is that another kill the resolution motion? Would you allow me to respond to what you just said?
Yeah, yes, sir.
And I'm kind of confused because you said mandatory release, correct?
Right. It's just
So
another
people,
form of
so
parole.
people are being released, right?
Yes, sir.
Mandatory release is short of parole, correct?
It is,
Two different things.
but it's just another form of parole.
It's not.
It is.
Because when we're talking about parole, what we're talking about is an applicant who becomes eligible for parole, who fills out an application that goes before a board that makes a decision. Our mandatory release, the one we just had, that went horribly, by the way. We're not talking about that, but that was based on a time certain. So once they reached a point, they became eligible for mandatory release, but they don't go before the parole board. Is that correct?
Correct, because they're
So we're
automatically coming out.
So this bill doesn't have anything to do with the mandatory release component. It is two completely separate things. And I don't want to confuse those two things so people get the wrong impression about what we're trying to do here. So when you say people are being released all the time, sure, the mandatory release, that happens. But when we're talking about going to the parole board, the exact opposite happens, and the numbers are showing that. We're less than 10% of applicants who go before the parole board who are being released regardless of their risk assessment. We paid a lot of money years ago to make determinations as to who's a threat to the public and who's not. Paid a lot of money for that because we wanted at the time to use those risk assessments to make determinations as to who gets released or not. To that point, that law requires that the board actually create guidelines that they're going to have to give to the Legislative Council this year, because we had every intent of having guidelines created and the board following them. So it's to our surprise, after that legislation was passed in 2019, that in over 80% of the cases, they're ignoring their own recommendations from the guidelines that they're supposed to create for themselves. So no, a lot of people are not being released by parole. Mandatory release is a completely different thing. And it's almost disingenuous for you to try to conflate the two to create an impression that this board is actually working, and they're not.
And Mr. England, and I disagree with you, because what they have in front of them is the bottom of the bottom because of mandatory release. Now, those people would have been considered for parole before we had mandatory release, and the numbers would have went up. But I'm just saying, mandatory release has emptied the bottom, and there's just not many applicants out there on parole to select from.
That's, I mean, that is almost, I mean, that is like, I can't even come up with a word to describe how inaccurate that is. And you're also talking about the bottom of the bottom. Well, you're not talking about the bottom of the bottom. We're talking about the body itself, okay? We didn't have mandatory release to the degree that we had up until recently. Our parole rates have dropped under 10% since 2019, since we passed the law and appointed a new chair. So before 2019, we were over 50%. It's only until recently that we're down below 10%. It's not the same thing, and it's not fair to conflate the two. And also, let me just point out, just a few days ago, maybe a week ago or so, this meaningful process allowed for those folks to deny parole to somebody who had died. That should offend you, because that means they're not doing any sort of adequate review of the person that applied. They don't know if that person, I mean, to say they don't even know if that person is alive or dead, they certainly don't know if the applicant that came before them has completed any programs to better themselves. They don't know if that person who in the 20 years they've been incarcerated has actually improved and would be a benefit versus costing us a whole bunch of money. And to that end, they also don't know if, unless they're told that somebody who's over 70 years old, who's sick, infirmed, no longer a threat to society, and is probably going to die within the next 6 or 7 months, gets denied just so they can die in prison. It's not a meaningful process. It's just not. And to pretend like they're going through this review, they're taking these applications at face value and not treating everybody the same based upon the offense they committed 20 years ago is inaccurate and unfair. And also, I don't think we should come to the point where we're looking at legislation, right? And we're saying we recognize that there may be some issue there. Because again, a process that works doesn't deny parole to a person that's deceased. It doesn't happen.
Well, I'll say this on that. That would be the officer that did the investigation. I wouldn't put that on the parole board.
But I mean, if the parole board is asking rudimentary questions about, is this person alive or dead, we don't get to this point. But they don't, and I mean, it also brings you another point that they don't even address the applicant. So they don't know anything about that person. They don't. They only hear from one side of the process, which is why it's not working.
I would disagree with that, because IPO officer goes to the prison, they interview that person with their personal social history and gives a report of their arrest record and also the details of the offense.
In less than 5 minutes and the person's not there.
I absolutely disagree with that, because they review their jackets and they do talk to them. I've done it myself.
I've been to recently, and I've also talked to many families who've gone through this process. Trust me when I tell you, it's not exhaustive.
Well, now you're talking about the hearing. I'm talking about when the institutional parole officer goes to the prison, interviews the inmate, makes that presentation, receives that application, and goes and makes his
With
report.
all due respect, I'm not talking about the officer that's doing the investigation. I'm talking about the decision from the parole board.
Right, but that helps the decision like a PSI does for a judge.
Yeah, and it's so exhaustive that a dead person got denied.
All I can say on that is that the officer didn't do his job. I don't know the details of that, but.
Right. But again, since 2019, we are at record lows on both pardons and paroles. And essentially, if we're going to analyze our entire prison population, right? And we have a board that's making determinations in regards to someone's threat to society, or threat to public safety. And meaning that process isn't meaningful to the point where people who are inside, who don't spend their days in the facility, they're actually out because the Department of Corrections, the people that are with them every day, have decided that they're no longer a threat. And that same person goes, and almost over 70% of those folks are being denied. Is the process working? And again, you and I both are concerned about public safety. But if we're not creating space within our prison system, we're holding more people that annoy us while more people that we're scared of go free. And if we have a choke point at our pardons and paroles, that means it trickles all the way down to the court system, where people who are on bond, who are dangerous, don't have, or pushed away, pushed aside, or cases are continued because we just don't have space to hold them. And it starts, our choke point is at the pardons and parole point, where in 2019 up until now, our prison population has skyrocketed. So I don't know about you, last I heard is that we're at $1 billion on one prison. Don't know how much the second one's gonna cost. We'll never get to the third, which is the women's facility. And all we're doing is making the problem worse by not addressing our problem in pardons and parole.
Yes, sir. Thank you.
Mr. Robbins.
I make a motion that we move this to the criminal subcommittee because I think there's some more work that could be done on this, and then we could maybe get it tightened up for a vote maybe after spring break.
I second that.
I'd like to talk about it for a minute before we go through there.
By all means.
Okay.
I think the problem that we have, the problem that I have with this is, Representative England, you're arguing about a parole board not doing their job. And that's your argument, that the board is not doing their job. So the answer to that is to create another board. And this other board is going to create these guidelines, and you can call them voluntary for whatever you want, but if they deviate from these guidelines, there's an automatic appeal process to the Court of Criminal Appeals, which is harder than any guideline of deviation on any sentencing thing that you have to go through. So you're creating this new level of government that will come through. You're creating a new bureaucracy to oversee the Board of Pardons and Paroles that will come up with these guidelines that if Board of Pardons and Paroles does not follow, there is an immediate appeal process to the Court of Criminal Appeals. I think we're growing government exponentially here. I do think that this is, if you don't like the people on the Board of Pardons and Paroles, you have avenues to either appeal to the governor or what we created for that board for the 2019 law that we changed. But to create this new committee that now has oversight of this, my concern is, okay, what happens if you don't like what this committee does? Are we going to create another committee to review what this committee does, to go have say so over that committee? And we have this never ending growth of government to, at the end of the day, we'll have 15 people as a bureaucracy deciding what we're going to do. And then if that committee doesn't like it, we're going to do something else.
Understood. The only way to get rid of a board member is impeachment. Secondly, generally speaking, when the legislature doesn't want to deal with something, we create a committee. We probably created committees to oversee problems that and situations that we've already got. I mean, hell, we just created a committee to deal with ARPA. That's what we do down here. When we want to avoid problems, we create committees. That's our approach. So the fact that we're talking about exponentially growing government, I mean, that's what we do here every day. And as a matter of fact, so many of our systems that we create break down that we are always here passing laws instead of dealing with the problem where it is we create another law to deal with the problem that we just created. That's what we do here. As a matter of fact, if we didn't, we'd probably all unemployed.
Yeah, I'm going to kind of echo Representative Simpson. He said it very well, that are my problems and concerns with the bill. I know our AG has spoken formally in opposition to this bill as well. But Representative England, I have the same issues with the bill as Representative Simpson.
Yes, I would kind of like on the same lines. My concern would be, just by reading the bill, is if they're denied, it looks like to me, basically, I would say all of them would appeal to this. Why wouldn't they? They would appeal to this next level. Well, when in my background, I've dealt with a lot of victims of crime and what they've been through. And, they've had to do this at court over extended period of times. Then they come up for parole and they relive it. They relive that situation. And then they're going to basically, I think, pretty much automatically appeal to this board. And then whatever happens in that board, they may be denied there too. And then it goes to Court of Criminal Appeals. And so the victim relives it yet another time.
I just want to correct that.
So I
You-
just,
You're not appealing to the board, you will be appealing to the court of, I don't think it matters at this point.
okay.
I just want to,
That's my comment.
I just want to reiterate, you know, we're 50% of our capacity. And, you know, either we're going to do it or somebody else is going to do it for us.
Okay. Gentlemen, go ahead, please.
Representative England, as I read the bill will dissolve itself 2 years from now, correct?
It's sunset,
Unless-
yes, sir.
Unless it's extended by the legislature, correct?
Yes, sir.
So removing a committee potentially, correct?
Yes,
So therefore not growing government in this particular instance, correct?
yes.
No further questions.
Mr. England, you talk about corrections, picking people that they think the risk assessment. I'm gonna give you an example that happened on my Nick Reisner bill. Subject went up for parole. He was denied. Department of Corrections said, oh, we're gonna give you good time back. The click of a signature, he's out. He kills 2 people.
Yeah.
Looks like Department of Parole is doing a better job than corrections. It also, you talk about corrections letting people out. If you look at these who, they're, every day there's, all the time there's prisoners that are escaping that are out on these work releases or different things. It's not hardly a week goes by, especially in North Alabama. Decatur's notorious for escapees. So I know the Department of Corrections is supposed to be picking, but looks like they're not doing a great job of a lot of them they picking also. So I think the Department of Parole is doing a better job than corrections in what I'm seeing.
I'm gonna be honest with you. I've never heard anybody saying that the Department of Corrections is doing a better job than anybody.
Well,
I also haven't heard the opposite. And so if it's a race between the pardons and parole and Department of Corrections, ain't nobody gonna win that one. It's a tie.
Yes.
Also, I just want to point out also with the good time stuff. Again, we've talked about this and I understand where you're coming from, but I want to make sure we understand that it wasn't necessarily the good time law that was the problem. It was the employees who were supposed to interpret who's supposed to get good time and who wasn't. Because if they had actually followed the law that was as is, they wouldn't have been on good time anyway. They wouldn't have been out. So, I mean, those situations are so unfortunate because I think we're blaming the law for just outright incompetence.
What happened on the prisoner, the good time, he got all of his good time taken away from him. But a warden in a struck for pen can give it back the way it is now. And that's what happened. He got out and he killed 2 people, which one of them was a police officer.
But again, it wasn't necessarily the good time, it was the fact that he got it back.
Yes.
And the calculations, you shouldn't have had it. Shouldn't have had it. So again, I think we probably beat this horse back alive. But I do want to say though, I do appreciate the discussion. Honestly, I do. And I do, because it's these discussions that help us recognize that there may be an issue, there may be a problem. And well, there is a problem. And ultimately, like I said before, if we don't do it as a legislature, we're edging dangerously closely to someone putting our prison system in a receivership and forcing us to do the job that we're refusing to do right now. And my approach may not be the best one. I'm not saying that I'm the smartest guy here, but at the same time, I would love for all of us to kind of try to come up with some solutions here because our prison system is growing, our population is growing, our public is not safer as a result of it, and we're just not doing anything to stop it. So, thank you.
All right, hang on, Mr. England. What I think we've got right now, ladies and gentlemen, is a motion to send this bill to the criminal subcommittee. And all in favor of that, please say aye.
Aye.
Any opposed? Okay, that's what we'll be doing. Thank you, Mr. England.
Can you put it in there with my gun bill so I only make one trip?
Yes, sir. We can do the England Criminal Subcommittee time. It could be. Next one is HB 39. I've had some discussion with people about that. I am going to carry that over. So that brings us down to Representative Alban. And by the way, ladies and gentlemen, this really is her very first foray into this committee, and I would ask that our committee members remember that and treat her kindly because this is a good bill. No, we'll carry it over. Carry over 39.
Thank you for that, Judge. I do appreciate that very much. It is my pleasure today to bring to you the Colby Act. And the Colby Act is named for Colby Spangler, and Colby is here with us. Colby, would you please stand and let us see you? Colby is here with his mother, Kim, and let's give them a round of applause. Colby and his mom came to see me this past fall in Tuscaloosa at my law office to talk to me about this bill, which is one of several across the country that are going on. I think 13 states have already adopted some form of this bill, and many more are considering it. It's also approved and recommended by the American Bar Association. It's really another tool in the toolbox, if you will, for people like Colby, who will be able to use what this will provide for us. And what that is supportive decision-making. The goal is to have a team of supporters for somebody like Colby to be able to nominate to be on his team, and they will help him to make decisions and communicate decisions with others so that he can live independently. And it might be easier for me to tell you what it's not. So currently we have guardianships and conservatorships for people who need assistance in decision-making, or frankly, who can't make decisions on their own. So they go to probate court, and the probate judge will appoint a guardian and or a conservator to act on their behalf. In order to do that, the court has to determine that that person who needs the assistance is unable to act on their own. So they basically give up all of their rights to make decisions for themselves, and a court-appointed guardian or conservator will make those decisions for them. That's not what this is. We also have powers of attorney, which is outside the purview of the court system, that I can execute, you can execute to name somebody to act on your behalf. You basically are handing them the power to act on your behalf, and there's no limitations on that. They can do what you want them to do. They can do something totally opposite of what you want them to do. And that, again, is not what we're talking about here, and we're not changing any of that, okay? All those things will still exist. What we're doing is adding a supportive decision-making agreement to allow people like Colby to bring people onto his team and to enter into an agreement to then be able to communicate with third parties his wishes. They are to abide by his wishes and to carry out what he wants to do. We do have 2 amendments that have been brought forth to this bill, and at the appropriate time, I'm happy to discuss those.
How about this, man? Let's go ahead and discuss Amendment 1, which I think is nothing but a form wherein someone would fill out to do this. Is that correct?
That's correct. We felt that it was hopefully will be helpful to have a form that is recognizable by third parties, so they'll recognize what the supportive decision-making agreement is. This was taken from one of several that are out there and used in other states. So that's what Amendment 1 is.
Go ahead, Mr. Chairman.
Motion to adopt the amendment.
Second.
All right, There's a motion and a second to adopt Amendment 1, which is a form where someone would fill out in order to facilitate this act. Okay, is there any discussion on that? All in favor, say aye.
Aye.
Okay, let's talk about Amendment 2.
Amendment 2 just came to me from someone reviewing the bill and suggested that we add this language that no one can require an adult to execute a supported decision-making agreement for any purpose. Just
All right.
make that clear.
To adopt the amendment.
All right,
Second.
there's a motion and there's a second. Any discussion on Amendment 2? Okay, all in favor, say aye.
Aye.
Okay, so
Have a
Ms.
motion.
Almond, we're back to you on the bill as amended, and Mr. England?
Motion to give the bill a favorable
Second.
report as amended.
I want to ask a question.
Okay, wait a minute. Okay, we got a motion and a second to give the bill favorable as amended, but yes, Mr. Wadsworth, go ahead.
Just wanted to find out, there's no bond, no inventory, no accounting or anything.
No,
Is it more similar to a power of attorney?
it is similar to a power of attorney. The difference is that the person that enters into this agreement with you has to do what you want them to do. That's the whole goal.
Do they have to be competent in order to sign this?
Yes.
And does it have to be approved by a probate judge?
No.
Okay, it's just strictly what they fill out.
Similar in process to a power of attorney in terms of that's something you do outside the purview of the court.
Is it more of a limited power of attorney, so to speak?
Well, it's different from a power of attorney because in a power of attorney, once I have that power as agent, I can go and act on your behalf, and it can be in something you want me to do or something you don't want me to do.
Okay, so this is whatever they want you to do.
Correct.
Okay, thank you.
Did you have a question?
I was gonna say, Representative Wadsworth kind of asked it. I was gonna ask about if you had thought about having any kind of bond or, because I know with conservatorships, you have to have a bond. And so I saw in here you're acting as a fiduciary. So I just wondered if you'd thought about, or if any of the other states have added it.
To my knowledge, the other states do not do that, and we really were trying to mimic what's worked in other places at this point.
Okay, I have no questions.
There's a motion then, and a second to give this bill a favorable report as amended. All in favor, say aye.
Aye.
Any opposed? Thank you, ma'am.
Thank you, Chairman. Thank you,
Yeah.
committee.
Representative Chestnut, can we go back to HB 4?
I have a motion.
Yes, sir.
Motion to give the bill as amended a favorable report. HB, no, oh, well, I'll make a motion to adopt that amendment.
The motion is to adopt amendment number 2, which would be to have the Board of Pardons and Parole promulgate rules and policies concerning microchip in insertion, maintenance, and removal.
Yes,
Okay,
make a motion.
is there a second to that? Second. Thank you. Any discussion? Okay, all in favor of this, I think this is Amendment 2, say aye.
Aye.
And Mr. Chestnut, then, where are you? All right, Mr. Chestnut, since you're the sponsor of the bill, I'm going to assume that you make a motion to give the bill a favorable report as amended twice. Is that correct? Correct. Okay, is there a second to that?
Second.
Thank you. Any discussion? Okay, all in favor of this bill getting a favorable report as amended twice, please say aye.
Aye.
Any opposed? Thank you, ladies and gentlemen. That's it. We appreciate it. We'll see y'all next week.
Spring break.
We'll see you.